We live in a world full of experts, where politicians use fear to generate power for themselves.
We've already had over 290 mass shootings this year. That's more mass shootings than days in the year.
Where our media feeds us with misinformation.
And according to the CDC, the #1 cause of death for children ages 1 to 19 in this country is gun-related violence.
Tropes.
Where it will literally tear out the inside of the body.
Where those who make the rules seem to know the very least. Scary terms used.
Arm known as a ghost gun because it skirts most federal gun laws.
Don't be like this guy. Listen to the Range Minded podcast and free your mind. We live in a world full of experts, where politicians use fear to generate power for themselves.
We've already had over 290 mass shootings this year. That's more mass shootings than days in the year.
Where our media feeds us with misinformation.
And according to the CDC, the #1 cause of death for children ages 1 to 19 in this country is gun-related violence.
Tropes,
where it will literally tear out the inside of the body.
where those who make the rules seem to know the very least. Scary terms used.
Arm known as a ghost gun because it skirts most federal gun laws.
Don't be like this guy. Listen to the Range Minded podcast and free your mind.
God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Everything? All right.
Jim?
22117, the Commonwealth versus Karen Reed.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, read anything about this case since we left here yesterday? Everyone said no or she did. Thank you very much. Here we have Dr. Scordi-Bello, please.
Watch your step on. You solemnly swear the evidence of the court and jury in the case now here to the truth, the whole truth, and nothing but the truth, so help you God.
I do. Whenever you're ready, Ms. Lally. Good morning, doctor.
Good morning.
Morning, Doctor.
Good morning.
Dr. Scordi-Bello, if I could ask you some questions, just turning back a little bit from what you were testifying to about yesterday. You had mentioned in your testimony yesterday that you had received some, in addition to the internal and external examination that you conducted of Mr. O'Keefe, you had received some other material that you had reviewed, correct?
Correct.
Now, included within that material was some material from the state police as far as the investigative agency investigating Mr. O'Keefe's death.
Correct.
Now, is that is that typical? Is that abnormal? If you could describe sort of in general terms, as far as what, if any, communication would you typically have with the investigating body or agency in relation to any sort of autopsy or examination you do?
Yes. In Massachusetts, under Massachusetts law, the medical examiner's office is responsible, and our role is to determine the cause and manner of death by doing an autopsy. The scene or the scene of death or the place where the decedent is found is controlled by the district attorney's office, and state police will do an investigation. When we accept a case into our office, we request reports, police reports, to explain and describe the circumstances of the death. It could be a house, it could be somewhere else, it could be outside. Every case comes with a police report, and we review that police report, and if we feel that we need more information, then we contact the investigating body and ask for more information, again, depending on the case.
And specifically in this case, in regard to Mr. O'Keefe, did you reach out to get some more information?
I did reach out, yes.
Was that in part in relation to what you were talking about in your testimony yesterday, as far as the diagnosis of hypothermia and trying to sort of better understand the circumstances?
Objection, Your Honor. Sustained.
Why did you reach out?
I reached out because when the case was presented to us, and after I did the autopsy, I did not have all the information that I needed in order to certify the manner. The cause of death to me was, I was able to determine the cause of death from the autopsy. When an event is unwitnessed, we usually reach out to the investigating agency and ask them whether they have any more information than they did on the day that the autopsy was done, because investigations sometimes take some time. So in the days and the weeks following the autopsy, I reached out and asked if there was any more information than what I was originally presented with. Was there any video from the surrounding areas? Did anybody come forward to say that they actually witnessed whatever happened? Again, by the time I was ready to finalize the case, and we have approximately 3 months or 90 days from the day of the autopsy until we issue a report, I was not provided with enough information for me to be able to determine the manner.
Now, Doctor, do you recall specifically who it was that you spoke with from the state police?
Yes, I documented that I spoke with Trooper Proctor, I believe, twice.
And with reference, not asking you anything as far as what that conversation consisted of, but as far as the tone of that conversation, did you feel pressured or coerced to come up with a certain determination?
No, I did not.
And even if you had been, what would your response have been in reference to that?
My response was that I am responsible for what goes on the death certificate, and unless I have enough information, clear and convincing evidence, I cannot determine a manner.
May I approach?
Yes.
That is not a typical question that a prosecutor asks, hey, Emmy, whether they were coerced into or pressured by police for a particular finding in the death certificate. So I feel like that was a preemptive strike on the defense. Interesting.
Gave you yesterday. Do you recognize those?
Yes, I do.
And what do you recognize those to be?
I recognize these as photographs of Mr. O'Keefe's body. I believe these were taken at the hospital. One of them is a photograph taken at the time of autopsy.
Thank you. May I approach again, Your Honor?
Yes.
I'm going to seek to introduce in the minutes the next exhibits.
Ms. Little? No objection. Thank you. 6:45, 6:49. Thank you.
Thank you very much. May I have a moment? I just want to make sure they're in the
Yes.
right order. May I approach again?
Yes.
Your Honor, with the court's permission, may we publish these for the jury?
So jurors, remember the instruction I gave you yesterday on these photographs, okay?
Ms. Gilman, if I could have photograph 2853. And Doctor, do you recognize what's up on the screen?
Yes, this is a picture taken of Mr. O'Keefe's body.
And Doctor, if you could, using the laser pointer that you have there, direct the jury's attention to what, if anything, you observe of significance in this photograph related to the injuries that you were testifying about.
Yes, so first thing you notice is the medical intervention, which I talked about yesterday. There's defibrillator adhesive pads on the chest. There is what's known as a C-collar, a cervical stabilization collar for the neck, and he has been intubated prior to going to the hospital. The injuries that are obvious in this picture include the abrasions on his right forearm and arm. And you can see here, there is discoloration of the upper eyelid of the right eye with some blood that's dripping. That's the orbital or supraorbital ecchymosis that I described before with we're too far to see the very, very small laceration that is present there, but that's what's causing the bleeding.
And Ms. Gilman, if I could have photograph 2857. Now, Doctor, this is not before you at the current time. It's currently marked as Exhibit 442. Do you recognize what's up on the screen?
Yes, this is a picture of the abrasions that I described in my report. Posterior upper arm and forearm. You can see that they have some sort of pattern to it. Anytime we see a pattern, we try to document it as best as we possibly can.
Now, Doctor, with reference to these injuries as far as the abrasions to Mr. O'Keefe's right arm, what kind of role will that play as far as your determination as far as cause of death of Mr. O'Keefe?
These are superficial abrasions to the skin. They are not lethal. They're not contributory to the cause of death. The trauma that I observed on the head along with the hypothermia are the two factors contributing to his death. These are present, they're noted, they're described, they're photographed, but I do not know how they came to be, and I did not contribute them to the cause of death.
Ms. Gilman, if I could have photograph 2860. Doctor, returning to the exhibits of photos that you have before you, do you recognize what's up on the screen here?
Yes, this is a photograph of Mr. O'Keefe's right hand. This is the dorsum or the dorsal aspect of the hand as opposed to the palm. And you can see that there are some contusions or bruises. There's a larger one here and two very small ones here. This particular contusion has two pinpoint small defects associated with it. I believe this could be due to attempts at gaining IV access during the many attempts of resuscitation, but I cannot be absolutely sure.
Ms. Gilman, if I could have a photograph from page 65. And Dr. Scortibello, if you could, again, using the laser pointer, direct the jury's attention to what, if anything, of significance you note in this photograph.
Again, this is a slightly closer view of Mr. O'Keefe's face. You can see the discoloration, the ecchymosis on the right eye with a slight amount of bleeding. You can see here that there's also some discoloration of his left eyelid.
And doctor, with reference to the other injuries that you were testifying about yesterday, as far as the small cuts or abrasions or lacerations, are those visible in this photograph as well?
I can't hear your question. If you could just repeat it and a little louder.
Sure. My apologies, doctor. With reference to this photograph, as far as your testimony yesterday in regard to the other smaller injuries around the nose and eyes area of Mr. O'Keefe, are those visible in this photograph as well?
You can see some discoloration of the nose, but this is not a very good picture of it. I think there's a linear abrasion on the left side of the nose that I described, and it's probably this.
Ms. Gilman, could I photograph 2877? And doctor, if you could, again, using the laser pointer, direct the jury's attention to what, if anything, is significant you observe in this photograph.
Yes, this is a view of the left side of Mr. O'Keefe's face. You can see the discoloration of the left eyelid, and now you can see this linear abrasion on his nose and a small abrasion more towards the middle of his nose.
Ms. Gilman, lastly, from this set, if I could have photograph 9488. Same, Dr. Scortibello, if you could, using the laser pointer, direct the jury's attention to what, if anything, is significant you observe in this.
This is the laceration to the back of Mr. O'Keefe's head. You can see this defect here. It's ragged. It's a typical classic blunt impact injury, and you can see the abrasion, the scrape that is adjacent to it.
Thank you, doctor. Ms. Gilman, you can take that. And the doctor, we get out the lights. Thanks. Now, doctor, with reference to what you were testifying yesterday as far as the subscapular bleeding, bleeding under the scalp, was that more or less prominent on one side versus the other side of Mr. O'Keefe's scalp?
Yes, it was more prominent under that laceration that we just looked at.
And so would that be more prominent on the right side? Is that correct?
Yes.
Now, you testified yesterday about a blunt object injury in relation to the injury to the back of the head, then leading to the fractures and the bleeding in the brain, correct?
Correct.
And then further leading to the ecchymosis, is that correct?
In the eyes, yes.
Now, that blunt object, what, if anything, can you say about what that blunt object could be?
Could be any blunt object.
Now, from your training experience with reference to the number of autopsies and examinations that you've conducted over the years, would that blunt object, the possibility include the ground, especially if it was frozen ground?
Objection. Ask the question differently.
The injuries that you observed to the back of Mr. O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
And to that point, as far as when you say classic, as far as a pedestrian collision is concerned, you've conducted autopsies on a number of different pedestrian collisions over the course of your career, is that correct?
Yes, I have.
Do they all sort of mirror each other? Is there sort of a disparity depending on how the person interacted with the car?
Objection.
Sustained. Watch the form, Mr. Lally.
What, if anything, are every injuries from a pedestrian collision the same?
No.
And why not?
It depends on many factors. It depends on the position of the body, of the pedestrian or the person being struck. It depends on whether they are moving or standing still. It depends on the speed of the car. It depends on whether brakes were applied or not. There's a lot of factors that come into play.
Would another factor be sort of the shape of the vehicle that strikes a pedestrian?
That's also possible. Yes, that's a factor.
And did you have occasion to see any photographs, or have you seen any photographs in relation to the defendant's vehicle in this case?
I have seen photographs, yes.
And the size or shape of that vehicle, what, if any, significance did that have to you as far as your examination?
Objection.
I'll allow it.
When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority we see injuries to the legs from the bumper of the car. Again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. O'Keefe, I did not see any injuries in the lower extremities. And looking at the car, I did note that it was a much bigger car with much higher, I would say much higher tail light, bumper. It was not a sedan or a car that's low to the ground where the bumper would be at the level of, let's say, the knee or slightly above or slightly below.
And again, I believe yesterday in your testimony, you indicated that the skull is a pretty thick bone. Is that correct?
Yes.
Sustained.
With regards to the thickness of the skull bone, what, if any, significance, or what, if anything, you say as far as the type or amount of force that would be would be necessary to cause the fracture that you observed?
Objection.
Overruled.
I would consider the amount of force to be significant, again, without being able to quantify it.
Have a moment, John.
Yes.
Yeah, take a moment to speak up there, Lolly. I want to welcome Big Ron to the show. He's with us. Good morning, Big Ron from Florida. One thing I noticed during the autopsy photographs, they had the camera on John O'Keefe's brother. He had eyes locked on
From
Karen Reed.
the internal and external examination that you conducted in regard to Mr. O'Keefe, as well as the other materials that you reviewed, were you able to come to an opinion to a reasonable degree of medical certainty as to the cause of death of John O'Keefe?
Yes, the cause of death was due to blunt impact injuries of the head and hypothermia.
Thank you, Doctor. Your Honor, I have no further questions.
All right. Cross-examination.
All right, here we go. Well, Lisa, I agree it's overkill, but every hearing or proceeding I've been in, that
morning, Dr.
they always go
Sotelo.
back
Good
to
morning.
Ms. Little, keep your voice up.
Absolutely.
asking
You
the jury the same
testified
instructions
regarding a
daily
number
on the
of
record.
injuries that you referred to as blunt impact injuries, correct?
Yes,
And to be clear, blunt impact injuries are a very, very large category that includes contusions, lacerations, abrasions, and fractures.
correct.
And you testified similarly that a blunt object can also refer to a large range of objects. Is that right?
Correct.
And I think yesterday you gave the example of a microphone being a blunt object.
Correct.
It could also include something like a baseball bat,
Correct.
a dumbbell,
Could be.
the ground,
Yes.
or a German Shepherd's claws.
Clause. Possibly, yes.
You'd agree that John O'Keefe had a number of blunt impact injuries on his face, on his head, and his right arm.
Yes.
Besides his right arm, which we'll discuss in a second, taking his body from the neck down, he did not have any significant injuries.
From the neck down. Not significant, no.
Let's take those one at a time. No injury whatsoever to his shoulders.
Correct.
No injuries whatsoever to his chest area, aside from sort of the CPR-related injuries that you discussed.
Yes, correct.
And that was in the sternum, is that right?
It was in the ribs, just adjacent to the sternum, yes.
Okay. No injuries to his torso, other than that.
No.
No injuries to his back.
No.
No injuries to his hips.
Correct.
No injuries to his pelvis.
Correct.
No injuries to his thighs.
To his,
Thighs.
no.
No injuries to his knees.
Correct.
No injuries to his shins.
Correct.
No injuries to his ankles.
Correct.
No injuries to his feet.
Correct.
From the neck down, he did not have a single broken bone, again, aside from those CPR-related injuries you discussed, correct?
That's correct.
Not a single fracture.
Other than CPR, correct.
And you spoke earlier about how the bumper was a little higher than on, say, a regular sedan, correct?
Correct.
And so usually in a pedestrian collision, you would see injuries to the knees. Is that right?
Objection.
I'll allow it.
Depending on the kind of car, depending on the speed, depending on the height of the individual and the car, you might see injuries to their lower extremity. Yeah.
But in this case, you didn't see any injuries to his thighs, to his pelvis, anything even at the height of the bumper. Is that correct?
Correct. At a very minor abrasion to the side of his right knee.
So surely you'd agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a 7,000-pound vehicle at 24 miles per hour and being projected 30 feet.
Objection.
Sustained. Break it down, ask it differently.
Whether you agree that John O'Keefe's injuries, are, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour.
I would say it's likely and unlikely at the same time, depending on the position of the body and the vehicle in question.
Well, let me give you a hypothetical. Let's say the person were standing with their arm like this, and they were struck by the rear taillight of a vehicle at 24 miles per hour. Would you agree that his injuries are inconsistent with that scenario?
Objection.
Sustained.
May we approach, Your Honor?
Sure.
Interesting. Interesting that the medical examiner says it's both consistent and inconsistent. That's pretty much a zero answer right there. Come out to zero for either side, really. And Lisa brings up a good point. The medical examiner is big admission that it could have been dog claws, explaining the injuries on his arm as well.
Now that's not the first time that we've heard the dog implement it and the wounds consistent with that.
Yeah, and we believe that the state, we saw an expert during the voir dire for the defense, but I believe the defense will bring an expert that says that those injuries are consistent and more than likely caused by a dog. So, interestingly enough.
And
You
if
are
that's the
unmute.
case, that it was created by a dog, and that puts him inside the house.
No, of course. Lisa says, why is the defense having a wet behind the ears
Would you agree that
attorney
John
doing
O'Keefe's
this cross-examination such a
to
key
his
prosecution
arm,
witness?
let's start there, are
I think she has a
inconsistent with
medical
having been
background.
struck by a vehicle at 24 miles per hour and then causing him to spin around and be projected 30 feet.
Okay, so you need to break it down.
Would you agree that John O'Keefe's injury to his arm are inconsistent with having been struck by a vehicle at 24 miles per hour?
I don't know. I am not a reconstruction expert. I'm not a biomechanics expert. I never personally inspected the car, so I can't offer an opinion on that.
You did examine John O'Keefe's arm, correct?
Yes,
You observed no
Let's remember
significant bruising,
biomechanics expert. I've got a
Correct.
comment about that.
no fractures,
correct,
and no broken bones.
correct.
I'd like to talk about the injuries to John O'Keefe's face. You testified that Mr. O'Keefe had a laceration on his right upper eyelid.
Correct.
You also described multiple abrasions on his nose.
2, yes,
Although these injuries may not have been the ultimate cause of his death, you'd agree that less severe injuries can still be very important in interpreting the manner or the context in which that person died, correct?
correct,
And in furtherance of that, you've been taught that when doing an autopsy, details matter,
correct,
no matter how small.
correct,
And that's one of the reasons as a medical examiner, you have to notate every single injury you find on a person. Is that right?
correct.
If I could show you. May I approach, Your Honor?
Yes.
Well, Lisa, Grandma Expert
Show me
did
the
mention dog claws and wounds when she was on the stand. I don't know if she's going to just say it was exactly teeth. I'll be quite honest with you, I'm not sure what she's going to say, other than I believe she's going to assert that they are very consistent with animal, dog in
Do you
particular,
recognize that photograph?
injuries.
I do.
And is that a photograph that was taken in connection with your autopsy?
Yes, it was taken at the time of autopsy after the face was cleaned.
Move to admit.
I'm sorry, after what?
The face was cleaned up.
Okay.
I move to admit, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Exhibit 650.
Permission to publish?
Yes.
It's kind of odd, almost like the judge was asking for an objection
Are
on
these
that.
the facial injuries that you were testifying to earlier?
Yes,
And
I think I
could
missed
you kind
that.
of describe in that photograph what injuries you observed to his face?
the orbital ecchymosis on both eyes, the small laceration to the right eyelid, the abrasions on the nose.
And you testified that the injuries to his face were also the result of a blunt force trauma.
Correct.
So that's the laceration to the eye and the 2 abrasions that we see there on his nose.
Correct.
And you'd agree that those injuries don't just manifest out of nowhere, right?
Absolutely.
They have to originate from something.
Yes.
Would you agree that his injuries to his face are consistent with having been punched?
That is a possibility.
You can take that down, Mr. Bates. Thank you. Your internal examination notes also cite a tongue laceration on the right front of the victim's tongue. Do you recall that?
Yes.
And you'd agree that a tongue laceration can be also caused by blunt force trauma.
Correct.
And that could also include something like a punch to the victim's face or jaw.
That's a possibility.
In addition to the facial injuries, you described that Mr. O'Keefe had a significant laceration on the back of his head.
He had one laceration to the back of his head, correct?
I believe we saw a photograph of that a
Yes.
little bit earlier. You testified that the skin around the laceration on the back of his head was also scratched. Do you recall
Yes.
that?
I do.
But you did not testify as to how you opined that might have happened.
No,
Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
it's possible.
You described the open wound to the back of his head as a laceration, which is sort of a blunt force injury that's not the result of sharp force trauma. Is that right?
Yes,
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that
Yeah.
right?
yes,
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
it's possible.
It could also be the result of being struck with a large object such as a baseball bat or a barbell.
It's possible.
In other words, it was an irregular laceration that resulted from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
Correct.
But you did describe the wounds to Mr. O'Keefe's arm as having discrete linear abrasions, which were caused by some sort of blunt object, correct?
Yes.
What does discrete mean?
It means each one is an individual injury as opposed to confluent where it would be all meshed together.
Your Honor, if I could publish what's been previously marked as Exhibit 19. Okay.
No, I agree, Lisa. Lally is
These
too
are sort of
slow.
the linear wounds that you're referring to.
Yes,
And you testified that these also sort of appear in clusters or groups. You call them
Yes.
pattern abrasions. Is that right?
yes, I did.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash in your
Yes.
career. And it doesn't look like that.
Correct.
Blunt force trauma can include injuries from various objects, as you testified, including an animal claw, correct?
Correct.
And you'd agree that these discrete linear abrasions are inconsistent with having been struck by a smooth rear taillight at 24 miles per hour.
Objection.
Can you answer that, Doctor?
I can't. By
Okay.
a smooth, no.
All right, next question.
By a smooth rear taillight, you said that is not what you would see at 24 miles per hour, correct?
Objection.
Sustained.
As you testified earlier, you've indicated that based on the facts that were presented to you, you don't know what caused those significant scratches on Mr. O'Keefe's right arm.
I do not.
You know, the ME's been very consistent. She has not said this was a vehicle strike. She said some things could be consistent, but it could be also consistent with other things as well. Lisa's got her notepad out. She is marking down the wins here. I like that.
May I approach, Your Honor? Sure.
So interesting. The medical examiner said she couldn't talk about whether she wasn't a biomechanics expert, so that she couldn't testify as to how the injuries got there, whether the vehicle could sustain that or not. Yet the state is saying that the biomechanic PhDs and doctors,
If I could just see what was.
Oh, I'm sorry, Mr. Lally.
doctors, she says that they can't testify because they're not MDs in the state of Massachusetts. They can't testify as to what caused the injuries.
Do you recognize
That's
that
interesting.
photograph?
I do. It's a photograph of Mr. O'Keefe's right hand.
May I mark that as the next in order?
Is there an objection?
May we approach?
Okay.
Your Honor, she's going to say that that's consistent with a punch, and that's not what the state says. So we'd like for you to keep that out. The injury on the hand is the injury on the hand. I don't know that it brings a lot of weight. It's kind of like everything else. Could have been done, but being struck by a vehicle could have been done in other ways. The medical examiner has not taken a stance as to what caused these injuries. She documented injuries and the cause of death meaning two factors. With the MA, Lisa's asking, what did the judge rule regarding the MA? I'm not sure, but I know what MA is. If we're talking about the experts, the bioengineers, biomechanics and experts, she's going to let them in. But the second person, I can't remember his name, she's not going to allow him to testify as to the mechanical pathology of the I'm losing my train of thought. The mechanical pathology as to whether a vehicle could have struck that or not. She says that only in the state of Massachusetts, only that a medical doctor can testify as to what caused injuries. Although we have a medical doctor, a medical examiner on the stand who's saying she can't do it because she's not a biomechanics expert. So that's interesting. But in general, what did the judge rule in regard to Massachusetts is that Massachusetts is a communist country, that the jury's in on that.
You are unmuted.
And yes, Lisa, I think that it was acknowledged yesterday when she let that out. She said, I will hear further arguments on that from the defense. And she said, I'm sure you're going to want to argue that, and I'll hear it probably next week as to the admissibility of the experts' testimony as far as whether it's consistent with being struck by a vehicle or not. We could see the state rest today. I don't know this.
Thank you, Your Honor. Thank you, Your Honor. Permission to publish?
I don't know how deep this counselor is going to go with Emmy. How much further they're going to go with this.
And then when it's appropriate, it will be transferred to being an exhibit, but
Thank you.
yes, you can publish. Is it all set to be published appropriately?
Yes, Your Honor.
The triple N for identification. Okay.
Dr. Scordivello, you indicated on direct examination that at least that one of the bruises from Mr. O'Keefe's right hand could potentially be attributed to an attempt to get IV fluid into the hand. Is that correct?
Correct.
During the course of your conducting your autopsy, you reviewed records from the Canton Fire Department and EMS, as well as Good Samaritan Hospital. Is that correct?
I did.
And do you recall reviewing records indicating that the IV fluids in this particular case were administered through the tibia and then later through a catheter at the hospital?
Yes, they were administered through intraosseous lines in both legs, shins, and at the hospital, they were administered through a femoral central line. Yes.
And you'd agree that bruising to the backs of hands is also consistent with defensive wounds.
Yes, that's correct.
And there are actually 4 separate distinct bruises outside of the one that you discussed earlier on Mr. O'Keefe's right hand, correct?
Yes, I would say 3, but I can see how you would say 4. 1, 2, 3. That might be 1 together. But yes, I can see how you would say 4.
And you testified yesterday that there was also an injury to Mr. O'Keefe's left hand.
There was a vague contusion on his left hand, correct?
You were asked by Mr. Lowry.
Can we take this down now, Ms. Little?
Yes, Your Honor. You testified on direct examination that you didn't see any sort of obvious signs of a fight because Mr. O'Keefe's fingernails were intact and you didn't observe any fractures on his hands. Is that right?
Correct.
But broken fingernails and fractured hands aren't the only observable signs of a fight. Isn't that correct?
That's correct.
In fact, you noted a laceration over his eye.
Yes.
You noticed multiple lacerations on his nose.
Abrasions on his nose. Yes. Yes.
Multiple abrasions on his nose.
Correct.
You noticed a laceration to his tongue.
Yes.
You noted the contusions on the back of his right hand.
Correct.
The injury, the contusion to his left hand as well.
Correct.
And as you just testified, bruising on the back of hands may be consistent with defensive wounds.
It could be.
So in fact, if you have a body that presents with a laceration to one of the brows, a laceration or abrasions to the nose, an egg over an eye, contusions and abrasions on the hands, and a laceration to the tongue, these injuries are consistent with a physical altercation, correct?
Objection.
Sustained.
Are those injuries consistent with a physical altercation?
Objection.
Sustained.
Your Honor, may we approach?
Sure.
I think the proper questioning would be, could they be? And I agree with Lisa. She says defense got what they needed, quit while they're ahead. But I think there's a couple more points they'll hit on this, Lisa. And quite honestly, that's probably going to be the end of the testimony today. And I don't know that the state has another witness. I think this may be the last witness. And good morning, John Cox, or Johnny Coxerin, as Big Kingdom calls you. I'm curious, my friend, do we have a brand new member of the United States Navy in the Johnny Coxerin household?
You are unmuted.
Morning, John.
Shifting gears for a second, you indicated on direct examination that you reviewed some photographs from law enforcement that showed no footprints in the snow. Do you recall that testimony?
I do.
Were those provided to you by Trooper Proctor?
Yes.
Do you have those photographs with you?
No, I don't.
Do you recall what was depicted in those photographs?
Yes. If I remember correctly, it was the area of the fire hydrant and the area where Mr. O'Keefe's body was discovered. It's the front of the house, the area of the fire hydrant, and I believe the flagpole.
Thank you. You testified that Mr. O'Keefe had multiple fractures to his skull, but that they seemed to be originating from a single point of impact on the back of his head. Is that correct?
It appeared so, yes.
Are you reasonably certain that all of his injuries were the result of a single impact to the back of the head?
It could be a single impact.
But it also could be multiple impacts, correct?
It could be, yes.
There's another one for you, Lisa. She's still winning.
Mr. O'Keefe suffered multiple injuries to the front of his face as well.
Correct.
In other words, he could have suffered a trauma to the face and then fallen and sustained the injury to the back of the head, correct?
That is possible, yes.
And you testified before the state grand jury that the areas of bruising to the brain were likely due to a fall. Is that correct?
Yes.
In your expert medical opinion, is it possible for someone to get punched in the face hard enough to lose consciousness and fall backward?
Objection.
I'll allow it.
It's possible.
I will tell you, yes, that is possible. I've seen that in the UFC.
I've seen it in Steve Irwin videos.
Wow, they're sorting it out.
Exhibits that were just marked on it.
We've got our police use of force video review tonight, folks. Just tune in. 9 to 11 Eastern. Panel of law enforcement attorneys and civilians.
Yes.
We'll look at police use of force videos and make kind of some grand jury judgments on them. It's going to be a great show tonight. We got some great videos to review.
There's some redness that you observe on the body by the ribs that we observed in some of the other photographs that were presented by Mr. Lally.
We have just a moment, Your Honor.
Yes.
The fence is lacking some pop this morning. I'm disappointed in that. Get that girl another cup of coffee. I feel her pain.
I'd like to show you what's been previously marked as People's Exhibit 648. Ms. Gilman, would it be, Mr. Bates, could you take that down? Yeah. Ms. Gilman, would it be possible to display Exhibit 648? 648. May I approach, Your Honor?
Yes.
2853.
Dang. Come on, girl.
Dr. Squirtyville, you were shown this photograph by Mr. Lally on direct examination.
Yes,
Do you see the redness sort of next to his rib cage on the bottom? Correct.
yes.
What is that?
That is livor,
Lividity?
lividity. Yes.
Can you describe for the jury what lividity is?
Yes, lividity is the pooling of blood to the dependent areas of the body after someone is deceased.
So even though it sort of appears to look like a bruise, that's lividity, correct?
That is lividity. Yes, it goes all the way down.
And it's not the result of an injury.
No.
Thank you. No further questions.
Okay, the lights, please. Thank you. Mr. Lally?
Yes, Your Honor. Dr. Squirtyville, you did observe a minor abrasion to Mr. O'Keefe's right knee, is that correct?
Correct.
And what part of the knee was that on, if you recall?
It was on the side, on the lateral side of his right knee.
And by lateral, sort of the side that faces away from the body, is that correct?
Correct.
We're asked whether or not the small injuries on Mr. O'Keefe's face could possibly be from a punch, is that correct?
Correct.
We said that's one of the possibilities, is that correct?
Yes.
What are some of the other possibilities?
Could be impact during a fall. It could be coming in contact with any blunt object in the snow.
Would glass be a possibility as far as a blunt object?
It could be under certain circumstances.
Piece of plastic under certain circumstances as far as a blunt object, would that be also a possibility?
Correct, yes.
Now, as far as
This is all a big nothing burger.
abrasion near the last.
It literally could have been anything.
You said you were asked some questions about whether or not that could be from drag, correct?
Correct.
Now, as far as injuries or abrasions concerning dragging, would it be typical to see just one isolated abrasion in the area of a laceration?
Not typical, but possible.
Could that also be a result of the blunt impacts or as one of the possibilities you testified before from hitting the ground.
Yes.
Now, you were asked about hitting the ground, specifically hitting concrete. Would that impact injuries to the back of Mr. O'Keefe's head also be consistent with striking his head on frozen ground?
I'm sorry. No, I'll allow it.
Can you repeat the question?
You were asked a question on cross-examination about the laceration and abrasion to the back of Mr. O'Keefe's head being consistent with striking his head on concrete, correct?
Yes.
Would that also be consistent with striking his head on frozen ground?
Could be, yes.
You were asked about certain wounds as being a possibility of defensive wounds. What are some of the other types of defensive wounds that you would expect to see that you did not see in this case?
I would expect to see, or I have seen, multiple bruising to the, again, posterior aspects of the forearms. I have seen cuts, lacerations, depending on how a person might be defending themselves, the position of their arms.
And would that also include breaks in the fingernails and fractures to the hands?
Objection.
Watch the form, Mr. Lally, sustained.
What, if anything else, would that include?
It might include bruising to the knuckles. It might include broken fingers.
Now, with reference to the injuries that you were asked about with respect to Mr. O'Keefe's right hand, would those also be consistent with impact from a blunt object as well?
They are blunt impact injuries, yes.
Now, again, if I could, just with reference to, you were asked about different possibilities with the
She's thinking,
skull fractures.
these
and
fools keep
bleeding
asking me a
brain.
bunch of damn
What
questions
is
I can't
your
answer.
opinion as to sort of how that was caused and sort of, if you could again just go through your opinion as to the head injuries, the skull fracture, and the bleeding.
Objection.
Ask it again, Mr. Lally, in a different way.
You were asked about some possibilities. What is your opinion as to how those injuries were sustained or manifested in Mr. O'Keefe?
I don't know how they came to be. I described them and
Boom.
I stated previously that they are consistent with a fall to the back of the head.
And so I'm sorry, Doctor. My question is more geared towards as far as the single impact to the back of the skull and then sort of
Move out. I
radiating
got you covered.
fractures in the skull. If you could explain that in reference to the subdural hemorrhage, subarachnoid hemorrhage, and the ecchymoses that you observed.
Again, a single impact with a fall could cause all the injuries that we're seeing in the brain and the skull.
Thank you. I'm not.
Essentially, the Emmy,
All right, doctor, you are all set.
she summed up her entire testimony. I described the injuries there. They could be consistent, but she can't tell you how they got there. Yes, they're consistent with a fight. Yes, they're consistent with being struck with a vehicle. Yes, they're consistent with being hit with a tree limb. Yes, they're consistent with any blunt object. That any scenario almost you can come up with where a person is embattled, struck, assaulted, accidentally comes in contact with any blunt force object while they're on their feet. Be consistent for this. That's arrest, folks.
So I'm going to stop you right there. A short recess.
If the court needs one.
I don't need one, but I will see you at sidebar.
We're getting to the defense today, folks. This is exciting. Hold up. I didn't expect this until Monday. I hear rumor on the Turtle Boy grapevine that the infamous Lucky will be the first defense witness. So this is exciting. Dante, am I still blocked? No, Dante, we unblocked you yesterday out of sympathy. I was told that I was being too harsh on you. So welcome back, my friend. Good to see you this morning. So yes, the state has rested with the medical examiner who pretty much said, I documented the injuries. They could be what you say. They could be something else. I'm not here to say that. She even said that she is not a biomechanics expert, that she can't testify as to what mechanical means cause the injuries that are on anyone. And I find that very interesting. If we go back to tomorrow, those that you were listening yesterday, go back to yesterday. Those of you that were listening yesterday, when the judge ruled that the biomechanical engineers, did they put you in? Dante's been put in YouTube naughty bin for a bit out of for some comments, but it looks like he's back. Good to have you back. Glad YouTube showed you some mercy in your sentencing. But back to what I was saying is that the judge ruled yesterday that the mechanical engineers couldn't testify as to injuries, what mechanical processes would cause said injury, and that in the state of Massachusetts, that it has to be a medical doctor. She says by law. I haven't looked at this myself, but she says by law it has to be. Although the medical doctor, the medical examiner, who is a medical doctor, and in fact, it is their job to say what caused the demise of people, said on the stand, I'm not a biomechanical engineer. I can't testify as to what caused these injuries. I can say they're consistent with this or that. And folks, for those of you that maybe not quite understand exactly what she's saying that if you come to me and said, we believe it was a baseball bat, she would say, it's consistent. It could be a baseball bat. That's right. Or if the police said, we think it was a motor vehicle, she's going to say, with these injuries, yes, it's consistent. It could be a motor vehicle. She can make an argument for any blunt force trauma almost that you can imagine. With these injuries, she could make the argument for. And I see what she's saying. And I think this medical examiner was a very good witness. She was very sure of herself, but she didn't play to either side. She came in there and testified to what she knew, and she wasn't playing the game. To an extent, she wasn't playing the game and trying to make a case better. Now, when she was asked by the defense, could it be consistent with dog scratches? Yes, it could be. Could it be consistent with baseball bat? Yes, it could be. So I think she played it fair on both sides when they both played the what if game. Do you think it could be this, or you think it could be that? So that's the state. What do you guys in the gallery out there? What do you think? Do you think the state's proven their case? If it went to deliberations right now, are you coming back with a guilty verdict?
I'm sticking to what I said earlier in the week and throughout the weeks that we've been watching this. I still don't think that she's done it. And in fact, when they had the person on yesterday talking about the orbital cracks in the base of the skull, that even more so says that he was struck with something. And I think bringing up the baseball bat or a set of weights and the fact that he had a gym in the basement of his house kind of solidifies that more for me. There's nothing so far that is telling me that he was struck at 25 miles per hour in the winter on a snowy road and sent flying across the front yard, where he bounced at least once and then slid and looked like a really bad Roadrunner episode. You're not going to convince me of it at this point. There's just absolutely no way.
That sounds like an acquittal to me. Range is asking, so is AJ Allen Jackson going to go Miley Cyrus and come in like a wrecking ball? I don't know if he's going to come in slow or if he's just going to pop the glove on and go in hard. I'm not sure what he's going to come up with first. I'll be quite honest. I think they may be surprised that the state is rested this early in the day. They're talking about going a full day today. And of course, these sidebars, they may have been talking about that, just that reason that the defense will be ready to go with their first witness. I got a text message from Kingdom, who's out and about. He's the man around town yesterday and today. But his really only comment was that the defense will call Lucky as their first witness. This is the road plow operator that says that there's no way in hell he would know if it was. There was no body laying by that flagpole at, say, I think 4 or 5 in the morning, when the state's with the state's theory that there would have had to been O'Keefe would have been laying there at that time. So that's interesting to see what he comes up and actually says, and if that's what it is. Of course, I'm sure that's coming from Turtle Boy or another external source. So take that for what it's worth. To see if actually Lucky does get up and what Lucky's actually going to say. Sorry, folks, had to take a phone call. But Big Ron, did the medical examiner do anything for you?
No, I agree with you on what she was saying. It was very even keeled. It wasn't leaning one way or the other. It was pure facts. This is what I found. This is what I saw. Yes, it could be conclusive with either one of these ways of getting the energy or the injury. It didn't really do much. It was information. That's about it. He's dead. This is what I think caused him to die between hyperthermia and blunt force trauma. She has no way to know what caused it. There's no quote unquote weapon with the exception of the car. We already know that the damage to the car really isn't conclusive with the speed of impact to a human body. I just, again, you're not gonna sway me that she did it. And in fact, if you looked at her face when they were bringing up the pictures of some of the injuries, she looked away. So you could definitely see that it was bothering her. And I think that's going to play into her favor with the jury too, seeing that she's showing emotion.
You know what? She didn't show too much emotion during that. I was watching her as well. And so was, interestingly enough, John O'Keefe's brother. When I think when they weren't showing any of the graphic photographs of the face, the camera in the first shot was directly on his face, and he was in a gaze, a stare directly at Karen. And I would imagine, and I'm just guessing that he's looking for a reaction in her face when she sees these pictures of his brother that's dead, a man that she lived with and had some feelings for, maybe not love, but at least had some affection for, who is clearly dead there in the photographs. So I don't know that I saw too much reaction out of her. She did look at photographs and then she would look away, but I didn't. She's pretty stoic. It was hard to see any emotion there with her. We may have the Johnny Cochran with us this morning. He's in and out having some connection issues there in North Carolina. I think I hear him. What's going on, John?
Yeah, I'm here. I had to run down and put the robot in the pool while I run some errands. So I now have intranet.
Well, you just wait till AI takes over. The robot will be able to get itself in the pool and know when to do that. It'll save you some time.
It's not too far off, I do believe. So yeah, I gotta run some
You know what?
errands.
If doing stuff like that, I'm cool. If it just does dishes, I'm cool with that too.
Hey, I do dishes and laundry.
Yeah, I do too, John. If I had a robot to do it, I'd be okay with that. I wouldn't complain.
But I don't. I actually hands-on do it. I like doing it. So what's going on with the ME? I heard her talking about fingernails and then the levity and all that, and then I lost connection.
In general, her entire testimony says that he was killed by blunt force trauma and or a combination of blunt force trauma injuries to his back of his head, skull fractures, internal bleeding in the brain, internal bleeding at the liver, and hypothermia. And that's pretty much where she lays her anchor. She doesn't go too much further. She says, yes, they could be consistent with being struck by an automobile. Yes, they could be consistent being struck by a baseball bat. They could be injuries that he sustained in a fight. They could be injuries he sustained from being getting struck. Injuries that he sustained from just falling down. So I think the medical examiner played this way. I think an expert witness like that should be playing it. these are my findings. These are the facts. Apply them for what you know. I'm giving you everything that I know. But she did not once commit this was a vehicle strike, as inclusive or exclusively a vehicle strike. She did not commit that it was dog bites. Didn't rule them out. Said, yeah, could be dog scratches on the arm, and she said it could be being struck by a baseball bat or another blunt object, including a barbell or a gym weight. She didn't rule any of those out, and I agree with her. She didn't have enough information to make a determination. So the state goes out, I think, with a whimper with that. Everybody knew that John O'Keefe was dead, and the medical examiner came in and testified pretty much to that fact that he was dead. And your guess is as good as hers as to how that happened.
Yeah, I was thinking last night. I wonder, as a juror, also, you take in the fact at the beginning of the trial and along the trial, they mentioned the dog. Then when Dr. Russell gets up there and I'm going to ask her about that, the jury knows that the dog got gone shortly after O'Keefe was found, right? Or no?
I don't know that that testimony's actually been in. Whether the dog is actually not at the location it was gotten rid of, I'm not sure what the jury knows on that. Now, if they don't know, I'm sure the defense is going to bring it up. They've dropped dog every opportunity, and they're going to bring in a grandma dog expert who's going to testify that she believes these injuries were caused by canine. So very interesting. We're going to see what the defense is. What is the defense going to bring to bear? Is it going to be as much fireworks as we anticipated? Or are they going to go out with a whimper? I'm curious to see. Guys, I'm going to step away and get a cup of coffee so I can get all my synapses firing as they should be. Big Ron, John, you guys talk about this amongst yourself, and we'll watch the ceiling fan until they come back. Right now, we're on a little recess between the state resting and the defense taking the case. In fact, guys, if you guys that have got this out on, if you would retweet the stream and let everybody know we're on the defense, that this is a pivotal moment in the trial. And I'll be back in a moment with a fresh cup of coffee.
All right. So, Big Ron, what do you think at this point?
Yeah, like I said, I don't. Just from what the prosecution's laid down, I don't think she did it, and I don't think we're ever going to find out who did it. If they acquit her or find her innocent, the state's not going to prosecute itself. I don't know what's going to happen in this. Although with the way we've seen the justice system running for the past couple of years, the flip side of that is they could put everything down. Everybody and their mother could think she's innocent, and the jury could be playing strictly on emotion, and like we know they do most of the time, and say, nope, she did it. She's guilty, and put the poor woman in jail for the next 35 to 40 years for a murder she didn't do.
Yeah. And you know what? And I along the way, I have thought that maybe they'll pick this back up and say, okay, well, she didn't do it. Let's re-examine this. But when you do that, you still only have the evidence to go by that they had to go by during Karen's trial. So that's still not going to point a finger or say who done it. So yeah, I think you're right. I have to be honest and say I was hoping that they would go back and they could figure it out. But now that I think about it more, I don't think they'll ever figure it out.
Well, when you have issues where they're not interviewing witnesses until 18 months after this has happened, there was no. That just blows my mind. For first few weeks, I get it. Maybe even a month when you're trying to put the case together, but 18 months interviewing some of these witnesses, the completely botched evidence collection using red Solo cups, leaf blowers, rakes. I mean, the entire crime scene was a shamble. A 5-year-old could have done a better job watching TV shows. It just, I don't get it. And I think Joe nailed on it yesterday when he was talking about, it's not so much incompetence as it is just sloppiness, and the sloppiness has become so commonplace that that's just the way they do it now. I think there needs to be a larger state investigation, and as much as I hate to say the word federal investigation into this police force and the way they do business, the way they do investigations. And like I said, I think it was last week or the week before, if this is the way they do things, how many people are sitting in jail right now due to a botched collection effort or an investigation where they wanted the stuff to go one direction. That's another thing that worries me. You know, how many cases do they maybe need to go back and look at now? But again, that would take a federal, intervention or a bigger state intervention for that to happen.
Well, and I'm not saying you're wrong, but I also wonder, and this is a rhetorical question. I wonder if they can file a lawsuit again. And when I say they, I'm talking about families or those who have been convicted that honestly believe that had the investigation been done correctly and not in a sloppy way, that they wouldn't be behind bars today. If they wouldn't have a lawsuit against the Massachusetts state police. I don't know. I've never seen that happen. I never heard of it happening. I'm not saying it can't happen. I don't know. Maybe Joe knows. I don't know. I don't know what what their options are, if any. And if they don't have any, that you're right. That's sad because there's people more than likely sit behind bars that are innocent, and we all know that that's happening regardless. But whether it be one or 100, I mean, that's that's somebody that needs to be out among us that shouldn't be where they are. That's the sad part about it.
I don't know if Lisa's in the chat. Lisa, have you ever seen anything like this where they've had botched investigations so bad to where they need to go back and look at the agency or maybe look at other cases? I don't know if she's still in the chat. I see she said she'll be back, so I don't know if she's still there. I'd like to kind of get the opinion of some counsel on that.
Yeah, like I said, when I get back home after I get everything done, I might do some research on that, but just to see. But I don't know. It would be interesting to know. Do we know who's on the witness list today?
I don't know who's on the list for for today for the defense. I'm sure Joe probably has a list. I'm just finished my first cup of coffee, so my brain's finally coming online. It's recuperating from last night in the after party. I had to take off a little bit early. I didn't want to inadvertently let the bourbon say something that shouldn't be said.
Oh, sounds like something I missed.
It was a good show last night. Just we got into the after party and that last old fashioned went down way too easy. And if I find myself getting to that point, I don't usually like to be my wife's like, you were giggling. I don't like to put myself into that situation. If somebody says something, my filter at that point is completely gone, and then the old crusty sailor comes out in me, and I don't want to offend somebody or get a strike on the show or something like that.
No, I understand. Yeah, I had to go get my girlfriend's son pick him up from MEPS. He run into one little more snafu, but hopefully that'll be corrected today. But he got everything else done. It was kind of funny on the way back. He's and I'm sure most of you will know. I'm not gonna say it on here, but he's like, yeah, he said they done my physical, and there was some very uncomfortable moments. I just started laughing.
The duck walk.
Yeah, he could get over that. He said, "Get this." He said, "I had to strip down to my underwear, and I had to squat down. Then I had to walk around the room." He said, "You know how humiliating that was."
The duck walk. It's awesome. Yeah, you and I will have to have a sidebar there, John, about this. We've got a question from Dante. He says, "How harsh are the sentencing options?" And the question mark of the chair. Technically, with her, killing a police officer, that's capital punishment. So yes, she could face the death penalty for that. Well, let me say, in Florida, she could face the death penalty to that. I am not sure what the sentencing options are in. I think she's in Massachusetts, is where this is coming out of. Am I wrong on that?
Yeah, it's
Massachusetts.
Boston.
Yeah, Massachusetts. Yeah. I'm not sure what the sentencing is in Massachusetts if they have the death penalty for capital crimes for police officers. I would have to check into that. don't want to give you bad information, but yes, in Florida, killing a police officer, you are definitely have the option of facing the death penalty. And I know that our governor does not play around. If you kill a police officer, he will push the DA for that. So just keep an eye on that, people, if you come to Florida.
Well, no, just curious, Ron, is that murder or also manslaughter?
I think, you know what? I think it's murder, John. I think it has to be intentional. So that's a really good point. With this being, you know, manslaughter, accidental death with no intention. Yeah, I think that may be off the table then. But in Florida, it's definitely, if you intentionally kill a police officer, they're going to push for the death penalty.
Yeah, in which they should under their circumstances. And yeah, total different subject, but I've already been in contact with Ron DeSantis's office about another thing that we're working on with Jason's gig, and they are very, very nice, very professional, very prompt. So
that's
far,
good to hear.
Yeah, I've actually been surprised. I think Jason was too, to a degree.
Yeah, keep me in the loop on that. Like I said, my wife being a teacher, I kind of want to stay in the loop on that.
Okay, yeah, I most definitely will. So
as much as you can, let's put it that way.
Yeah, so yeah, I mean, I was told who to call with the school system, so my understanding is that it's a go. It's just got to get the ball rolling, but I'm waiting on a phone call back. That's about all I can say right now.
Hey Vet, kind of another off topic. I know we're kind of all over the place. Hey Vet, I saw your message this morning. If you get that nailed down for that location, let me know, and I'll make some phone calls and see if I can make some adjustments for you. So if we have our Wednesday show coming up, where we're talking about smokers. So for the Wednesday show, so everybody knows, I'll be doing a brisket this weekend. Try to get some good pictures of that. We're gonna do a full brisket on the pellet smoker. See how good of a smoke ring we can get on that. And I may even try for a good bark on it just to see if I can do it, since that's been a discussion of contention between Joe and I of the ability to and not to be able to get a bark on a pellet smoker. So we're gonna tomorrow. Go ahead.
You're saying you have been challenged?
Well, it's not so much challenged as it is a challenge, but we're coming back, guys. We'll see what's got going on.
Please be seated, court is in session.
You are unmuted.
All right, so Mr. Jackson, yesterday you told me you would like 10 minutes for your argument. I'll hear you now.
Thank you, Your Honor. Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count.
Okay.
In each one of those counts, there must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe.
That's what I'm thinking, Joe.
There's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything in the Commonwealth's case, everything relies on that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that Trooper Joe Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence that the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters. or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory. And there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court, the only evidence that is before the court, is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries. And they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies science, common sense, or even logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses. What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth. But here, there is no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case found at 491 Mass 848, pinpoint site 860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily requires conjecture or surmise. In our view, there is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture. And that's why, in our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3. It's because each of the counts, as I said at the beginning, necessarily include an element that John O'Keefe was struck by Karen Reed's vehicle. Thus, if a rational jury cannot reasonably believe Trooper Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing else in the court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe that any rational jury would ever unanimously agree with Trooper Paul, and thus we ask the court to find Ms. Reed not guilty at this time.
Okay.
I'll submit.
Your Honor, if I may just, we have a written motion for the
Okay.
court to act on pursuant to that argument. May I give a copy?
All right, I will hear you, Mr. Lally.
Yes, Your Honor. Surprisingly, I would disagree with counsel's
So let's leave the comments out.
Your Honor, as far as the comments, all I was going to say is that I would submit to the court that,
Is this surprisingly that I took issue?
and my apologies for that. What I would submit to the court, Your Honor, is that this case does not rest and fall with the testimony of Trooper Paul. Trooper Paul's testimony, while important when taken in conjunction with the remainder of all of the other witnesses and all of the other testimony that the court has heard, I don't want to minimize it, but at the same time, that is not the only evidence that the vehicle struck Mr. O'Keefe or interacted with Mr. O'Keefe. So what the court has, as far as the physical evidence, next to Mr. O'Keefe's body, the one sneaker in the location of the curb, the glass, the drinking glass that Mr. O'Keefe is seen walking out of the Waterfall Bar at approximately 12:11 a.m. with, that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillight, which was testified by Ms. Hanley to be consistent with the pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillight, and this part is important in relation to Trooper Paul's testimony as far as the linear momentum, and it's all in the same sort of direction and path of all of the roadway evidence that he observed that's discovered in and around the area where Mr. O'Keefe's body was. The testimony from Ms. Valier, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on the ground and then put back together, matching not only to that, but the taillight housing from the defendant's vehicle. The taillight housing from the defendant's vehicle, which has the victim's, Mr. O'Keefe's DNA contained on it, as well as the mitochondrial DNA testing of the hair that was on the rear right quarter panel of the defendant's vehicle, which also was matched or consistent with that of Mr. O'Keefe, his mitochondrial DNA, as well as court heard from his chart from Bodie Technology. You have the plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications, as well as the testimony of the children in this case as to the state of their relationship from the defendant's own mouth in those text communications and in those voicemails as to the state of their relationship. You have the testimony in regard to Mr. O'Keefe and his recounting of the state of their relationship and his numerous attempts to break it off with Ms. Reed prior to that date. There are arguments that continue throughout the afternoon of the 28th and seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources, including firefighter Nuttall, firefighter Flamati, firefighter McLaughlin, and Ms. McCabe. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument. You have the testimony in regard to Ms. Roberts and Ms. McCabe as far as the altercation or the verbal argument stemming from Ms. McCabe's reference of Bella's mother being a landmark, being someone that Mr. O'Keefe used to date just prior to that argument occurring in front of the house at 34 Fairview Road. With each and every piece of evidence that was presented throughout the course of the Commonwealth's case, including the forensic evidence, including especially one thing I would stress for the court is taking not only Trooper Paul's testimony, but Trooper Paul's testimony in juxtaposition to Trooper Garino's testimony as far as the vehicle or the native GPS locations of Mr. O'Keefe's phone in reference to the timing and in particular the information or data from the Toyota text stream. Trooper Garino's GPS native location of Mr. O'Keefe's phone has that reversal, the same 3-point turn that Trooper Paul testified about, which occurs 8 minutes prior to the vehicle traveling 24.2 miles per hour for approximately 62 feet in a straight line in reverse. And as far as the testimony and the evidence that the court has before it, the court also has those backup testing videos that Trooper Paul conducted with the defendant's vehicle, so the court can see exactly what that vehicle looks like at approximately 25 miles per hour in reverse in a straight line. And what I would submit, Your Honor, is that there's more than sufficient evidence from a medical perspective, from a forensic perspective, from a civilian witness perspective, and from the investigation of this case as to all three indictments that the Commonwealth has met its burden, particularly under the standard before the court at this time. And for those reasons, I would request that the defendant's motion be denied.
Okay. Right. In the light most favorable to the Commonwealth under the prevailing Lattimore standard here in Massachusetts, I am satisfied the Commonwealth has met its burden. The defendant's motion is denied. So, Mr. Yannetti, are you calling your first witness?
Yes, Your Honor.
Okay, so let's bring the jurors in, please.
All right, folks, I'm back. Let me put John back on the stage. He may have removed himself for a reason, but I'm throwing you back up there anyway. Those listening and may not know, I'll say the obvious, that it's not uncommon for the defense to always put a motion in between the state resting and the defense picking up their case for a dismissal The judge is obligated to deny that motion if there's any facts left for the jury to decide. Those of you that follow the night court show, we did a case on the Ninth Circuit Court of Appeals decision on the COVID vaccine, a lawsuit out of the Los Angeles school districts. And that was their decision, was that a judge gave a summary motion to dismiss when there was yet still facts to be decided by a finder of facts, which is a jury in this case. So I'm not surprised that the judge didn't approve the motion. Not surprised the defense put it up. It's kind of a common thing.
So, roundabout, how many more witnesses do you think they have?
I have no idea how many defense witnesses there are. We know we've got the 3 that were in voir dire on Tuesday. I've heard Lucky. Kingdom is saying on text messages that Lucky that Lucky's going to be there and be the decider on this and the Perry Mason moment in this case. But I don't know who the defense is going to call first thing this morning, and but I'm dying to find out. It should be interesting. Now, remember, the defense can recall witnesses and put them on the stand. Could very well call Trooper Proctor and with a different scope and foundation of questioning. Now, will they call Proctor back? I don't know. They may have gotten all they needed out of Proctor. I don't know how much more you could squeeze out of that turnip, other than putting him up and making him look like an ass again, which I'm for. I'll sit and listen to it. It sounds like it'd be a great idea.
Court's back in session. Please be seated.
All right, so jurors, if you remember in my preliminary instructions to you a long time ago now, I stressed to you that the burden of proof rests with the Commonwealth. The defendant has no burden of proof whatsoever, doesn't ever have to testify or present any evidence. So the Commonwealth has completed its case, the Commonwealth has rested, and I want you to keep in mind that the defendant has no burden of proof. Ms. Giannetti, do you have a witness for us?
Thank you very much, Your Honor. The defense calls Brian Laughlin.
Okay.
Brian Loeffler? Is that what I heard?
That is what you heard.
Okay, good. I don't know who that is. But we're about to find out.
You solemnly swear the evidence you give the court and jury in the case now hearing should be the truth, the whole truth, and nothing but the truth, so help you God. I do.
They will typically go like the prosecution does, kind of chronologically. You'll have your foundation witnesses come in, and they'll
Yes.
Good morning,
tighten the
sir.
noose
Without
as it
voice,
goes.
Would you state your name and spell your last name?
Sure, it's Brian Loughran. It's Loughran.
And where are you from, sir?
Mr. Lockren, I'm going to ask you to keep your voice up as loud as you can, sir.
Sorry.
That's okay.
Maybe put your mouth as close to the mic as you can. Where did you grow up, sir?
Canton, Mass.
Is that where you live?
Yes.
How long have you lived there?
Both 35, 36 years.
And did you go to Canton Public Schools?
Yes.
Now, in the course of living in Canton, were you familiar with the Albert family?
Yes.
Which members of the Albert family were you familiar with?
All of them.
And when you say all of them, can you name the ones that you were familiar with?
I was familiar with Brian,
Brian Albert?
Chris Albert, Brendan Albert, Kevin Albert, and I believe Kathy Albert's the sister, but I'm not 100% sure on her first name.
Okay, and those are the siblings that you had contact with and were familiar with?
Yes.
Did you know some better than others?
Yes.
Whom did you know the best?
Chris Albert.
What is the age difference between you and Chris Albert?
I believe we're the same age.
Did you graduate high school with him?
He went to a different high school, but yes.
Graduated at the same time?
Correct.
And with regard to your familiarity with Chris Albert, can you explain to the jury how you became familiar with him and what your relationship with him has been?
I went to school with him, elementary school. We went to middle school. Then he transferred to a Catholic school. Then later in years, I began to work for Chris for D&E Pizza, delivering pizzas.
Okay. And approximately what ages were you when you were delivering pizzas for D&E Pizza and Chris Albert?
I was 25, 26 years old.
And how many years did you deliver pizzas for him?
Up until I got married, 35.
So several years.
8 years.
8 years, okay. And with regard to your interactions or knowledge of Kevin Albert, can you describe that?
Kevin Albert would be through D&E Pizza if he came in. Through the police department, would see him on details.
All right. And were you friendly with him?
Yes.
With regard to Brian Albert, could you describe your interactions or your relationship with him?
Again, through D&E Pizzas, delivering pizzas to his house. Cordial, polite, would say hello.
All right. So you're friendly with the Albert family?
Correct.
Now, back in January of 2022, where were you working?
I was working for the town of Canton.
In what department?
I was working in the sewer department.
Is that also called the water department?
Yes, water and sewer are combined.
And under what heading is that?
It's DPW.
It's under the DPW, the Department of Public Works?
Correct.
Now, back in January of 2022, were you one of the regular snow plowers for the town of Canton?
Yes.
And
This must be lucky.
directing your attention to January 28th of 2022. Do you remember that day?
Yes.
What do you remember about that day, the 28th?
It was a potential blizzard. We had been given a start time.
All right. And when you say you had been given a start time, what does that mean?
It means that we're expected to be in our trucks at a certain time on our route.
Okay. And who gives those instructions back in January of 2022?
The supervisor for Canton DPW,
And who was that at the time?
William Walsh.
Also known as Billy Walsh?
Yes.
Now, when were you called in to do plowing that evening or early morning?
We were told to be in by 2:30
And is that 2:30 a.m. or p.m.?
a.m.
Would that now be on January 29th?
Correct.
So what time did you arrive at the DPW that early morning?
About 2:15.
When you got there, what did you need to do in order to go out plowing?
I needed to get into my truck and get that prepared to go out.
All right. And your truck, is there one that's specifically assigned to you when you plow?
Yes.
And does that truck have any particular nickname?
Yes, it's called the Franken truck.
And why is it called the Franken truck?
It is a truck that has a lot of different parts than what it's required. It's not parts that were made for that specific truck.
An older one?
Yes, it was a truck that was very uncomfortable at the beginning to use. So they try to make it as comfortable as possible.
All right. And that particular truck, is it used for anything else other than snow plowing?
Yes, it's used for everyday use.
Okay. Now, so you get to the DPW at 2:15. You say that you get your truck ready. What does that entail to get your truck ready, and how long does it take?
It takes about 5 minutes, but just basically you need to make sure that it's got enough gas in it so we're not going to the route and running out of diesel fuel, which is not good. It's just basically going over the truck, making sure, you have everything you need for that night.
And do you plow alone or with someone?
By myself.
Now, with regard to the visibility in your snowplow Franken truck, can you describe that for the jury, what you can see, what you can't see?
So the Franken truck has an air ride suspensions, an air ride seat. So the seat is raised so I can see over the hood.
Okay.
And I can see about 5 feet on either side of the passenger side, driver's side.
And when you say 5 feet, are you talking straight out from the?
From the windshield straight out.
All right. And what, if any, lighting do you have on Franken truck?
We have marking lights. We have 2 plow lights that are situated at the corners of the trucks, and it's up high. It illuminates very well. It's very well seen.
Okay. And with the extra set of lighting that you just described, how far can you see off to the sides, in front of you, and directly in front of you?
Probably 5 feet on the sides.
Well, you already testified to that, 5 feet straight out.
Yeah.
But what about the sides going forward?
It's you know, it's hard to decide to put into words, but I can see a real long distance. That visibility is fine. It is extremely. If you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
Enormous amounts. It's almost driving with the spotlight.
And with regard to the air ride seats, what action did you take with those that particular night?
I raised it so that the bottom of my knees would hit the steering wheel.
And what, if any, obstructions, I should say, were in front of you that would prevent you from seeing what's in front of you or to the side?
Nothing.
All right. Now, do you have a specific route assigned to you?
Yes, I do.
Could you describe that route? And by the way, that specific route, was that the one that you were assigned on January 29th?
Correct.
Could you describe that for the jury?
Yes, it's a route that consists of Cedar Crest from Kings Road to Chapman Street and everything in between. There are a lot of streets I could name if you would like, but Fairview is one, Spring Lane is one, Cedar Crest, Kings Road. Those are pretty important roads that I would consider major roads on my route.
All right. Now, that particular night, if you got there at 2:15, what time do you think you were on the road in Franken truck?
I was on Cedar Crest about 2:30, 2:35.
Now, with regard to Cedar Crest, I would like to show you a map if I can. May I approach, Your Honor?
Yes.
I've handed you a document. If you could just review that to yourself and then look up at me when you're done. Do you recognize what's depicted on that?
Yes.
What is it?
It is my plow route and consisting of streets that I plow.
All right. And to be fair, that's a portion of your plow route, right?
Correct.
There are other areas of the city that you plow?
This actually depicts my actual physical route.
Oh, okay, great. And that's a fair and accurate representation of the streets as they existed back in January of 2022?
Yes.
I would offer that, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay. Thank you.
And can I have permission to publish before the jury?
Sure.
Okay. Now, you just testified that you got to Cedar Crest, I believe. You said 2:30 to 2:35 or so?
Correct.
All right. As we look at this exhibit on the screens, are you going from right to left or left to right on Cedar Crest when you first approach Fairview?
Right to left.
Okay, so you're going sort of from the upper right-hand corner of the diagram down Cedar Crest toward Fairview. Is that accurate?
Yes.
Could you take the laser pointer and just confirm that route for the jury? That's, okay. You see that's Fairview Road? Are you able to read that right?
I'm not, to be honest with you. I'm sorry.
Do you still have that map in front of you? Maybe that'll help you, Mr. Wall.
And actually, can I orient it so it's oriented just like that for him? Okay, that's how it's up on the screen.
Okay.
And by the way, I should have asked this, but is it in terms of is it you can't read the writing or you can't really see the outline of the streets?
Both.
Okay. Well, that's not going to help much. Okay, if we can have the lights back on. With the court's permission, can I leave that up on the screen while I ask a few more questions?
Sure, except you said you can't see it.
Right, no, I know, but the jury can, so I think it would be helpful for them. All right, so you're coming down Cedar Crest, and would Fairview be on your left or your right when you first approach it?
When I first approach, it's on my left.
All right, now do you take that left at that time?
No, I do not.
Why not?
At the time, I'm pushing snow, and we don't want to block any part of the road with snow, and taking a left would have left a row of snow. So I proceed to the end of Cedar Crest, do a cul-de-sac, and then head back up Cedar Crest.
All right, so there's a cul-de-sac at the end of Cedar Crest.
Correct.
Dead end.
Yes.
And you plow that?
Yes.
All right, so then when you come back up, is Fairview on your right or your left?
It is on my right.
What do you do?
I take that right and continue to plow.
Now, are you familiar with the Albert residence on Fairview Road?
Yes.
How did you become familiar with that?
Growing up in Canton, I knew where they lived.
Can I have Exhibit 66 displayed with the court's permission?
Yes.
From where you're seated now, Mr. Loughran, are you able to see what's on the screen?
Yes.
And do you recognize that?
Yes.
What do you recognize?
Give me a second. We've got a froze screen. Let me get that
I
fixed.
start in the middle and I angle right with the plow.
Now, I want to direct your attention to when you were, your truck was essentially perpendicular to the driveway. You see the driveway in Exhibit 66?
Yes, I do.
When you were perpendicular to the driveway, where were your headlights pointed?
In front of me. In front of the truck.
I'm sorry?
In front of the truck.
And what were you able to see of the front lawn of the Albert residence that very first time you passed?
I was able to see the entire front lawn.
And about what time was it that you first passed 34 Fairview Road?
About 2:45.
Now, as you continued along past the driveway, did you continue to have all of those headlights on in front of you?
Yes.
And as you continued along, what were you able to see of that front lawn? How much of it?
A very large portion, almost to the front steps.
And now, when you're plowing, where is your attention focused, sir?
My attention's focused in front of me and then to the sides.
Why would your attention be focused to the sides?
I am trying to be aware of any side traffic, any pedestrians, and God forbid, any animals.
And when you were passing the Albert residence, as you pass every home, what attention do you pay to the sides of the road and the lawns that are adjacent to the road?
I'm, again, making sure that there are no animals, no pedestrians, and making sure no one's coming out of their driveways, not expecting to see me.
And with regard to Exhibit 66, do you see the flagpole there?
Yes,
Is that something you had seen previously?
yes.
And when you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
If there had been a 6'2", 200-pound man lying in the snow there, would you have seen it?
Objection.
Sustained.
Now, once you pass the residence, where do you go?
I go to the end of Fairview.
And what street does that intersect with?
That intersects with Chapman Street.
If we have the previous exhibit put back up with the court's permission. Sure. Okay. Do you still have the exhibit oriented the same way, sir?
Yes, I do.
Where's Chapman Street on the exhibit? Down the bottom, the top, or which side?
Down the bottom.
Okay. And when you come to the end of Fairview with Cedar Crest in your rear now, right?
Correct.
Do you take a left or a right on Chapman?
I take a left
All right.
onto
And
Chapman.
once you take that left, what do you do?
I back up and then take a left to go back down Fairview.
So you're essentially doing almost a three-point turn in the road?
Correct.
All right. So now, do you go back down Fairview at that time?
Yes, I do.
And how far do you go down Fairview?
To the end, to Cedar Crest.
Now, at this point in time, you would also pass the Albert residence, correct?
Correct.
Would it be on your right or your left?
On my left.
Were you looking to the right and the left as you were coming down?
Yes.
How much light did your headlights illuminate of the Albert's front lawn as you were coming down from Chapman Street?
Coming down Chapman, just about the entire front lawn.
And again, with regard to that area around the flagpole, did you see anything on the lawn?
Nothing.
See a body?
No.
All right. Now, after you've done these two passes, sir, where do you go?
I then take a right on the Cedar Crest. I proceed up Spring Lane, come down Spring Lane, and then do the remaining of my route.
How long did it take you before you wound up back at Cedar Crest and Fairview?
About 45 minutes.
So I think you had previously testified you made the first pass around 2:45?
Correct.
So would that put us at about 3:30 when you're about to make the second pass?
Objection.
Sustained, ask it Tiffany.
Sure, I'm sorry. What time was it, to your best estimate, in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30.
All right. Now, when you approach that intersection, again, are you approaching it such that Fairview would be on your left or your right this time?
On my left.
Same as last time.
Correct.
What do you do when you approach Cedar Crest? I'm sorry, when you approach Fairview and it's on your left?
At that point, I have an option. I can go to the end of Cedar Crest, or I can turn around at a street, depending on how much snow I have on Fairview.
And with regard to the decision you made regarding that choice, what decision did you make on January 29th?
Went all the way to the end.
Went all the way to the end of Cedar Crest?
Correct.
Same thing you did the first time?
Correct.
And then you come back up?
Correct.
Is Fairview on your right or your left at that time?
It would be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that point?
At that point, I saw a Ford Edge on the side of the road.
Where was it parked on the side of the road?
In front of the Albert's house.
Where in front of the Albert's house?
By the flagpole.
And why was that unusual?
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now, what were the snow conditions like at that point? This is now, I think you said about 3:15 to 3:30.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard where there's plowing to be done?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
Now, once you saw the Ford Edge parked on the side of the road near that flagpole, what did you do?
I had to go around the vehicle and as to not hit the vehicle.
All right, and probably obvious, but as you're approaching the vehicle, was it faced in the same direction that you were traveling?
Yes,
And so you're going around to the left or the right of the vehicle?
left.
And once, as you were approaching that vehicle, were you able to see on the right side of that vehicle the lawn sign?
Yes,
Did you see anything on the front lawn at that time?
Objection.
I'll allow it. Did you see anything?
no,
Lights were still on.
correct.
All right, now, once you pass the vehicle, did anything attract your attention at all?
No.
All right, where do you go?
I go up to the end of Fairview and do the same process, take a left on this Chapman and back down Chapman and take a left into Fairview again.
Once you come back down Fairview, do you pass the Albert residence again?
Correct.
Was there that car that you saw?
Correct.
It moved from when you passed it the first time.
No,
Were you able to see the front lawn of the Alberts in front of you as you were coming down Fairview toward Cedar Crest?
not as much as the first time because the car blocked the view.
All right. Now, after that, how long did it take you before you came back to that area to plow again?
About 3 hours.
Do you recall about what time it was that you wound up back on Fairview?
I don't honestly recall what specific time.
Sure.
Um,
Approximately, if it was 3:15 to 3:30, that second time, what would be your best estimate of the time when you came back?
I would say if I had to say, it would have been 5:30 up Fairview and came back down. And then at that point, I wasn't able to go further than Carriage Lane.
Okay, and when you say that you went up Fairview and came back down, you initially went from which side of Fairview?
Right side.
What would that be, the right side? I'm sorry. Would it be the Cedar Crest side or the?
It would have been Cedar Crest side.
Coming from Cedar Crest, and then you went up Fairview, came back down?
Came back down. As I'm going up, I am actually seeing first responders. And at that point, as I'm coming back down, the road's blocked at that point.
Okay. And when the road was blocked, what, if any, plowing were you able to do after that on Fairview?
I was able to go as far as Carriage Lane and then turn around.
Okay. And then I imagine it was several hours before you could plow again?
Before I could plow Fairview to the end of Cedar Crest, yes.
All right. Now, I'd like to direct your attention to February 15th of 2022. We were approached by an investigator who wanted to ask you questions about what you had seen and done on January 29th of 2022.
Yes.
Do you remember his name?
Yes.
What is it?
Paul?
And what was your understanding about whom Paul worked for?
Objection.
Ask it On
On February 15th of 2022, were you ever approached by anybody in law enforcement, sir?
No.
So what was your understanding of Paul's job?
Objection.
I'll see Councilor Taiba.
All right. What do we think?
Did they ever determine who the Ford Edge belonged to?
I don't know. I don't think it's going to be in this testimony. I'm talking about with old Lucky here. What do we think?
I think it's interesting that he made a point that they normally don't have vehicles in the street. In this specific incident, they had vehicles in the street.
What about the fact this truck is called Frankenstein because it's been retrofitted to make it more comfortable and adapted for street plowing? That it has a essentially a side light, like you would have side lights on a alley lights, like on law enforcement vehicles that broadcast out far to the lateral. And that he is saying that he saw that entire yard and was normally used to seeing that entire yard, including where the flagpole is and all that business. And that there was nobody there that he could see, at least on one of those passes. Now, I think he said the view could have been obstructed with a vehicle there sometime after 2:30. But he's saying that if the state's case is correct, John O'Keefe's body would have been there the first time he drove by and plowed. He said it wasn't there.
Sure.
I didn't even catch that. That's a
At
really
any
good point, Joe.
in 2022, were you ever approached by any police investigators, sir?
No.
When was the first time that you were approached by the state police in this case? Do you recall?
I don't recall the actual date, but I do know.
Year?
Yes.
What year was that?
2023.
And do you recall the name of the investigator that approached you?
Mike Proctor and Sergeant, and I can't pronounce his name. I don't want to.
If I said Buchanan, would that ring a bell?
Yes, it is.
I have nothing further. Thank you, sir.
Okay, Mr. Lally.
Thank you, Your Honor.
I don't expect to see much out of this, so then he's going
Morning,
to
sir.
nail him
Good
down
morning.
that, a negative doesn't make a positive. You sure didn't see it.
Now, may I approach?
Yes.
Sir, I'm showing you a document that's already been marked as Exhibit 109. Just ask you to look at that and look up whenever you're finished, okay?
Yes.
You recognize that, sir?
Yes, I do.
And what do you recognize that to be?
These are the plow routes for the town of Canton.
And there's different numbers that are associated with different routes and different drivers assigned to those routes. Is that right?
Yes.
And if you look down at number 11, is that your route that you were talking about as far as the sort of portion of Cedar Crest neighborhood that you plow?
Yes.
And that's the route that you were assigned to on January 28th and January 29th of 2022, correct?
Yes.
Now, if I could ask, just as far as there's a certain way that you plow a route. Yeah. Excuse me. There's a certain way that you plow a road, correct?
Correct.
And when you're first plowing the road, you're sort of plowing the middle of the road, correct?
Correct.
And you do it in sort of a fashion that's referred to as ring road right. Is that correct?
Yes.
Can you explain to the jury what that is and sort of why you're plowing a road in that particular fashion when you're first starting to get out there with the plow?
So ring road to the right refers to the snow coming off the plow It actually leaves a row of snow. We rin road to the right to prevent cars from having to go through the rin road to the left. If you go to the left, you've now put the rin row in the middle of the left-hand lane. So everything's to the right.
So everything's to the right because if there was a vehicle coming the other way, you'd be plowing into that vehicle. Is that correct?
Correct.
And your goal, sort of, when you're first getting out there to plow the roads, is to sort of clear the middle of the roadway first, correct?
Correct.
So that's where your truck is when you first go out and plow the road, is you're sort of in the middle of the road near the double yellow line, if there is one on that road?
Correct.
Okay. Now, this truck that you were driving, on that day, how long have you been assigned to that truck for plowing purposes?
I was assigned to that truck for probably 2 years, maybe longer.
Maybe longer. Were you driving that same truck in 2015?
No.
No? Okay, so you were driving a different truck at that point?
Correct.
Do you remember what kind of truck that was?
It was an F-550 utility truck, pickup
That's
truck.
Similar in size or shape to the truck that you were driving that day?
No.
Now, you were asked some questions about February 15th, 2022, and you spoke to some investigator on that day, correct?
February 15th?
Yes, 2022. That Paul person you were talking
Yes.
about? Okay. And you met him at a skating rink, is that right?
Correct.
And you said in a statement to him at that time that you would have seen a body on the front lawn or the sidewalk, is that right?
Correct.
Now, are you aware that there is no sidewalk on the same side of the street as 34 Fairview Road?
Correct.
Now, you mentioned some familiarity with the Alberts and with the Albert resident. Are there other people on that route that you're familiar with as far as where they live and who they are and all that?
Yes.
And how are you equally familiar with them, more familiar with them, or less familiar with them?
Equally.
Equally? Now, familiarity with 34 Fairview Road, does that extend to sort of the lighting around that area?
No.
So do you know that there is actually no street lighting whatsoever in the area of the fire hydrant or the flagpole or anywhere there for several hundred feet?
Correct.
So you do know.
Yeah, I believe so, yes.
And so when you're driving by, you're looking for cars coming out of the driveway, cars coming in the opposite direction, people walking, is that correct?
Correct.
And you're trying to look for those objects so that you make sure that you don't strike them or hit them or anything like that, correct?
Correct.
And on February 15th, 2022, when you had this meeting with Paul, you told him about 3:30 or 4 a.m. Is when you saw this Ford Edge on Cedar Place, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
No, told him it was a Ford Edge.
You didn't tell him first that it was a small SUV?
No, told him it was Ford Edge.
Do you remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No. He wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So he brought you out to the parking lot at the skating rink that you were meeting at, specifically showed you a Ford Edge and asked you if that was the vehicle.
Correct.
Now, do you know sort of the difference between if you were to see a Ford Edge at nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes.
What's the difference?
The taillights in the back.
What about them?
Ford Edges are more round. The whole back facade is a little bit more round. A Jeep Cherokee are more square.
Now, what color was this SUV that you saw?
I can't tell you that. I am colorblind.
Can you tell, I'm just curious, sir, as far as your color blindness, can you tell whether or not an object is dark or light just by looking at it? Or you can't tell at all?
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you saw, was this light or dark?
Light.
I don't think you're going to shake old Lucky on vehicles. He knows his vehicles.
I was getting ready to say, oh, Lucky, he's solid.
Exactly where
I like him.
Mr.
He
O'Keefe's
seems
body was
credible
found,
and
correct?
honest.
Correct.
How do you know where his body was found?
What is up with the bald heads in
I
Massachusetts?
told him specifically
Oh, it's not just
if he was looking at the door, the front door, it was about 3 feet to the left of the door. And with
To the left of the door?
looking at the front of the door to the left of the door, pushing it up Fairview.
So if he wrote in his report that you told him that the vehicle was exactly where the body was found, that would not be true?
Objection.
No, I'll allow that.
Could you repeat that question, please?
If he wrote in his report that you told him that the SUV was exactly where the body was found, that would not be true, would it not?
That would be true. The car was to the left of the door, putting it in front of the flagpole.
My question for you, sir, is how do you know where Mr. O'Keefe's body was found? At any point in time, did you see Mr. O'Keefe's body on the front lawn?
No.
So how do you know where Mr. O'Keefe's body was found?
Through police reports, police interviews, stuff that was posted on the media.
So you've seen police reports in the media?
Well, not the
correct?
police reports, I'm sorry, but what was said during on the news.
So what you've heard on the news, not necessarily what you saw or what you know yourself, correct?
Could you repeat that question, please?
You're recounting sort of what you've heard or saw on the news, so this doesn't come from your personal knowledge or anything about where Mr. O'Keefe was, correct?
Correct.
Okay. Now, you also spoke with some other individuals in May of 2023, correct?
Correct.
Now, did you tell those individuals that you actually came in, and when you say came in, you come into sort of the main sort of hub or the shed on Boulevard Street, correct?
Correct. We punch in.
That's where you punch in and you pick up your truck and you sort of do your checkpoint around the truck and then you go out and plow.
Correct.
Now, you were plowing on this street. Was there any other sort of subcontractor or anything else that was working plowing the roads as well?
Yes.
And who was that?
It was by the yard landscaping.
And so they assist as far as the plow route is concerned, and they go around and they plow things on the same route that you were describing, correct?
Correct.
Now, these other people that you talked to in May of 2023, did you tell them at that time that you actually came in around 11:30 p.m. to 12 a.m.?
I don't remember that.
You don't remember that, or you didn't tell them?
I don't remember that.
So that would be a significant difference, 11:30 p.m. to 12 a.m. from 2:15 a.m. and 2:30 a.m., correct?
Correct.
Now, you also indicated to them at that time that you went past Fairview at approximately 12 a.m. and 2 a.m., correct?
I never did 12, but it was definitely 2:30,
So if they
2:40,
wrote that in a report, that
2:35.
would be inaccurate as well, correct?
Sustained, and only one person can talk at a time.
I apologize. I'm sorry, sir. Please continue and finish your answer.
It won't be good for the state if he
didn't
tries to run a
hear the
roughshot
question.
over this guy. He
Well, let me
comes
ask
off
it
as
again.
a
So as far as
good-mannered,
that was contained
decent
in a
guy.
report regarding
It
that
looks like you're
conversation
bullying
in May
him.
of 2023 that you went past Fairview Road or went down Fairview Road at 12 a.m. and 2 a.m., that would not be accurate, correct?
Objection.
Sustained, ask it differently.
Did you go down Fairview Road at 12 a.m. and 2 a.m.?
No.
If that were contained in a report of your conversation you had in May of 2023, would that be accurate?
Objection.
Sustained, ask it differently, Mr. Lemon.
Now, as far as that conversation that you had in May of 2023, did you tell those individuals that you saw the vehicle around 1:30 or 2 in the morning?
Again, I don't remember ever saying that.
Is that accurate as far as whether or not you told them that?
Again, I don't remember saying that.
Did you see a vehicle around 1:30, 2 o'clock in the morning?
I wasn't on the road at 1:30 or 2 o'clock in the morning.
Correct. Now, do you also recall telling those individuals that Fairview Road was blocked off by cruisers at about 3 or 3:30 in the morning?
Again, that would have been incorrect.
Do you recall saying that in May of 2023?
I do not.
May I approach, Your Honor?
Yes.
Lolly needs to be careful. He's going to look like he's bullying this guy and pushing him around, and it's not going to come across good for the state. This guy is a lack of a better term, sympathetic. I think the jury's going to see him as a common guy, your neighbor, people you've gone to school with, somebody that you could trust. If he tells you
So I'm gonna
something, he's
ask
got
you
no
the-
ulterior motives.
Showing you a document. This paragraph.
And he's looking like he's going to try. He's trying to loop him into a line what somebody wrote in a report somewhere, is attributing to him as saying that. And the significance range of the forward edge is that I just drew a blank on the young man's name, the Albert young man that they claim could have been involved in the assault to John O'Keefe inside the house. That he drives a forward edge. That's why the significance of it being there at that time is significant to the defense's case. And for the fact that he did not see, he plowed that area and did not see a body lying in the yard. He was very clear about that, that he could see from the street to the front doorway with his lights that swept across the yard. He's familiar with it. There was a cover of snow. If there had been a body there, he would have noticed it because he's looking for things to that he doesn't damage and put his spoil that he's scraping off the roads on.
Yes.
So
May I approach this retrieval?
Yes.
pretty good witness, in my opinion.
Mr. Loughran, after having reviewed that, as your memory refreshed as to that conversation you had in May of 2023,
No, it does not.
so you still, after reading that, don't recall telling anybody in May of 2023 that you came in around 11:30 p.m., 12 a.m. on the 28th, 29th?
I never came in at 11:30, 12:30 at night. It was 2:30 calling.
You don't recall indicating to anyone in May of 2023 that you went past Fairview at 12 a.m. and 2 a.m.?
Correct, never did.
And you don't recall telling anyone that you saw the car around 1:30 or 2 a.m.? Is that correct?
Correct,
And you don't recall telling anybody that the part of Fairview containing 34 Fairview was blocked off at 3 or 3:30 a.m., correct?
correct.
Now, if the part of Fairview that you were talking about, so you didn't say that in May of 2023, because at 3 or 3:30, the roadway wasn't blocked off, correct?
Correct,
It was blocked off sometime around 6 a.m., correct?
correct.
And so if you had said that the roadway was blocked off at 3 or 3:30 in the morning, and it was actually 6, then when you saw the vehicle would have been off a little bit as well, correct?
Objection.
Sustained.
Seeing the car at 1:32 in the morning, with the road being blocked off at 3 or 3:30 in the morning, if the road's blocked off at 6 a.m., then that actually would have been, you saw a car sometime around 5 a.m., correct?
Objection.
Sustained.
Sure you didn't see a black Lexus SUV in front of the house at 34 Fairview Road around 5 a.m.?
No,
Now, you also were asked some questions and you spoke to some troopers in August of 2023, correct?
correct,
And County Canton, they have a parking ban in Canton, is that correct?
correct,
That goes from November until April.
correct.
Now, part of your plow route is a road called Tippy Cart, correct?
Correct.
Where is Tippy Cart in relation to Fairview?
It is on top of it's on the right side of Cedar Crest. It would put it 2 streets before Fairview.
And at some point, when you were plowing on Tippy Cart that night, you actually hit a basketball hoop, is that right?
Yes,
And did you call that in?
yes.
And as a result of that, what happened with the basketball hoop after that?
Nothing. The point was to make sure I was covered, basically. That's why I notified my supervisor that I hit the basketball hoop.
And about what time was that you hit the basketball hoop?
I don't recall.
Is it closer to when you started, closer to when you ended?
I don't recall. I don't recall what time.
So you don't recall anything specific about that time, correct?
No, just that I know I hit the basketball net.
And obviously, and I'm not trying to put words in your mouth or anything, sir, but you didn't intentionally hit the basketball hoop, correct?
Correct.
So you hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it, and the machine had a different size body than what it originally had, and I underestimated when I was going around that I need to be wider.
Oh, that
You
didn't go over
misjudged
well for
distance.
the
Is
state.
that fair to say?
Yes.
Trying to say you missed something. He's like, no, I saw it. I just misjudged the distance and I knocked it over. That's not the effect I think he was going for. That's pretty awesome.
May we approach, Your Honor?
Okay.
Well, Your Honor, I mean, I tried to make this guy look stupid because his IQ was not as smart as high as mine, and he's really kind of running me. So, can you give me some suggestions on how I can make him look dumb and not credible? I think this witness looks very credible. What do you guys think? Dante, you're not wrong. I think he was trying to get this guy flustered up and get him to change his story. He's like, well, if you put it in the report, I must have said it. But this guy's like, no, I didn't say that. Nope, not a problem. I think the guy's doing great. The amount of bad police logs so far, the injury are unlikely to believe the report. The jury are unlikely to believe the report over Lucky. I agree. I think Lucky's coming across this as maybe the most truthful witness the jury's heard this far. I think he's doing a great job. And I think Lolly looks like an ass by trying to make him look otherwise. That's right, Rob. He's not falling for it. He's just straight up. He's like, nah, didn't say that. The great part is that he tried to go to the basketball hoop. And I'll tell you why he was able to do that. Then go in the log and see that he had an incident that night because he reported it like he's supposed to. And he made it look like, well, you couldn't even see a basketball court. You expect to see something like a body laying. You was there. You didn't see it is what he's trying to say. And he's like, no, I saw it. I just misjudged it because, the Frankenstein body. I just fucked up. I just missed it. I misjudged it, but I saw the basket. It wasn't like it wasn't there. I knew it was there. Net got caught in the blade. That's how things go. So I thought that was very good. And I think that shook Lolly. I think Lolly is on his heels right now. I'm not sure what they're trying to bring up in the sidebar here with this witness, but definitely the state is shook by this guy they think is a simpleton who's actually a good, honest American there to tell the truth. So I like that.
If I could take a minute to remind everybody, please like and share, repost this out. Let's screw the algorithm. Let's get this thing out there. Let's do it on Twitter, Instagram, all those good ones. Make YouTube. Please make sure we're reposting this on YouTube. Everybody that's in the YouTube world.
Good point, Big Ron. I sure appreciate you. We got Rob. So plow drivers around here are a dime a dozen. Everyone has a plow, and half of them are drinkers and unreliable. Shame on you, Rob. Do your streets not get plowed?
You are unmuted.
Because they have a drink or two. So using that to paint an image that a man named Lucky is just that. You're 100% right, Rob. They're trying to make this guy look like a simpleton. In the end of the day, he's just a hardworking American, and he's telling you what he saw. He's not pushing to it. You're not going to put words in his mouth. I respect Lucky. I like Lucky. State looks like an ass.
Now, sir, at some point prior to coming in here and testifying today, have you met with Mr. Yannetti?
Yes,
How many times?
twice.
And when were those times?
Tuesday and Saturday.
Tuesday and Saturday. When, sir?
Tuesday of last week, Saturday of last week.
And this Paul person that you spoke of before, was that person present there as well?
Yes.
And did you make note of Paul writing anything down or Mr. Yannetti writing anything down while you were talking to them?
No.
And as far as you're aware, there's no reports that were generated from any of those conversations or any of those meetings. Is that correct?
Correct.
So, sir, I'm correct if I say that you're sure about every time that you went down Fairview Road and everything that you saw going down Fairview Road, but you're completely unaware of the time that you ran into and struck a basketball hoop that night. Is that correct?
Objection.
Sustained, you can ask it differently.
You're sure about all the times that you went down Fairview Road?
Yes.
And you have no idea what time that you went on Tippy Cart and you struck the basketball hoop. Is that right?
If you ask me to guess, I can guess for you.
I'm not asking you to guess, sir. I'm asking you to know.
I don't recall exactly what time I hit that net.
Nothing further.
All right, anything, Ms. Giannetti?
Briefly, there's just one question I wanted to make sure that we understand what's going on.
So no statements, right? Just ask a question.
I always do that. I apologize, Your
Okay.
Honor. You were asked a question by Mr. Lally. Are you sure you didn't see a black Lexus at around 5 a.m. in front of Fairview? And your answer was no. And my question to you is, does that mean that you're not sure if you saw one or that you didn't see one?
Objection.
I'll allow that.
I did not see a Lexus at 5 a.m.
At any point that night while you were plowing,
No,
you see a black Lexus in front of 34 Fairview?
no.
Thank you, sir.
Very briefly, based on your timeline, were you on Fairview Road at 5 a.m.?
Yes.
How so, sir?
It was about 3 hours after the last time I went on it. So it put me, I was last on it at about 3:45, about 5:30.
You were on the road about 2:45, and you said it took you about 45 minutes to sort of do the loop and come back, correct?
Correct.
And from the time that you were on there, including the time that it took you to plow and the time that it took you to do all of those things along the route, you're coming back to Fairview Road at 45 minutes later, or it took you 45 minutes to do the route?
It was about 45 minutes.
And so from there, 45 minutes, from what time are we talking that you were first there? Said about 2:45 or so?
About 3:30. With
About 3:30, okay.
Yeah.
So about 3 hours after that would then be about 6:30, correct?
It was about, I mean, I know I went up there and saw the first responders coming down. And when
What I'm asking is, you would testify that you may or you were on Fairview Road around 5 a.m. If you're not returning for 3 hours later, and that's about 6:30 from 3:30, correct?
Correct.
So then you were not on Fairview Road at 5 a.m., correct?
I was. The time that it took me to do what I needed to do put me there about 5. So when I'm coming down Cedar Crest from doing my route, I am constantly looking at Fairview to make sure that it's considered a main road. So we need to take that as a priority. So if it's a lot of snow on that road, I am going to go turn around and do the road so that the road is available. So first responders have access to that road.
So what I'm saying is you testified, your timeline, that you came down there around 6:30 in the morning, correct?
My timeline was 5:30.
At 3 hours
5:30?
after 3:30.
It was 45 minutes.
No, 45 minutes was from 2:45 to get you to 3:30. Then 3 hours later, it's 6:30,
It was
correct?
It was about 45 minutes because I didn't get a lot of time. At that time, the snow was coming down at a significant rate, and I needed to make sure Fairview was kept clear. So I come down and I check. So I have the streets are all around Fairview. They're 5-10 minutes around Fairview. So the furthest street from Fairview is Kings Road.
So my question is, are you talking about coming down Fairview, or are you talking about being on another road and looking at Fairview?
Coming down Cedar Crest, looking at Fairview.
Despite that timeline that you gave her?
I am always looking at that street.
Nothing.
All right, Mr. Lochran, you are all set.
Yeah,
sir.
go ahead and beat this guy up. Just makes the jury think that you're an asshole and doesn't want to give you anything, including this entire case.
Okay.
Rob says he has a Lucky in Peabody, Maine that I use. His name is Dan. Dan must be a good guy. You could have a beer with Dan. You know what? You could trust Dan. I think Dan's a trustworthy guy. I think Lucky's a trustworthy guy. I like him. Dante says there was aspersions cast on Lucky's eyesight in the media. I knew Lally would try it. Glad it flopped. I think everything Lolly did flopped with this guy. He tried to make him look like a bumbling fool, a simpleton, and Lucky didn't fall for it. He twisted him up a little bit in the end on trying to do some math on the fly, but it just made the state look like an ass, I think. Rob says again, but having a municipal contract in terms of plowing comes with numerous responsibilities and standards as well, as these drivers are held to a higher standard. I agree. I think he's a city worker, Rob. They did have some contract plowers, and they made a claim that this guy, Lucky, who's a city worker, had made a comment to one of the contract plowers, who oddly enough has some weird ties back to the Albert family, that a different timeline that Lolly tried to float out there, but it got smacked down, looking like a fool. Most plow drivers don't report hitting a hoop from his experience, and he does say the same thing. I think it's a sign of true honesty. Oh, we got Grandma. We got Dog Lady, folks. Dog Lady's about to testify. This is going to be exciting. Grandma's going to talk about dog bites. Let's see if she goes over well.
I do.
I wasn't sure if they were going to allow her to testify after the
Yep, she can testify. She can testify about dog bites, but she can't talk about law enforcement procedures or medical ER procedures, because it's been like, my lifetime since she's done any of that.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi, Dr. Marie Russell, Russell.
Doctor, what do you do for a living?
I'm an emergency room forensic pathologist, just recently retired.
And prior to retirement, what was your position?
The immediate position before retirement was chief medical executive at for the state of California at the Corcoran State Prison.
So, Dr. Russell, I'm going to ask you to keep your voice up, okay?
Yes. Okay.
Thank
Because
you.
Grandma, I'm not turning the air conditioner off. It's freaking hot in here.
Your voice as loud as possible. What is, in fact, an emergency physician?
An emergency physician is a medical specialist who has completed a residency, internship residency in the field of emergency medicine, which is a field which involves taking care of patients that are sick or injured and go to the emergency room.
Can you tell us what your education, starting with your education, training, and background is that qualifies you as an emergency physician, starting with your education all the way back to college?
Okay. Well, I have completed at least 16 years of formal education beyond high school, which includes college, and then 4 years of medical school, then 4 years of emergency medicine residency and internship, and then 4 years of pathology residency, which includes 2 years of anatomic and 2 years of forensic pathology. And then I treated, I've taken a bunch of other courses and attended seminars.
Let's start with your college. Where'd you go to college? Where'd you start?
Okay. MIT. I did my first year at MIT, where I took my pre-med courses.
And then what happened after that? By the way, about what year was that?
Oh, that was in 1972 to 73.
Where did you go after MIT?
So what happened? I was interested in becoming a doctor, and so I took the pre-med courses, and then subsequent to that first year, I learned that my mother had metastatic breast cancer. And so I decided to go home to New York to be with her. After that, she subsequently passed away. And I returned to Massachusetts and decided to take advantage of the time off from school to investigate my interest in law enforcement. And I subsequently became a police officer here in Massachusetts.
So following MIT, did you go to a police academy?
I did.
Which police academy did you go to?
I went to the Boston Police Academy.
And did you end up becoming a sworn officer?
Yes,
For how long?
I did it for 7 years full time.
And what department did you work for?
I worked for the City of Malden Police Department.
What years was that, if you could give me a range?
From 1977 to 1984.
During the time that you were a Malden police officer, did you also go to school and continue your formal education?
I did.
Describe that for us, please.
Well, I took specialized courses through the Massachusetts Criminal Justice Training Council.
Objection, move to strike.
All right, so I'm going to strike that. Jurors, disregard that.
Let me ask you this way. I don't want to get into the specifics.
Okay.
While you were a police officer, did you also take formal education to further your medical training or your college?
Yes, I did.
That's what I'm interested in.
Okay.
Tell us about that.
Oh, yeah. So I attended Northeastern University part-time and received a Bachelor of Science degree in psychology.
After you got your degree in psychology from Northeastern, did you go on to continue your education in medicine?
I did. I attended medical school at the University of Massachusetts Medical School from 1983 to 1987.
Also known as UMass?
Yes,
Did you ultimately end up with a medical degree?
did. Doctor,
After you became a doctor, did you engage in a residency?
yes.
What years were the residency, that first residency?
So the first residency was from 1987 to 1991, and that was in Los Angeles at the Los Angeles County University of Southern California Medical Center.
Is that also known as LAUSC?
It was at the time, yes.
And that's associated with the University of Southern California Medical Center, is that right?
Yes.
After your first residency, by the way, what was your first residency in? What was the subspecialty?
So it was in emergency medicine, and USC is a very large trauma center.
How would you describe the size and volume of the USC Trauma Center?
Well, it's one of the busiest in the United States.
After your first residency in emergency medicine, did you?
You know,
do a
I hear
second
that from
residency?
most hospitals. It's
Yes.
always most
What was
something in the United
subspecialty in that
States.
second residency?
Which
So I
which
did
way I get that.
2 years in anatomic pathology and 2 years as a fellow in forensic pathology at the Los Angeles County Coroner's Office.
So you did 2 full residencies after you became a doctor, is that right?
That is correct.
What's the difference? I don't want to go into great detail, but what's the difference between an emergency physician and, for instance, the residency that you did in pathology, both anatomic pathology and forensic pathology? What are the differences?
Well, generally, the emergency physician treats live patients, and the spectrum of injuries can be wide, or illnesses can be wide, and the forensic pathologist treats or deals with deceased patients generally.
Did you become a fellow at the LA Coroner's Office following your second residency?
No, that was part of the second residency.
Understood. Describe that fellowship.
So that was 2 years of full-time work at the LA Coroner's Office under the supervision of very experienced medical examiners. And what I did was I did autopsies, every day, 1 or 2 autopsies every day, attended conferences, and read journal articles, etc. It was a very formalized education.
Did you also become, at some point, a professor or an assistant professor at LAUSC, the medical center side, the university side?
Yes. So while I was doing the forensic pathology and anatomic pathology residencies during the daytime, I worked as a full-time ER doc supervisor in the capacity of an assistant professor in the evenings.
They need to be careful running
And-
down this road. They're going to bore the jury to death with her
Los Angeles, California.
75 years of
Yes.
I work here and I work there.
Yes.
And you had separate responsibility as a professor in that.
And folks, we have Kingdom
Yes.
tapping in on the chat line with a
medicine and
rut
forensic
row. You
medicine
should be
in
pretty
that
excited about hearing
That is correct.
dog
It
testimony.
was a master's level program.
Him and John say that dog is the
How long
linchpin,
were
the
you
key
an ER physician
to this whole case.
total and an attending physician for Los Angeles County
Don't be hating on Dr.
USC
Russell.
Medical Center?
29
I'm not
years in
hating.
total.
I just hope the jury's awake when she
4 of
starts
those
talking about
were
the dog
in
bite.
training, and the rest were as supervisor.
Of
And
your 29 years, 25 of your 29 years, you were supervising others,
correct.
meaning other doctors,
Other doctors, yes.
teaching other doctors,
Yes.
and teaching medical students.
Yes, and seeing their cases. Once they examined the patient, they would present their case or tell me about the case, and then I would go in and see those patients in addition to my patients.
That was my next question, doctor. In addition to teaching, were you also specifically assessing, diagnosing, and treating patients of your own?
Yes, not all the time. Some shifts I didn't have to do that, but much of the time, yes.
For the bulk of the 29 years that you were an ER doc, an emergency physician, in other words, were you also attending to patients as well?
Yes.
Once you left that fellowship with the LA Coroner's Office, did you remain active in any way or connected to the Los Angeles Coroner's Office?
Yes, so I would attend their weekly conferences when I could, when I was available and to do so. And I also
We're literally talking about
consulted on
conferences
some
she's
cases
attended. We're
with
going to talk
them.
about
So if they
maybe
had
the best dinner
something-
she had as well. Come on. Uh-oh, what's happening here?
Patience, young one, patience.
I'm having the same internet issue I had yesterday.
Director of the USC Center for Life Support Training. So, that involved teaching other doctors life support courses such as advanced cardiac life support.
And
or
John,
they
I
would
have
teach the
patience. I'm
surgeons
saying
advanced
the jury
trauma
will
life
glaze
support.
over and they're going to miss the important
Uh,
part that she's
I'm
here to
sorry.
talk about.
Go
If you go
ahead.
into much
Were you also a director
65
for
years of
their
every job
quality
she ever held.
improvement, in the early 2000s?
Yes, for the emergency medicine department.
What was the reason for the quality improvement program, if you will, for LAUSC?
Well, for any
And here's the thing.
program,
I'm going to
it's
talk
ideal
over.
to have a quality improvement component. Because
Remember, the
what you wanna
judge
do
narrowed the
is
scope of what
look
she
at,
can testify to is just
cases that were
the
treated
dog
and see
bite
if there were
issues.
any
But we went
errors.
into a lot of
And if
emergency
so,
medicine stuff
correct
from
the errors, teach the doctors
Alan
that
Jackson.
involved. What
Alan
went
Jackson may
wrong,
try to sneak in
and
some
try
medical
to make
or some emergency
systemic
room procedure stuff
improvements
because he's
or
got some issues with the way that
teaching improvements to prevent those errors
some
from
of that was
occurring in the
handled.
future.
But I think he'll get his hands slapped if he tries to do that. But I think that's why he's laying down so much foundation on her medical training and
Yes, we
ER
tried.
doctor
And you were the
experience.
director of that program, correct?
Yes,
Did you also become the director of LAUSC Jail Medical Services?
yes.
What is the connection or the tether between the jail system in Los Angeles and LAUSC Medical Center?
Well, LAC jail ward was
I will tell
established
you,
about
you're smartest
70
and
years
brightest
ago,
aren't
and it was a
working in the
place
jail
that
system providing
the
medical care to
officers
inmates.
from various
I'll throw that out
agencies
there.
such as LA Sheriffs, LAPD, California Highway Patrol, or any of the municipalities around could bring people that they arrested who were in need of medical care.
So I did
the
read on
jail
her
system, very large
that
jail
she
system, I'm
helped
guessing,
publish a
in
magazine
Los Angeles, correct?
about
Correct, yes.
There have to be
regular
medical
role
attendants
canine
to that
bites,
jail
but also
system, correct?
that
And
happened
you
within.
became the director of the jail medical
Wonder if that's
services for
where
the
he's going
entirety
with
of that system?
For the hospital component of it.
Understood. The
John, you remember banning real bad.
California,
Try to say that again.
You're obviously licensed in California.
Yes.
There is a state
All right,
medical
hopefully
board
that's
in
better.
California, correct?
So
Yes.
And did you ever do any work with that state medical board?
Yes, I worked with them for about 7 years part-time.
I've lost y'all together,
as
my
a
friend.
regular employee embedded in their enforcement unit. And what that involved was examining cases that were referred to the medical board because of substandard care or illegal activities of the practitioners, providers. It was for physicians and physician assistants that we regulated.
What was your title with the state medical board for those purposes?
The title was medical consultant. That was the official title.
Okay. And then before your retirement, by the way, what years were you the medical consultant for, or a medical consultant for the state board in California?
What year? I think from 2009 to 2016. I think those were the years. I'm not positive. I did that. That was a job I was doing. One, I was doing the LA County USC Medical Center job too. It was an extra job.
So you didn't stop working as a physician, an ER, an emergency physician at LAUSC to take that position?
No,
You just consulted with them.
I did it once a week, 1 day a week.
Got it. And then with regard to the one of your last positions that you held, did you become the chief medical executive for the California State Prison, Corcoran?
Yes.
Tell me about that position and the years that you held that position.
So that was from 2018 to 2023. And as the chief medical executive, I was the supervisor of all the doctors and nurse practitioners that provided care to the inmates.
And obviously the California prison system is a very large prison system.
Very.
Doctor, are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes, I'm actually fellow status, which is higher than member.
Are you a member of the American Academy of Forensic Science?
Yes, again, I'm a fellow there.
Which also is an advancement above just being a member?
Correct.
Have you ever published in the area, and now I'm going to get very specific, have you ever published peer-reviewed articles and done research in the area of animal bites and scratches?
Yes.
Did you author or co-author a peer-reviewed article named Managing Law Enforcement Dog Bites in the ER?
Yes.
About what year was that?
It was in the 1990s.
Late 1990s, 1996, does that
Yes.
sound right? Did you also author or co-author an article called Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes.
So given those articles, did you study specifically dog bites, dog wounds on the human body?
Yes, I have a very strong interest in wounds in general, and I have a strong interest in dog bites in particular.
During the course of your career, your professional experience, how many patients would you say you've seen or treated with animal injuries, including bites and scratches?
It's very hard to estimate, but between my own practice and the residents that I supervised, it was, I'm sure, well over 500, and could possibly be double that.
Could be up as many as 1,000.
It could be, yes.
Have you qualified as an expert in emergency medicine in the past?
Yes.
You qualified as an expert in the area of forensic pathology and wounds in the past?
Yes.
Is that both in federal and state courts?
Yes.
Doctor, were you asked to review certain materials related to this case in furtherance of coming to some opinions and conclusions about injuries suffered by John O'Keefe specific to his right arm?
Yes.
What did you review in coming to your opinions and conclusions?
Well, I reviewed hospital records and pictures taken of him in the hospital, when he was in the hospital. I reviewed autopsy records, the autopsy report, and photographs taken during and before the autopsy. I reviewed, let's see, I reviewed reviewed the grand jury testimony of the autopsy pathologist. I reviewed affidavit of Dr. Sheridan. I reviewed the town of Canton dog bite reports about regarding incidents.
Section, may we approach?
Yes.
I don't think she's going to come off as a very great witness, in my opinion. And she may have some great information to share about dog bites, but in my opinion, they need to get to that pretty quick. You do 45 minutes of grandma talking about, I remember this and I remember that and all this other mess. I think that I think she's a nothing burger, not the witness that we wanted to see on the dogs. And Lisa said she scooted out. What did you miss? You missed grandma talking about back in the day in 1963. I was a waitress at a coffee house, and then we've gone from there. I think we're in 1996 now or something, maybe. Not the greatest. Are they taking their lunch break? Everybody stood up like the judge or the jury's going out. Probably the jury, unless they're going to stop and have some sort of another voir dire here about Granny's testimony. Oh, here we go to the fan. All right. Yep, looks like we're fan audio cut off. I'm assuming we're at the lunch hour. Let's run a little promo. Today is a range-minded podcast. Back to Vordar. Let's see. Let's go to some comments first. Rob says we could tell the other day she would be the weakest witness. I agree, Rob. There was some other in my crowd on this side thinking that she was going to be the strongest. And I'm not saying she's not smart. I'm not saying what she does bring to the table doesn't have much merit. I just don't think she comes across well as a witness on the stand. And Lisa says back to Vordar or Wardeer, as y'all say. I don't think so. It's time. We didn't get the audio on the sidebar. It just went to stand up, which tells me that the jury was leaving. And now we're to the fan. I think we're on our lunch break, Lisa. There could be some voir dire after this, but I don't know. I don't know what the sidebar was about, other than maybe Lolly said that she's more boring than I am. We're gonna have to speed this up because I'm falling asleep. And Rudy says that she can't string together thoughts in a way that keeps the jury watched or engaged. Rob, I like you. If you're not following me, you should. You and I think exactly alike. She's gonna make your eyes glaze over and tip off in a nod in about 5 minutes. And the jury, I hope the jury didn't have a large, heavy lunch because that's not going to be good. Lisa, but she's here to testify. This is her moment. She's been certified as an expert, and Granny is on the stand to talk about dog bites. She just hadn't gotten to dog bites yet. We're maybe into a dog bite paper that she wrote in 1996. Again, 1996. She attended MIT in like 1971, 72. So keeping granted, we've chronologically climbed that ladder, and we're at about 1996. I'm hoping we'll get to 2022 or 2024 when she saw the records and get to this dog bite stuff pretty quick. But the defense is still laying foundation. And folks, don't let me beat her up too much. The defense does have to lay down foundation. You want the jury to hear the credentials of your expert witnesses. That if I've had all this schooling, I've had all this training, I'm so good and I'm so knowledgeable. So when I tell you something, you should listen to it and give me some credit. That's what Alan Jackson's trying to lay down. My fear is that I think he might have lost people somewhere about L.A. County Jail as a doc. I'm not sure. She's kind of all over the place, and she doesn't testify well, in my opinion. Lisa, you did step out. Absolutely. Commonwealth has rested. The first witness was Lucky, the snowplow driver, who was very adamant about there was no body laying on that side of that road when he went through there, that he's got the Franken truck, and the Franken truck has got side alley lights on it that gives him almost a 180 degree or 90 degree light field on the side of his truck, and that he's very familiar with the Albert House. He knows the flagpole, seen it many times, plowed the road many times. In fact, that there was cars parked on the side of the road there. I think sometime 2:30. I don't remember the timeline. Sometime in the morning, there was that Ford Edge that was parked in front of the flagpole that normally they would have plowed right around it because there's an ordinance or no park ordinance that's through there during snow times. But he said, out of a courtesy to the Albert family, I just kind of went around it and was going to come back later and plow that street. So Lucky was the defense's first witness. I think Lucky was a solid hit, solid base hit for the defense. I think he come across very well, and I think he's truthful. I don't, he's not there to play any games. He's there to tell you what, from his point of view, what it is that he saw. So yes, the state has rested. We are into the defense. This is the second witness of the defense, which is Granny Dog Bite Granny, and it's going slow. It's going slow. Lisa says, well, the defense started out with a great first witness. This is actually the second witness. I thought their first witness was pretty good. And it also was an opportunity for the state to look like an ass by trying to push around a guy. And I think in their mind, oh, he's a snowplow driver. He's beneath us because we're educated. And they look like asses. They tried to catch him on because that same night he reported damage to a basketball goal. I think this was too close to the side of the roadway, and that his equipment caught the net as he went by. But he did, as he's supposed to, he reported the damage to the net to his dispatcher, and that's logged in. Lolly knew that, so Lolly brings that up on the stand. But basically, well, you didn't see the basketball net, so you hit that. You hit that because you didn't see it, because Lolly's smarter than everybody else. But Lucky put it back to him. It was like, oh no, I saw it. I just misjudged the distance, and my blade got caught in the net as it went by. No big deal. I reported it, and that's the way it goes. But I thought Lucky was a good witness. I've heard a lot about Lucky from Kingdom, and I'll back Kingdom up. Lucky was a good witness. And we've got John Cox back. Let's see if we've got some audio from our man here. And Rob says, I'd love to follow all of you. I watched the stream, and it's the only stream for case updates daily. I already follow Kingdom Radio. Just let me know who else to follow. Well, you need to follow John Cox, Joe Lanou, and Big Ron. Lisa's a good follow on X as well. And also, Rob, you should attend our night courts. We have a night court show that we do with myself, John Cox, Big Ron, who's a co-host here as well, and we have a few other co-hosts. We take on different topics. Tonight, we're going to do a police use of force video review. We actually do that every Friday. It's a stream instead of a Spaces show. We'll stream again tonight. A 2-hour show where we go over police use of force videos with a panel of law enforcement, attorneys, and civilians, and we give our opinions on kind of like a grand jury, whether we would bill or indict on the actions of the police officer on the uses of force. But we do that every Friday night. It's one of our better shows each week. You should catch that. And you can follow me on X as actually, let me pull it down and you can see it here. I think I can show you all of them here on the screen. Give me a second. Figure out which mode to go. Got all these banners up. Let me move. That's actually in the way. Let me move that one.
Am I rubber banding now, Joe?
Nope, you're better. But Rob, that's me on X. It's Joe_Lanou, LNU. Give me a follow and shoot me a DM, and I'll hook you up with all the rest of our co-hosts because we've got a few of those that are good follows as well. And I'll also get you hooked up with Lisa. Lisa, don't tell anybody, but she's typically on our panel for attorneys on the police use of force. But, great show tonight. I can't, if all the shows, if it's your first night court show, tonight's the one to catch. It is a stream only. We'll do the stream so everyone can see the police videos. We have the panel that's in the studio with us, but we also take questions just like we're doing on this court on covering this trial at the moment. So we want everybody's input. I just don't want the panel's input on these police review videos. I want everyone's input on it because that's what makes the conversation interesting. So No, absolutely. And then I'm gonna put you up, Johnny Cochran. See, I can get that done. Let's go with 2 of those. Oh, John, you just have John C on there. You don't have to follow me on X or even what. He is 2A Talk and Tactical. Rob, if you can remember that, maybe John will do a solid and add that to his tag here on the stream so everybody can see what that is. He's a good follow. John also runs a YouTube channel. And on that YouTube channel, he does a lot of 2A talk and talks about some of the legal issues going on and a lot of law enforcement. John's also a former law enforcement officer, as I am. But actually, I started this little lunch break. Today is the Range Minded Podcast Day. We're pushing Range Minded Podcast. This guy puts in a ton of effort. Has been doing this for a few years. Very quality content that you'll see from our friend Range Minded. You can catch the Range Minded Podcast on any place that has podcasts. That's literally in the world. If they say I've got podcast on this site or this link, you click it and do a search for Range Minded. You're gonna find him. He just dropped a video last night. It's about 50 minutes long. He takes a deep dive into what's going on, this phenomena going on in the last 4 or 5 years of larger agencies not reporting certain crimes to the UCR, the Uniform Crime Reporting system, to the FBI, that tells us what crime is across the nation. That's where they get that information. That information is the agencies voluntarily report it. But he digs into why who's not doing it and why they're not doing it. And I'll be honest with you, it's just damn shady. It's just damn shady that we have that a law enforcement agency would withhold information just so they can influence the public opinion on what crime is. In my opinion, that's dirty. But let's take a quick promo. And for those you don't know, the Range Minded Podcast, this is what you get. This award-winning, beautiful face.
We live in a world full of experts, where politicians use fear to generate power for themselves.
We've already had over 290 mass shootings this year. That's more mass shootings than days in the year.
Where our media feeds us with misinformation.
And according to the CDC, the #1 cause of death for children ages 1 to 19 in this country is gun-related violence.
Tropes.
Where it will literally tear out the inside of the body.
Where those who make the rules seem to know the very least. Scary terms used.
Arm known as a ghost gun because it skirts most federal gun laws.
Don't be like this guy. Listen to the Range Minded Podcast and free your mind.
There you go, folks. That's the Range Minded Podcast. He's known for his gorgeous good looks, but he's actually very informative. He is a 2A advocate, obviously, but just a common sense American that loves freedom, and his content reflects that. Absolutely give him a follow on YouTube, a subscribe on YouTube. But he's on Spotify. I listen to him on Spotify. But he's literally on anything that you've got. You also find him on X. And Rob, I've got your DM. I'll get you a list over of some good follows. I think that you would like my night crew folks. John's got his tag in there for X, which is 2A Talk and Tactical. If you want to type that in, if not, I'll send it to you, and I'll also shoot you Lisa's as well. She's a good follow. But we would like to invite you again to catch our show tonight. I think you'll like it. You'll have the full crew. The full cast, everybody comes out on Fridays. It's one of our bigger shows each week. And also, if you didn't catch our show last night with Tickle Talk, our friend who's a South African immigrant, naturalized American citizen who lives in the great state of Texas, was on our show last night. Super informative show, probably one of the better ones we've done in a long time, as far as just digging into some facts and some history about what's going on in South Africa. How it got to be the way it is, and some of the history behind it, which was pretty eye opening, I think, for everyone there. I've gotten a lot of good feedback on that show. It's on my timeline. You'll be able to go back and take a listen to it. It's just about 2 hours. We went over about 6 minutes on that one, I think, last night. Sometimes it's hard not to do, but it's absolutely a good listen, very informative, and Tickle Talk. It's literally at Tickle Talk on X is a great follow. Oh, we've got audio back in the courtroom, folks. We might be coming back to something. Going to you now. Curious, are we going to go to voir dire or are we going to go back to testimony? It seems like a quick lunch.
Good after this, I'll report back in session. Please be seated.
So the Commonwealth's objection is overruled. You can continue.
All right, there we go.
You've listed several items that you've reviewed in coming to your opinions and conclusions. Did you also review a toxicological report?
Yes.
And a neurology report, neuropathology report?
Yes.
As well from the Commonwealth?
Yes.
That at TPCLJ is on X, folks. If you're not following Lisa out there in the stratosphere of X, you should be. Super informative, great follow, very active. One of my best.
Concerning the injuries specifically to John O'Keefe's arm?
Yes.
Or his right arm? Were there any documents in furtherance of your review from UC Davis?
Yes.
Did you review those as well?
Objection.
Sustained.
With the court's permission, may we display Exhibit 19, please?
Okay.
Doctor, I want to show you a photograph and ask you very quickly, have you seen this before?
Yes.
Is this one of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you base that opinion?
Yes. Well, may I use the?
Sure.
Okay, thank you. There's a number of patterns here. There up on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks. Again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow, And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds. So if someone were to protect themselves.
Objection.
So sustain. Next question.
Sure. Doctor, if I can ask another question. Just to clear up what you said a little earlier about some of the wounds close to the elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
Okay, so in other words, instead of the mouth going all the way around the arm, it could have, the top and bottom jaw could have situated itself on this portion that we're seeing, the posterior part of the arm?
Yes. And in this case, the animal did not get a good enough contact.
Objection. Move to strike.
So I'm going to strike that, ask a different question.
Have you seen contact wounds where the animal, a dog, for instance, gets a very solid purchase on the leg, arm, part of the body?
Yes.
Okay, is that this or is this something else?
Something else.
Describe that.
Well, when an animal inflicts injuries, the type of injury depends in part on the actual type of contact and how much force is applied by that animal, in addition to any relative movement between the animal and the victim in this case. So, for instance, in the law enforcement dog bites, many of...
Objection.
Right. So the nature, is it notice? Is it, what's one word?
May we approach?
Okay.
All right, John, what do you think the objection's all about?
I mean, he's not, Jackson's not asking her, but she's like going into her answer, which I can see him letting her do that. But I also see where the prosecution is having an objection, even though she's she's a professional at this, identifying things, she's like giving more information than what she's actually being asked for. So maybe he's objecting to that. Just stick to the.
I think he's objecting to. Remember, Chloe was a German Shepherd that belonged to a police officer, i.e., so that's what for a lot of people.
Yeah.
A police dog, and he wasn't. Chloe wasn't a police dog, but it was a German Shepherd that belonged to a police officer. And when she talks about certain wounds, she'll say this thing, but then she said when police dogs do it, and I think that's where the objection is, that they're laying a foundation that not only was this a dog bite, but it was more likely a German Shepherd or police, like they say, AR-15s or assault rifles. German Shepherds are police dogs. Not every German Shepherd's a police dog. They do use the breed, but
you are
I think that's his objection.
Yeah, I'll see what you're saying.
May I, Your Honor? Yes. Thank you. Without getting into any specifics about police canines,
okay,
does this appear as a
Damn,
pattern
I should have a law
that
degree.
you see appear consistent with an animal or
I think
large
you should
dog?
go up against
Yes.
Lawyer Joe.
Does the number
Well, I do.
of
Then Lawyer
injuries
Joe
that
just
you
agrees
see
with me,
here
so it's not really that much fun.
relegated to just the right arm, is that also consistent with an animal or large dog?
yes, it can be.
Is the direction of the injuries or the consistency of the direction of the injuries, the parallel injuries, is that also consistent with an animal or large dog attack?
Yes.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog.
Yes.
Have a moment, Your Honor.
Yes.
That's all I have at this time, Your Honor.
Yeah.
Okay.
Oh, wow.
May we approach?
Okay.
You know, I agree with Rob. She can't get the words out coherently without adding extra info, and that is objectionable. But the objection was because I noticed what she was doing. When they're talking about specific wounds, she would insert that in this particular case, or she would compare it to a police dog. And remember, Chloe was a German Shepherd that belonged to a police officer. I've heard in the news media that it was a air quotes police dog. Although German Shepherds are used as police service animals, not all German Shepherds are police animals. A German Shepherd born is not a bite dog for the cops. There's a lot of training and a lot
You
of
are
dogs don't make
unmuted.
it. And I'm just going to put that up with there. My friend James says, "Yep, that was it." I take accolades and tips,
Hey, John.
folks. I'll be here all day.
Good afternoon, ma'am.
Good afternoon, sir.
Now, testified that you're certified in emergency medicine, is that correct?
That is correct.
And you're not, nor were you ever certified in forensic medicine, is that correct?
That is correct.
Pathology.
Correct.
And when was the last time that you worked at a coroner's office?
John, I've got to step away for a minute. It goes to
1995
something,
in terms of doing
get
autopsies.
some comments, please.
Okay.
Now, when was it that you first spoke to anyone from defense counsel in regard to your coming in here and testifying today?
May 17th.
Doctor, I am going to ask you to keep your voice up.
Oh, sorry.
Thank you.
May 17th, 2024.
May 17th of this year, is that right?
2024.
So about 6 weeks after this trial began?
I don't know when the trial began.
Now, as far as who reached out to who?
I reached out to a district attorney that I worked with with the LA coroner's office.
And then somehow that person put you in touch with Mr. Jackson, is that right?
Yes.
And was that also on May 17th?
17th and 18th, yes.
So I'm sorry, 17th or the 18th? Which one was it that you spoke with Mr. Jackson?
I didn't speak to him.
You did not speak to him?
Not speaking, not verbal. There was some email communication or text communication.
You communicated with him. Was that
Yes.
on the 17th or the 18th?
Yes, both, I think.
Both. Okay. And when did you render this opinion as far as what you've testified to here today?
Shortly after he sent me the files.
Now, in regard to those files, you testified in this court a couple days ago, correct?
I did.
And you were under oath at that point, is that correct?
Excuse me?
You were under oath at that point, is that correct?
Yes.
Okay. And when you were asked specifically what materials that you had reviewed, you included a number of items, but you did not include anything about a Dr. Sheridan affidavit, anything about a UC Davis report, or anything about any sort of bite history for a canine that lived or resided at 34 Fairview Road, correct?
That's correct because I hadn't reviewed them then.
And so since then, 2 days ago, now you've reviewed them, correct?
Yes, I became aware that those files existed. Yes.
You became aware of those files. Were they not sent to you previously?
No, I think there were technical difficulties regarding me and the computer and downloading from Dropbox. And so, yeah, so they were, I think they were sent to me, but I think I didn't open them.
Now, with reference to these technical difficulties, did you ever express any of those technical difficulties or, hey, I can't see the whole file, or there's other things in here that are listed that I can't look at?
No, I wasn't aware.
And so with regard to, as far as your reaching out or contact in regard to this case, how did that come about?
Okay. I saw an article, I believe it was in the Boston Globe regarding this case. And I didn't, initially I didn't think anything of it. Then I saw an article that indicated that there was some.
I'm not asking you anything about anything any article indicated. You saw an article in the Boston Globe about
Yes.
this case, is that right?
Yes,
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time. Yes,
Did at the time. What time was this?
in May.
May of 2024?
Yes,
And how long had you had a subscription to the Boston Globe at the time that you saw this?
it was either a 6-month subscription or a year. I don't remember.
And that was the first time that you had seen anything about that?
First time I paid attention to anything like that, yes.
Now, again, you had testified here just a couple of days ago when I asked you questions about this. Is that right?
Yes.
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months. You
No.
remember, not 6 months a year.
So only one person can talk at a time. So was that your testimony, doctor?
No, I don't believe so. I believe that I said it was a 6 month subscription or a 12 month subscription.
But in any event, you saw something. That's the first time that you recall seeing anything in the media about this?
And for the record, that is exactly what she said.
It was the first time that I recall reading anything about it. Correct.
Now, did you write a report in regard to your opinions that you've testified here today?
No.
And I asked you that a couple days ago as well.
Yes.
Okay, so in the last couple of days, you've had time to review a UC Davis report, Dr. Sheridan's affidavit, and any sort of dog bite history, but you haven't had a chance to write a report?
Objection.
Sustained to that form.
You haven't written a report, correct?
That's correct.
Why not?
I haven't been asked to write a report, sir.
Now, did you ever look at anything related to Mr. O'Keefe's head injury?
I looked at.
Objection.
Sustained.
You want to make an appropriate briefing?
Yes.
Can't help but wonder if they're objecting to what she testified to the other day doing the Bordar. But she did say 6 to 12 months was her subscription. She could not remember.
All right, John, I'm back. I was kind of watching that while I was doing my things on my phone. I think the objection is by the defense. Now, remember, the judge narrowed her scope just to the dog bite testimony. But the prosecution is now getting asking about head wounds. But that's a benefit for the defense. And that's why he wanted to go sidebar. It's like, cool, let's talk about it. Then I'm going to bring in her medical examiner experience, and we're going to give her testimony as to what she thinks caused these injuries. So let's see what happened.
Yeah, I do remember Judge Bev saying the other day that if they got to that point, then they could meet at sidebar and discuss it.
And they did, and Dante nailed it right on the head. He is asking about stuff he wanted her limited on. So, but the thing is, in a term for it is opening the door. If he opens the door, and he did, although they didn't let her answer, that would lets the defense come back on redirect, and dig right in and walk right through that door and start talking for the next
Testified that you had
6
some
hours about head wound
familiarity
injuries with her.
Areas of forensic science, you're on some boards, things of that nature. Is that correct?
Yes.
And as a result of that, or any other work experience, are you familiar with a NAS report from 2008?
Not with that limited information, no.
You're not aware of a report issued by the National Association of Forensic Science in 2008, which specifically has a section dealing with.
So I'm going to see you both at sidebar again.
And here we go. Now, I'm curious if the state wants to open that door. Maybe they see something in her past or background that they can exploit and folks understand what's happening here. The state is going to try to discredit her in the eyes of the jury. That yeah, she said this, but it's not somebody you can really rely on. That's why he brings up the Boston Globe. That's why the subscription is so important. These expert witnesses, this lady on the stand, I promise you, she's going to clear about $20,000 for sitting up there talking about what she's talking about, and that's going to come out of that lady right there's pocket. But there's an incentive for expert witnesses who are not material witnesses to a crime be certified and sit on and give their expert opinion in a trial, and it's monetary. It's very lucrative business if you get good work if you can get it, so to speak.
So, ma'am, you're not familiar with that report specifically as it applies to forensic odontology?
So could you say that again, Mr. Lally? What's the report?
The National Academy of Sciences 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report, no.
So then you equally unfamiliar with the representation that is not from the NAS report, that is not a reliable science as far as bite marks are concerned.
There are certain aspects of bite marks that have been deemed not reliable. And that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of, that recommendation.
You're not aware of any findings in the NAS report that has led to questioning of the value and scientific objectivity of such evidence?
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking, again, this is a report. Are you familiar with it or are you not familiar?
I'm familiar with a summary or a abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
And so you're not familiar with it also talking about sample data and collection, analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NAS report as well?
But what specifically, do you have a specific question about that, or?
My first question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
From the report.
Mr. Lally, let the witness answer one question at a time, one speaker at a time. Doctor, can you answer that question?
Sure. I did not read that report.
Okay. Now, you had written some articles that you were asked about in reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about law enforcement dogs and a bite and a hold technique, correct?
Yes.
Now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds, is that right?
They can, yes.
Severe crush injuries, is that right?
Correct.
Large tissue avulsions and lacerations, is that right?
Yes.
Wounds necessitating surgical debridement, is that right?
Yes.
Bony injuries ranging from cortical violations to displaced fractures, is that right?
Yes.
Neurovascular damage, is that right?
Yes.
And other wounds at high risk for infection, correct?
Correct. But we also put a disclaimer in that article.
I'm not asking you about any disclaimer.
Okay.
I'm asking you about that's what the type of injuries that you were looking at, is that correct?
Yes, but we saw a skewed population.
You skewed
Yeah, I don't
population
like
in the
what she's
study,
doing
is that
there.
correct?
Just answer the question.
What we saw the worst of the worst.
Yes or no? Did
Yes.
you skew the population in the study?
I'm sorry, I don't understand
Did
the
you
question.
skew the population?
Did we skew the? Did we skew? No, we reported on all the ones that presented to the emergency room for care. However, a lot of dog bites don't present to the emergency room.
And so from the different cases that you report on within that article, are there any of those cases in which there is injuries to just one aspect of one part of the human body for the victims of dog attacks or dog bites in those cases?
There may have been. That's a summary of the 700 cases, more than 700 cases.
Is it normal in any kind of animal attack for injuries to occur on just one side of one arm of the person that's being attacked, clawed, or bitten?
There are many people who are bitten or scratched.
I'm asking
Only-
if it's normal, ma'am. That's all I'm
Okay,
asking.
so hold on, Mr. Jackson. Mr. Lally, ask a question, wait for the answer, and then start a next question. Do not interrupt the witness.
I apologize. I don't mean to interrupt, but I'm asking for an answer responsive to the question.
So ask a question and ask it in a manner that you get a responsive answer.
Dr. Russell, is it your testimony that it's normal in an animal attack for injuries to occur on just one side of one arm and nothing else, anywhere else on that person's body?
It can be, yes.
I'm not asking if it can be. I'm asking, is that normal?
I can't say.
It's sustained. You have to ask the question differently.
So from your observations, you looked at various photographs of Mr. O'Keefe, is that right?
I did.
Did you observe any injuries on any other part of his body that you would attribute to an animal attack, whether they be claw marks or bite marks or anything else?
No,
So nothing on his left arm, correct?
nothing that identified as a dog bite or
Nothing
scratch.
on his legs, is that correct?
That's correct.
Nothing on his torso, is that correct?
That's correct.
Now, you say an animal attack, possibly a large dog, correct?
Yes.
Can you say what type of animal left these marks that you attribute to an animal attack?
Not with 100% certainty, no.
Can you say where physically Mr. O'Keefe was located when those the animal attack supposedly occurred?
Objection.
Can you say that?
No.
Okay.
Can you say when Mr. O'Keefe purportedly sustained these injuries from an animal attack?
Well, to a certain degree, yes. Before, yeah, it was before death, but not long enough to have a big inflammatory reaction. So yes. So minutes to hours before death.
Minutes to hours before death, but at some point before death, correct?
Yes.
Can you say anything about the breed of dog?
No.
Can you say anything about whether it occurred inside the house, outside of the house, anything like that?
No.
As far as you mentioned some of the different things that you reviewed over the course of your testimony, or the preparation of your testimony, both prior to Tuesday and between Tuesday and today, any of those things contain any forensic reports or phone examinations or anything else related to this case?
Could you repeat that? I didn't. What kind of examination? Phone?
Any of the materials that you reviewed, whether it be prior, sometime between May 17th and Tuesday, or anything that you reviewed between Tuesday and today, did any of those materials that you reviewed contain any sort of forensic reports or anything beyond the UC days?
Yes, I saw a photograph.
you saw photographs. And to that point, you never actually saw Mr. O'Keefe's body, correct? You just saw photographs?
That's true.
And with respect to the UC Davis report, as far as canine DNA, are you aware that the results of that were that there was no canine DNA on Mr. O'Keefe, on swabbings that were sent to the UC Davis lab?
I'm going to allow it.
Yes, but there was clothing in between.
Okay, but the swabbings came from the clothing with tears in
Okay.
the clothing in the same area as the injuries, correct?
Okay.
Do you know that or no?
I couldn't tell if they came from the wound or the clothing. I thought that they came from the clothing, but
You couldn't tell by reviewing the report whether or not the swabbings came from clothing or from Mr. O'Keefe's body.
I know the clothing was sent to the laboratory,
You know the clothing was sent to what laboratory?
to the DNA laboratory.
To UC Davis?
Oh, I don't know that. No, I'm sorry.
You are aware that that came back as far as negative for any canine DNA, correct?
That's correct.
Now, as far as the injuries that you observed, your testimony is that both the top teeth of whatever animal this is and the bottom teeth of whatever animal this is both made contact with only the top of Mr. O'Keefe's arm or the posterior of his arm?
Both sets of teeth made contact with certain of those wounds, yes, but not all of them.
But neither the top nor the bottom teeth made any contact that you observed, assuming your issue as far as an animal attack. There's no evidence of any animal attack on the bottom of Mr. O'Keefe's right arm, correct?
I'm not sure what you mean by bottom.
Anterior,
Interior? That's correct.
and nothing on the posterior or the anterior of his left arm,
That is correct.
and nothing on his legs,
That's correct.
nothing on his torso,
Correct.
nothing on his head. Is that correct?
Correct.
Now, as far as the marks that you did observe that you do attribute to an animal attack, can you even say with certainty whether or not those marks you feel are bite marks versus scratch marks? Do you have any idea which are which?
There may be a combination.
So is that a no?
Well, no, I think that the ones that had the linear abrasions above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
Now, you indicated that part of what you had reviewed was a dog bite history for a dog from 34 Fairview Road named Chloe. Is that right?
Yes.
And there were a couple different instances of that dog essentially getting in a fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, correct?
Yes.
Did any of those dog bites that you saw in those photographs look anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but okay.
That's all, man.
Objection, Your Honor.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
So is it your testimony that from reviewing what you reviewed, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
What I'm asking you is.
All right, so Mr. Lally, I'm going to let the witness answer.
Go ahead, man.
I've seen thousands of people with injuries to their skin, and from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
So it's your testimony that the injuries to his
I agree
body
with
don't
Rob.
look
I'm on the
anything like
fence whether
blunt
she's
force
helping or
injuries
not.
that you've seen before. You wouldn't characterize them as that?
That's correct.
And that's based on some photographs and some other materials that you began reviewing sometime May 17th, 2024.
Yes, I'm an ER doctor. I need to make a diagnosis quickly when I see something, and I'm trained to do that. That's my specialty.
Were you being asked as an ER doctor to come to a quick conclusion in this case?
No,
But you did anyway.
it's how I'm trained.
Nothing further.
And James, we're listening to testimony, brother. We're not trying to talk over the top. We want to hear Grandma
Concerning
talk.
the forensic odontology report, the NAS report that Mr. Lally asked you about, what is your understanding about the report as it pertains to identifying individuals who left a bite mark? Explain that to jurors, please.
I believe the report says that is not reliable as it once was thought to be.
Like a fingerprint identifying a human being, DNA identifying a person, or a bite mark identifying a person. NAS said, not the bite mark. Doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
You were asked several questions about the injuries that you saw and studied attendant to highly trained canines, police dogs, correct?
Yes.
Very different than just a domestic dog that somebody might have as a pet, correct?
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
You were asked whether or not you were aware, based on UC Davis's report, that there was no canine DNA found on the swabs that were sent to them, correct?
Yes,
Are you also aware that there was pig DNA?
I'm aware of that.
Did that have any impact did you analyze that at all, one way or the other?
Not to any degree of scientific certainty, no.
But you do know that dogs chew on pig ears sometimes, correct?
Objection.
Sustained.
You've reviewed at least a report, if not a series of reports, that indicate that a particular dog has an attack history, correct?
Yes,
You were asked specifically by Mr. Lally whether or not the wounds in a dog attack on another dog attack where a human stuck a hand in the middle look anything like these, correct? Remember that question?
I remember a question like
And
that.
you said no, but, and then you were cut off. Remember that?
Yes,
You finish that answer for us.
yes. So animals and dogs in particular can inflict a wide variety of injuries on the skin, from just individual puncture wounds to abrasions where there's a scratching of the skin, to where there's actually a pulling away pulling away of the skin from the underlying tissues, your ripping effect. And so there's a variety of wounds that or patterns that one can see from an animal attack. It depends a lot on the thickness of the skin, the movement of between the victim and the animal, and also the power of the animal and the training of the animal. Yes.
So in other words, not all wounds inflicted by a particular animal are going to look exactly the same.
Correct.
Very dynamic situation, isn't it?
Objection.
Sustained.
Doctor, having seen up to 1,000 bite and claw marks on the human body, and based on your review of the entirety of the case file that you reviewed, including the nature and the pattern and the consistency of the injuries that you saw on Mr. O'Keefe's right arm, what is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is your ultimate conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
Can you tell the jurors at the end of the day, what is your opinion and conclusion about those injuries?
Objection.
Sustained.
Donna, can we approach?
Well, I mean, at some point you've accepted her as an expert. You got to at least let her give her expert opinion, I would think. Let's see. I'm not sure where the how the judge is sustaining each one of those. I thought the last one was pretty good. Vet, grandma, I think the jury's still out on whether grandma's a great assistance to the defense or not. I don't think it hurts the defense. I'll put it that way. I just don't know that it's like the jury's going to go, oh shit, it's dog bites. But hey,
Well,
let's talk about
Jackson-
Let's talk about dog bites real quick. I'm sorry. Go ahead, John. I didn't mean to step on you. I stepped all over you, good sir. Go ahead.
No, you're fine. So when Jackson originally started, outside of her experience, Jackson asked her about the wounds and if they were what they were consistent with, and she said an animal attack. So is he objecting because that question has already been answered?
He's objecting to getting her summation, her expert opinion. In the first one, he said to a scientific certainty. I see that objection being sustained. I mean, she can give her opinion, but she's not science. She's not Dr. Fauci, guys. So she can't give a scientific opinion of scientific certainty. But she can give her opinion through her experience because she's been deemed an expert in this court. So she can give her expert opinion. The following two questions I thought should have been allowed, so I'm not sure why the judge is pulling that out. There may be some issues and deals on the sidebar that they're violating.
Thank you. No more questions.
You are unmuted.
Mr.
If he had on a sweater, this is my experience with him. Good ball. Hear me with you. Hello.
You're in and out. I thought it was me, but you're rubber banding in and out.
I'm having some internet issues here today, so I think I might be back. Yes, Dylan. All right, I'm back. But remember, he had a sweatshirt on. And there, there we go. So he has a sweatshirt on. Dogs can get what's called a faux bite. They don't get on the, if it's your arm, they don't get the top and the bottom like you would think a dog would bite. That they'll hit the sweatshirt, hit the clothing, and they pull back. The clothing will slip. Essentially, the teeth will the bottom teeth get caught in the bottom of the sweatshirt. The top teeth will scrape across the skin. And I'll be quite honest with you, I think that could be consistent with what we see on John's arm. I don't think that our dog expert nailed it, in my opinion.
I just want to know who you have this afternoon. All right.
Oh, it sounds like I got one more for the day. And that may be one of the, I think it's ARCA experts coming in for after lunch. So that should be interesting. And once again, we do have the issue where the judge has limited the scope of these experts, these biomechanical engineers. Their expert is not being able to make a determination or give an expert opinion as to what caused the injuries on John O'Keefe. So I'm curious if the state opens the door on it, then the defense will walk through it. I just don't know exactly how that's going to go. I'm curious to see how that testimony goes because they can't testify as to these injuries consistent with a vehicle accident or not, which these guys, it's literally their job to do. And let me back up. If you caught the medical examiner's testimony today, when she was asked to be able to identify that the wound's consistent with being struck with a pedestrian strike, she said, "I cannot give you that opinion because I'm not a biomechanical engineer." So basically, she's saying she can't give you the opinion because she's not what these other guys are. So that's interesting to me. A nice of Bev to call lunch until your internet is fixed. That is nice, Dante. I was going to send her a text message, but I guess she's watching the stream herself. She said, "Hey, let's take a break and let's look at Joe's internet that's been having some issues the last couple of days get up." But I know they shut my internet down late last night and did some working on it in this area. I guess I don't know if they're not done with it yet, but I normally don't have internet issues, but I did have yesterday and I did have today. But it very well could be sunspots. That's something that's been kicking up. Hey, I want to mention a good friend of ours for the Night Court show. That is Foundry Holsters. You see that web address there, foundryholsters.com. This is a veteran-owned business out of North Carolina. They make custom holsters, any style that you want. If there's something that you want you can't find anywhere else, reach out to them. They'll make it. John, you've got one custom holster by Foundry, and they're making you another one, I think, right now. But he has a satisfaction guarantee. You're going to be happy with the holster. He's going to keep doing it until you are. A great little company. They're 2A advocates. They're pro-freedom, and folks, they need our support. That's how they put food on the table and grow their company and get their message out there, just like we like to get our message out there about being pro-freedom, pro-American and individual rights. So I can't stress enough, if you're interested or looking for a holster, you have some ideas of a holster that you want that you can't find, inside waist, outside waist, leg strap, something with mollies on it so that you can put it onto some web gear. These are the people to reach out to. If you don't see it on their website, shoot them an email, tell them Joe Lanou sent you, and they'll get you hooked up. He'll take care of it. Even the aesthetics. He's got one on there with kind of an imprint of the U.S. Constitution. It's kind of gray or brownish, beigeish color, like the turn color of the Constitution with the writing on it. Pretty sharp looking holsters. But go check them out. Give them a look and patronize those folks. The smaller companies like the Foundry, they need local support. They need individual support. They're not big box companies running millions of dollars. These are guys that are doing it out of the garage, doing it in small businesses, and trying to build and capture the American dream with a little freedom as well. And speaking of that, we've got another supporter of the Night Court show, and that's Sig Soda. Sig Soda is a I see I've got John in here two ways. Let me put you back up here, John. Yep, yeah, we got John live from North Carolina. But we've got Sig Soda. Sig Soda Designs. This guy puts together, he's also a pro-freedom individual. But he puts together, designs hats. He designed a hat for our friend Dexter Taylor. I stand with the Dexter Taylor, and that hat is available there. And he's also got a donation page there for Dexter Taylor's account. But it's not only that. He's got anything conservative gear. If you don't see something you like on his side as well, a quick email or a DM on X. You can follow him on X as Sig Soda. You shoot him a DM, and I promise you he can come up with a design that you'll like. But here's a quick little promo for them as well.
Hi, folks. Joe Lanou here. SigSoda.com has come up with an exclusive hat design to show your support for our friend Dexter Taylor, a.k.a. Carbon Mike. Message me on X to order, and $10 of every purchase goes to the Dexter Taylor Legal Defense Fund. Sig Soda is your source for Pro 2A Amendment gear, official sponsor of the Night Court show. Let's show Sig Soda some love and some support.
Yeah, absolutely. I can't stress those two small companies out there for if you're looking for some Pro 2A gear, some conservative gear. Sig Soda is your man. If you're looking for a holster out there, and honestly, you guys, any type of holster that you're looking for, the Foundry, those guys at Foundry can get you hooked up. And my last little my last little dig here, trying to get in somebody's pocket, is for the night court show. Folks, we do appreciate tips and donations to the night court show. We do use that literal kindness that people extend to us for subscriptions and things that we have to purchase, the time and efforts that we put into this show. We've got the Smoke Show with Joe Lanu, which is a meat smoking show that just started last Wednesday. We have another episode coming up this next Wednesday. The shows that you catch with Night Court, our live coverage of the Karen Reed trial. All this stuff is not only time consuming, but it costs us personally a little bit of cash out of our pockets to do. So anything that if you appreciate what we do, just like you do if you get good service at a restaurant, leave us a tip. We do appreciate it, and it will go to a good use. But if you see there, you can do it on Cash App. It's $ Joseph Lanu. That'll get you directly into the Night Court account, and drop a couple of dollars there. We appreciate you. Thank you very much. And I see we've got James in the studio with us. How about that? Go ahead, John. I didn't mean to cut you off.
No, you're fine. So if I can tag along with your promos there. So for those of you who do not know, doing this kind of setup initially, and even to keep it going, is quite expensive. And even if you can send Joe $5, $3 with it all connected, everybody pitching in, that goes a long way. Believe it or not. Like Joe said, if you get good service at a restaurant, you leave somebody $5, $10, whatever the case may be, your $5 goes a long way also. And as far as TJ at Foundry, yes, I've got another holster he's currently working on right now. I am very pleased with it. I'm one of those that if I don't, I'm not a complainer, but if I don't like something, or if I have an issue with something, whether it be the material, the product, the customer service, I won't buy again. He's working on my second one. And I will tell you, if you mention Joe's name, when you make your order, he will definitely take care of you. And the same kind of holster that he's building for me right now, custom, I've looked around. Number one, I can't find it because of the light that I have on my firearm. But generally speaking, a holster with the kind that I'm getting, with the hood on it and to fit a light, is going to run about $160, $170. He is way under that, and that includes shipping. So go check him out. I just wanted to add on to that, Joe. I'm sorry. Go ahead.
No, I appreciate it. I'm glad you brought up the holster, because I know this is the second custom holster he's made for you to accommodate a light. Am I right?
That is correct. It's the same firearm, same light. The one that he made is just a screw type retention. Being in law enforcement, it's fine. Don't get me wrong. It's a great holster, but I just want something with a little more security. So he's making me one with the inside thumb release and a hood, also for that same firearm and light. So he's adding some bells and whistles to it to make it a little bit more safer. But I'm on the second one.
Now, if you go to his website, I was impressed with the website when we first kind of started talking about him doing supporting the show. He's got a statement on there that is different than you see in other places. It's a 100% guaranteed satisfaction. It's not like there's got to be a defect in the product. It's like, you know what, I had you made this and I don't like it. He will go back and fix it, redo you another holster, but he's going to leave you happy, without a doubt. And that's not his personal guarantee. That's on his website. That's his business philosophy. But folks, I want to welcome James. James, how do you say your name on YouTube? The Q name. Say that name.
I pronounce it Qualnius.
Qualnius. I'm glad you picked easy names people can pick up real fast. But James is Qualnius on the stream that you see is popping up. It's the one and only James, and he is he's a loyal supporter and a legacy speaker for the Night Court show. You can see by the ring that he's got there. But James is a good guy, has a good view on things sometimes when he agrees with me. When he doesn't agree with me, I just let it go because James is a good guy. But welcome to the show, James. What's your opinion on what you've heard so far with the defense's case? We've heard from Lucky, the snowplow driver, and we've heard from Dog Bite Grandma. What do you think? How do you think the defense is doing?
You guys might have heard from them, but unfortunately, I was asleep for the first 3 hours of the court, so I kind of woke up when Grandma came back.
Well, I think most of the jury went to sleep when Grandma got on the stand, going through her 99 years of experience and training. So the jury may have got out of that as much as you did.
Just kind of reversed because they probably listened to Lucky. Anyway, so far I've been entertained quite a lot. This court has definitely answered a lot of questions I had and has opened up a lot of avenues for the jury. I honestly don't see any way that they can convict. There's just too many doubts.
Give me your top two doubts. Give me your top two doubts that the two things that if you were on the jury that you'd say these two things right here, you can't answer these questions for me. I can't convict. Give me the top two that sticks in your mind.
I'd probably go with the gosh, that's hard to pick down. Holy. I'd probably go with the investigators doing such a slipshod job with gathering the evidence. Like, why on earth is this case a little bit different than some of their other cases? Like, why weren't they quite as thorough? And the security footage. There's none of the incident anywhere nearby. Yet there's a couple of houses. I think one or two of them had cameras, but no footage.
So you're saying what stick in your mind is literally the absence of evidence that you think there should be there?
Yeah, like the state hasn't actually pulled the evidence to prove guilt. There's no proof.
Let's say, how do you think the state should have attacked this case? Let's go back 20 years before these Ring doorbell cameras were prolific and almost on every door. Do you think there's without that? Do you just saying there's no way to prove it? I mean, let's say your Ring camera's dirty or your Ring camera's inoperable. I mean, it's possible. It doesn't mean that you have a Ring door camera on your door that it's operating all the time. Things go on the glitch. Is it not possible that the cameras that could have seen that the area were not working, turned off, covered up?
Well, yeah, sure. I suppose that's possible. And as far as proving it 20 years ago, I would think that they would have done a better job gathering what evidence was available. Like, why on earth did they wait weeks to gather evidence? They went back, what, 2 extra times after the initial evidence gathering trip? Stuff could have been planted in that time. They don't know.
Okay, so really, I guess what I'm getting from you, what sticks out in your mind is the biggest issue you have with the case is that you don't trust the integrity of the police investigation, that it was sloppy, it left a lot of holes, so it's hard to say, I'm going to put somebody in the penitentiary off this hard work that you did, Mr. Law Enforcement Officer, right?
That's about the gist of it. I mean, if they'd gotten all of their evidence on day one, that would be different.
You know what? I don't disagree with you on that. I think that's probably my biggest hang up is I don't know that there was an impropriety by the law enforcement officers as far as like criminal, I'm going to frame this one, or just blunders, Keystone Cop type investigation. Either way, it doesn't change my mind. I think the state needs to come right. The state should not get any leadway. They are the state. We are the people. And it's better for a guilty man or woman to go free than it is for an innocent man or woman to be in prison and have their liberties taken away, because our liberties should be cherished. They're given to us by God. The government should only be able to take them away when they come 100% right. John, I want to get your opinion on that too, and then actually I want to tell you guys a true story of something that's kind of similar. Not a murder case. It's just a simple shoplifting robbery case, but how lazy police officers threw that away. But John, what's the one or two things that sticks in your mind as a jury saying, this is it, this is the hill I'm going to die on. I will not I will not vote to convict Karen Reed because of this.
Well, and not in this order, but kind of like what James was saying, I get evidence that's going to come forward as the investigation goes on. Maybe a week, 2 weeks, maybe a little bit further, but a year and a half interviewing people, I don't know. That just leaves a lot of time for people to practice their stories, talk to other people, and so on and so on. The other thing that I have an issue with is where the evidence was found. Um, I never worked in that field per se, but I've been there when it was being done. And you're looking around trying to look for evidence or preserve evidence when you find it. But when you look at that scene, clearly as a crime scene. So when you're looking at that crime scene and you're finding pieces of the tail light where they were, what is the probability? What is the probability that 3 or 4 pieces of tail light are going to be found underneath, the main stack of the fire hydrant, ever how far it was off the road? In my opinion, and I don't know the distance, but how feasible is it for that vehicle to travel off the road and not get stuck? And, I understand there wasn't much snow on the ground, but even then you're going to have some kind of a tire track, some kind of a tire mark and tire tread if there's, whether there's snow on the ground or, maybe not, I don't know. But, the other thing is I don't think they canvassed the area very well. We don't have access to the police report, so we don't know who they talked to, when they talked to them, and so forth. But from what I'm hearing, they didn't canvass the area very well. I have an issue with that. I think when you move on from the crime scene, the storing of the vehicle, moving the vehicle, the data that was found on board the computer on the vehicle, and then you go into phone data, the discrepancies that I've got a lot of holes in that. I have a lot of reasonable doubt, even way before you get in to where we are now. And I've said that before. I think I can't help but wonder if the jury hasn't already made up their mind. They're just listening for something that may change their mind. I don't know. But I have to be 100% honest. I think based on what I know and what I've listened to, my mind was made up about a week and a half ago. She didn't do this. I mean, how do you explain now even before you bring Miss Russell in, anybody with any kind of common sense knows those are puncture marks consistent with a dog. How many of us have not seen a dog bite or a bite from an attack, whether you were directly involved or not? I mean, we got the internet, people. We've got video. We got YouTube. People look at police canine apprehensions all the time. It's thrilling. It's informative. It's all kinds of stuff. I mean, it's almost like they're questioning the common sense of the jurors also. And I think a few minutes ago, I started seeing Lally, start trying to tread water. Maybe I'm wrong, but I think he sees that ship sinking. And I'll stop there. I just think there's a lot.
Yeah, I guess it's the investigator in me that I'm looking for something substantial that I can put my feet on if I'm going to make a decision for an acquittal or a decision for a guilty verdict. That I need something more than I wanted to see evidence that wasn't there or something I can plant. I do have a problem where the evidence was found. It doesn't seem plausible that all the debris field is located in the grass. The state hasn't alleged that her vehicle left the roadway, jumped the curb. The state is alleging that contact was made in the street, and he was knocked essentially at a 90-degree angle, and which can be done. We play pool. We know that you can apply some English and sideswipe a ball to make it move in that direction. That it did, but yet the debris, because inertia, think about it, this vehicle is moving at 26 miles an hour in one straight line backwards. That tail light is also moving at 24 miles an hour in that same trajectory, the same line. So when the contact is made, we all know that in order for it to change its direction, it has to encounter a greater force to make it go that direction. And for it to go 30 feet, I'm just saying it had been a hell of an impact for all the pieces of the lens of that tail light to all go into the essentially 90-degree, and nothing would continue in its path as it was going straight. In other words, I would expect to see debris in the street, not just the shoe. I would expect to see debris from that vehicle in the street if it was shattered into the small pieces that they're showing us. So I do have some issues with that, but Let me go back to this was in the early 2010s or mid 2010s, and it was a case that I wasn't involved with. I went to court to get a warrant signed. It was a jury trial going on, so you see how much trouble it is to move a jury around and stop a jury trial, right? So when those are going on, you just have a seat in the back and wait. And the judge that I was there to see, he'd always acknowledge kind of with a head nod when he saw me come in, or any officer, not just me, but I only saw it when it was me. But he would acknowledge, and sometimes he'd put his finger up or he pointed his watch, kind of giving you some indication how much longer is it going to be. But I'm sitting there and I listened to testimony. This was a shoplifting case out of a Walmart. Two larger black ladies are seen on a Walmart camera. The camera wasn't great as far as its quality, but you could tell two larger black women. They do some shoplifting, pretty much leave the store with the items in bags, and they were pursued by loss prevention, Walmart security people, to stop. Hey, give me the bags, and not let them leave. They were going to make an apprehension. They swing elbows and push away to get to their vehicle, get in their vehicle, and as they're pulling out, they kind of sideswipe, not intentionally, but they kind of sideswipe one of the loss prevention persons. No serious injury. But during the struggle getting in the vehicle, they drop a purse and they leave. They identified the people by video camera and the license plate, and they were apprehended a very short time later. These two ladies, they go to jail, and then like a year later, we're in trial. And I'm listening to this. I saw the state's video of it, and I don't know what these guys are really fighting. It's all good. It looks like it would be an open and shut case. The two ladies sitting at the defense table, or who I saw thinking that they were what I saw on the video camera. But remember, it wasn't very clear video at this time period in the world. The quality hadn't gotten to where it is now. It gets to the defense attorney, and this is a defense attorney. I know him very well. He's kind of a cool cat. I like him, and he's a good defense attorney. I don't think he's really got much of a defense, but he goes to the defense, and he's doing cross-examination with a police officer. This was a local PD officer that's on the stand that investigated this, made the arrest, and logged in the evidence. So he's going through there. They've entered this purse into evidence, and he takes the purse. It's on the defense table. He's going through it. He's looking through it like you would look through somebody's purse the first time you'd opened it up. Kind of going through the contents of it as he's asking questions. And then you see him pull up the wallet, and he opens the wallet, and he looks at the wallet. And then he pulls out an ID, and he looks at it again. And then he turns back to the officer. He said, "So when you logged this into evidence, did you do an inventory of its contents?" And I think the officer said he did, but it was logged into like purse and contents. It wasn't a detailed inventory list. And he asked him that, so it wasn't a detailed inventory list. Well, no. He said, "Well, did you ever look into it?" And he said, "To see whoever's ID this was in the purse, to maybe identify the owner of the purse." The officer's like, well, no, I didn't. So you'd be surprised to find out that the person that owns this purse is not either one of the defendants, and it's got an ID of a heavy-set black woman that's not either one of the defendants. The jury goes. They go into the rest. I'm there until they rest, and then the judge puts the jury into deliberations. I go back to get the warrant signed by the judge. The judge is making comments about that, and he said, "I don't understand how you police officers, of course, the judges do it just like everybody else does. Now I'm the same cop as this jackass sitting on the stand. I don't understand how you police officers take something in evidence, you don't even take a damn look at it." I said, I'm kind of surprised too. The first thing I want to do is when I have a purse is to dig into it, just find out what's in there. You never know what's going on. And obviously, you put something in evidence, you want to have a good inventory of it and a detailed inventory of it and a chain of custody. By the time I walked out of the jury come in, and I just paused for long enough to see what it was. What do you think the verdict was?
Not guilty.
Not guilty. But I'm pretty damn sure the two ladies that were in there, because you find out the backstory later, that was a cousin to one of the ladies that was arrested. It just wasn't one of the ladies that was there that day. 100% sure them ladies did rob Walmart, and they got away with it. But how hard is it for a police officer to what? Do an inventory, figure out who this person is, going to make contact with him, say, "Oh, no, I wasn't there. I was with someone else, but my cousin, she'd be carrying my ID. I know she'd been carrying my ID." And that then all that would have been avoided, and the state would have got a conviction. And I feel this case is a lot similar. The cop didn't do it out of ignorance. He's not smart enough to inventory. Absolutely, he is. He did it out of laziness. He figured, I got this wrapped up. These two ladies, we got them on video, even though the video is not very clear, but we got them on video. This is a done deal. And let's put it down and let me go on down the road. Instead of doing a thorough job on every investigation, they cut corners on that one, and that's what caught them. I think on this case, nobody ever thought this was going to go to jury, that they thought they had the slam dunk, didn't have to dot their I's and cross their T's, and lo and behold, they're finding out now that they very well should have. And they've delivered to the prosecution office a shitty case, but I'm not taking the blame off the prosecutor either. The prosecution office should have demanded a better case. And I think the court systems there in that area, they need to be demanding a better case from the state when they bring cases to court. And the way they do that, judges are going to have to start clamping down and having penalties. And that does mean sometimes some guilty people are going to go free because the state and law enforcement doesn't do their jobs, in my opinion.
No, you're right about that.
That's my soapbox. I'm off of it.
Yeah, we had we didn't. The city agency in the county I work in had a big case years ago. A lady that was working at it's called Silk Plant Forest, or it's been in I think they actually done a documentary on it. You can Google it and find out. But long story short, she was pregnant. The lady that worked there, she was assaulted, put in a vegetative state. But they ended up arresting a guy shortly after the incident. And very long story short, the officer that was the first officer on the scene, identified, or she said that the victim was identifying a white male, or I'm sorry, a black male, and the investigating officer wrote down white male. It took a while for that to come out. We was talking a while back about officers keeping their notes. Well, she had kept all of her notes through all of her calls, all of her investigative calls, except that one. So when it finally went to trial, after several times, she finally testified that she said, "Well, I thought," she said, "it was a white male." But it was later found out, I forget now how, but she had basically lied in her report. But before that was found out, she went from the city agency to the county agency, and I'll leave it at that. But yeah, it's in that, that in this area here, people started pointing fingers at every law enforcement officer. If you had a badge on your chest, you were having fingers pointed at you. You're crooked. You're dirty. You're only after one race and all this and that. And it was all because, she had an agenda for whatever reason. My point is that, initially you're the one that has to document what you find when you get there. And, you got to make sure you're on your P's and Q's, and just to grab a purse and say, a brown purse with items inside of it, and not go through it and look at IDs. That's sloppy. And then, like you said, the judge throws you all under one umbrella, and that ain't fair.
Yeah, this old judge, he just ribbed me. This is the same judge that gave me shit. A very similar circumstance when a woman gets convicted for burglary, I believe, and the only person in the whole gallery, but the only person in the gallery is her 16-year-old daughter. When her mom gets 4 or 5 years, long enough to be concerned about, upset about, the daughter kind of loses her shit, and the bailiff is an older guy, and she's not responding to him, and I had to get involved. And the problem with using force against females, a lot of times we go at it soft-handed, thinking they're going to not put up a fight, and she kind of did put up a fight. But this is the judge that before I could get out of the courtroom, after putting this young lady on the deck and getting her handcuffed and calmed down, by the time I could get out of there with my warrant signed and to where I was going, my phone's blowing up from the sheriff's office, including the sheriff himself. Everybody's calling to check up on me because the judge was concerned about that I could have sustained injuries because I just got in a fight with a 16-year-old girl. So the judge had a sense of humor. Sorry, James, I stepped on you. Go ahead, sir.
No, that's fine. I was just gonna inject a little bit of knowledge here. Do you guys know what Mind Your P's and Q's comes from?
I do not, being honest.
You know what? I can't recall it. It seems like I've heard it before, but maybe I don't, though. James, tell us.
A lot of people like to say it's mind your pints and quarts. That's not true. It came technically from the First Amendment, or rather, the implementation of it here in this country in the printer's press, how we made newspapers back in the day. What you would do is you would have drawers of lead type, the characters that you were using, and they're all upside down and backwards. So it's like looking at something that's upside down through a mirror, and that's how you have to read it. So P's and Q's, B's and D's, they all just kind of merge and blend together, and you could very easily put the wrong character in there. That's why you have to mind your P's and Q's to make sure that you put the proper type down.
Interesting. I've learned something today.
You know what? If I thought I knew what it meant, I've never heard that, and that absolutely rings with some truth there. Appreciate that. That's good info, James.
I've actually ran the printer's press at the San Jose Historical Museum, so kind of know a few things.
Nice. Do you know where "pull my chain" comes from? When someone says, "Are you pulling my chain?"
That I do not.
Interesting. In mining, they've got the cart that on rails, the little rail cart that they'll move material in and out of. But they've also got a toilet cart. There's no place to go to the bathroom there. They've got a chain by it, so they'll bring the toilet cart near where the workers are, so they can go in and do their business. And when you go in, though, you take a chain and lay it across the tracks, so that the cart can't roll because it's on wheels. But the chain is like a chalk, and it stops it. So if you want to make a joke or pull a joke on someone when they go into the shitter cart, you move the chain and push the cart. So that would be the term. So you hear a chain moving, you're inside of it. It's like, "Hey, are you pulling my chain?" Means if they're joking, it's a joke. Someone is punking you, so to speak.
That makes a lot of sense.
So yeah, our knowledge on expressions is a good way to kill a space and kill a conversation. But yeah, that's funny.
Yeah, I was gonna say, did we lose the trial?
No, they're on lunch break. They may have been going to lunch break when you were getting into here, but yeah, they're on a definite lunch break now. They'll come back. We've got one more witness for the day. I didn't catch the name, but I think it's going to be one of those ARCA experts. So I'm curious to see how. I'm really curious to see how this goes and how much latitude that Bev is going to give them, because they can come in and actually give testimony that John O'Keefe's injuries are not consistent with the state's story because they're biomechanical engineers. If you go back to during the voir dire, if you caught that, one of the scenarios that the guy that's being restricted gave that he's testified in court before was a recent case, because they asked him how many cases, and he's got so many, but he pulled out a recent one going back to this earliest this spring, was a homicide case where a husband claimed that his wife fell down the stairs. And he was able to show that this injury sustained by the victim were not consistent with a stair fall, and was able to prove that, and then show that it was more consistent with the state's allegations as far as how, I don't know what mechanical means it used, he didn't say. But my point is that that's the type of testimony that this guy's an expert in. He testifies in federal courts and other state courts all over the country, and probably has testified more than we could count. But yet when Judge Bev is going to allow them in as expert witnesses, but they cannot testify as to what injuries would have caused or matching the injuries on John O'Keefe's body to the mechanical injuries that the state alleges. So I'm curious to see how this actually goes through, and what they're really going to be able to testify about, because they're biomechanical engineers. That's what they do. There's another little asterisk to that. Today, the medical examiner, when asked by the state if John O'Keefe's injuries were consistent with a pedestrian vehicle strike, she says, "Well, yes, it could be one of the contributors to it. That could be how it happened, basically." But she said there are other things as well. And he pushed her for a more specific answer, and she pushed back, saying, "I am not a biomechanical engineer. I cannot make assumptions as to what caused the injuries." And she said, "At this point, I can't tell you. I can tell you that it may be consistent, but I can't say definitely that it was a motor vehicle strike. So it's interesting that, excuse me, it's interesting that OBEV says that in the state of Massachusetts, it has to be a medical doctor to give that type of testimony. But yet, when the medical doctor's on the stand, the medical examiner who does that can't give it and says that it would have to be a biomechanical engineer to take a look at it and make that decision that this guy's actually narrowed. Folks, we got Kingdom popping in from the man on the ground out there in Austin, Texas, I believe. He says, "Is there any chance Karen Reed will be found guilty?" I say there is a chance. I say that you can't rule that out. I think there's a high probability on a hung jury. In fact, I would put my money right now that this is going to end in a hung jury, which will end it all and put the state back to either bringing charges back against her or letting it go. But Karen Reed will be not exonerated, but she will be free from charges after the deliberations. I say it's going to be a hung jury.
I can't disagree with that.
Because, you know, important to get a full acquittal, you got to have the same thing you have for guilty. Everybody's got to agree. I'm sure there's people on that jury that are going to stick on, and I'm going to go back to the debris field again. I've said this before. I think that's a very critical piece of understanding the story. If you believe that the debris field was as it was, the police said it was, then you have to convict her. There's no other explanation for John O'Keefe's death. Now, whether that be manslaughter, she didn't do it intentionally, or she did it intentionally. Make your decision at that point. But somewhat, how or another, she'll be convicted because her vehicle that she was operating come in contact with his body, and that led to his demise, which that would be technically correct. If you don't believe the debris field or the debris field's troubling for you, then you can't convict her. There's nothing else out there that points to her guilt without that debris field being intact. In other words, correct as the police said it was. So in my mind, if you can't get past that, then it's a not guilty. But I'm sure there's people that are sitting in this jury that are going to go, well, plastic pieces there, the glass was there. I mean, you can't really explain that. I don't know about everything else, but you can't explain that. So therefore, I'm going with it and that she's guilty. So that's why I think a hung jury is it. I think there will be some in there that will be on the state side for conviction, but I do think you're gonna have others in there that are gonna be like, I just can't do it. It's too sloppy, too much bullshit, and I just can't do it. So I think hung jury.
Man, I truly wish I had had the opportunity to serve on a jury at some point. I've been summoned several times, but never actually served. And strangely enough, I've never actually gone to a summons. I've never been called.
Yeah, I tell you what, so if you want to serve on a jury, the way they do it in Texas, I think they do it similar in most states, is that be a registered voter. Be a registered voter in the county that in Texas. What they do is they take all the registered voters in the county, the jurisdiction that the court has, the land area that it has. It takes all of those and it literally puts them into a lottery. And when they need jurors for grand juries and when they need jurors for jury trials, they pull those literally randomly out of. They do it by computer now. It's a pops up a random generated list of people who are registered voters. But in the old courthouse, in the jurisdiction that I served in, they actually had the old barrel with a handle on it that they would put all the everybody's jury cards into this roller thing and roll it around, and then different people would pull them out until they picked enough people as a potential jury pool to summons them for court. But if you want to serve on a jury, make sure that you're registered to vote. That's the way it's done in Texas. I would assume it's probably done that way in most states, because that usually if you're registered to vote, I mean, you're probably not a felon. You would probably be qualified to actually sit on a jury.
Well, yeah, and like I said, I've been summoned, I think, 4 times, and strangely enough, I lost the summons or forgot that it was that day or whatever, and out of the potential jury pools, they got their jury selection without ever needing to call my name. Otherwise, I would have been penalized. Never been penalized, never went. Weird.
Well, in Texas, it actually is a violation not to answer a jury summons, but there's no penalty for it. But don't worry, they just keep even if you serve on a jury, they're going to keep you in the pool and keep recycling it. It's not like once they've called you, they won't call you again. Honestly, once you've been called, you're probably going to go into the pool where you'll be called again and again. And once you've served on a jury, other defense attorney could use that as a reason to strike you. The prosecution could use that as a reason to strike you. So, in order to actually get seated on a jury, you got to show up, James. You got to show up, and if you show up, there's a good chance that you'll actually get seated because they don't just seat one jury. The way courts do it, they'll pull all the juries they need for this month, and they'll go through all that in about 3 days and get all their juries for the month seated. One day, 1 or 2 days a month, they'll do that. So it's a process. You got to show up if you want to do that.
Hey, Joe, I had an interesting question put to me the other day, and I only know of one case that I had an answer for this. But say in this case right here, this happened in 22, correct? 21, January
22.
22. So Karen Reed's vehicle is a 2021 Lexus. We're going to assume that she had a loan on it. So the question I had that somebody asked me is if somebody's involved in a crime where it involves the vehicle to whatever extent, and there is a lien on it, like you're making payments, are you still responsible for making those payments if the vehicle is seized? I have been told yes, but I do know of a case where the vehicle was used in a double homicide, and the victims was actually placed in the back of the vehicle. But long story short, the insurance company, the lien holder got a hold of the insurance company. The insurance company totaled it, and that way it kind of absolved the suspect, or the owner, I should say, of having to make that payment. Do you have any experience with that to elaborate more on that, or is that what's your take on that?
You're right. You can file the lien holder, which would be the bank, can file on the insurance because the vehicle is totaled at that point. If your vehicle is involved in a murder investigation, that vehicle is going to be impounded. It is not going to be available for use. In another thing about it is that the state has to maintain that on a conviction. They've got to maintain that 7 years after final disposition. I'll tell you, the Massey case was in my county, which happened before I was in law enforcement, some years before I was in law enforcement. But I remember it was a big deal. It was a kind of a wannabe on his way to be a serial killer. Got caught before he could get too many kills under his belt, but a pretty sick dude. But he gets the death penalty. And after I'd been in law enforcement for some time, I go to our big impound barn, which was huge. Tons of vehicles in there that are being held for evidence and seizure. Not many seizure, most everything in there was for evidence. But way in the back is that guy's vehicle. He'd already been executed, I think, 2 years or 3 years before this. So he had his penalty, served his time up until whenever that is, 20 some odd years or something like that. Gets the needle in his arm and he's dead, but yet we're still maintaining that vehicle. We have to maintain it for 7 years after disposition of the case. Disposition of the case is when the sentence has been carried out. So if somebody gets life in prison, that vehicle is impounded forever. And that vehicle will be destroyed. Once it's done, they'll destroy the vehicle. They'll never sell it. That vehicle is not going to be on the road. I would say her Lexus is never going to see another driver behind the wheel. It will maintain impoundment almost indefinitely. So, but yes, they can. The lien company, the lien holder, or the third uninterested party in this case, can file a claim on the insurance and for all intents and purposes, that's a loss of the vehicle because it can never be used again.
Yeah, I wasn't sure. And I mean, I know they totaled it, or that vehicle, but say in her case, not knowing, keep in mind, if they come find out that her vehicle wasn't used, I wonder where it goes. Then. I mean, would it go back to her if it wasn't used in the death of O'Keefe? I don't know. It's just something I was thinking about.
Yes, but the state's not going to release it. The state still is going to say that is a piece of material evidence for this homicide. If she gets acquitted, if she's acquitted, they're not going to return the vehicle to her. That Lexus is going to go the way of the Massey vehicle. It's going to catch a bunch of dust in the back of an impound yard and ultimately find its way into a scrap yard to be crushed.
Yeah. I was just wondering. I never had really anything to do with that other than that one case.
You know, and that's something that a lot of folks don't realize is that even smaller law enforcement agencies, the expense that they go through to maintain evidence for years, but you have to maintain it. Let's say you take the Massey case where he killed a girl killed a man, a boy and a girl in the car, but there was pretty horrible things done to the girl inside the car itself. So that is not only the crime scene, but it's a material piece of evidence for the crime. But he's on death row for 25 years, and then all of a sudden he's exonerated, or that there has to be some other legal action where we're going to go back and examine evidence, or this evidence should be examined years later, that he wins some sort of appeal or some sort of a motion by an appeals court to say we want to re-examine evidence, bloodstain evidence out of the vehicle, and the state doesn't have it, then the state's going to have to let him go. Because if a judge says that this is worth looking at again, and the state didn't maintain it to look at it again, then it's a problem. So even the small items, so clothing. You've heard about DNA evidence from cases from 30 or 40 years back that they'll pull out and go get DNA. DNA is advanced to the point where we can do DNA testing on samples. We couldn't do samples then. That means that, but you understand that an agency has maintained it, didn't let it rot, kept it clean, kept it sealed and with hopefully integrity over all these years, so that it's available for re-examination because it's evidence in a crime.
Yeah, I mean, that makes sense.
Yep,
That's all an
and
interesting question.
sorry about that. And yeah, like you said, if the state doesn't maintain that evidence, they're gonna have to let them go, because like, no, this was a key piece of evidence that was keeping this person in jail. You don't have it anymore. No, go get out.
Now, and there's actually some case law out there on that very thing where, especially with blood evidence. Let's go back to the early 90s. I actually worked on a cold case. It was a double homicide at a hotel, a motel, really, for a truck driving school. It was a truck driving school, and people would travel from other places to go to this truck driving school, and they had made a deal. Part of their their essentially truck driving college, and this is their dorms were this motel. But they had roommates, two people to a room, two men to a room. So there's two men staying in this room at this hotel, and guys that have been into barracks and places like that. You know how it is, like after class, you got your guys that you go drink with, guys you go hang out with. So you had your little crowd of guys that were hanging out together around this hotel, this motel. But one of the gentleman's girlfriend comes down to visit for the weekend. Everything's fine. They go out to dinner. They meet some other guys at a local pool hall, and they shoot some pool that night. They go back at not very late, about 11:30 at night. Everything seems to be fine. And sometime around about 2 in the morning, a guy comes out with blood on his head, but there was a double homicide in there. It should have been a triple homicide, where his girlfriend was raped and shot in the head. He was shot in the head, but the bullet hit the brain the skull, and actually went around the skull and didn't penetrate. Knocked him out, though. He was unconscious until he'd woken up, and killed the roommate that was in there. Couldn't figure out who did it. I mean, there was a lot of suspects on the deal, but this was in 1990. So think about the time period. This happened in 1990. They did have the wherewithal, believe it or not. And the reason we pulled this up and looked at it again, because you start looking at the report, there's in 1993, a couple of years later after the offense, there's an entry into the chain of custody that the FBI had taken custody of some swabs or some swatches where they cut blood-stained clothing, swatches out of the clothing, and they took them. So after I run that down, I was like, well, why did they go to the FBI? We didn't know why. Didn't know if somebody had ordered that for some FBI forensic testing, but they didn't. It was back when the FBI or the federal government was trying to put together CODIS and DNA was kicking up, that they were reaching out to law enforcement agencies on unsolved cases and trying to come up with ways to preserve this evidence for further analysis because they believe that DNA would progress, the technology would progress over time, and they were right. The problem is they picked the wrong way to do it, to preserve it. 'Cause what they did, they didn't keep the clothing. They actually removed and extracted the DNA and put the DNA on slides so that it could be inputted into a CODIS system later. But the standard to put DNA in a CODIS system changed, and when it changed, they couldn't go back with the slides and make it be match the parameters that it took to have a sample analyzed through the CODIS system. So there's about 7 or 8 years worth of slides and information that's in CODIS that can't be used because you can't compare it to modern day matches. And this case was part of that. But the problem is that they took most of the blood evidence, the clothing and the blood evidence samples that they had, and they converted them into this style of DNA. And I couldn't tell you what it is, but there's a difference on it. But we were able to take the slides and actually do some comparisons. I know who did it. I know the story on it, but it'll never go to trial. You're never going to be able to prove it because of the way that the FBI stored the DNA samples at the time. Of course, they didn't know. They did it with the best technology they had at the time. It's not just this case. There were many cases that were done that way. But I'm not sure how I got down that road with the DNA evidence on a cold case. But that's an interesting story. Like I say, the man that did it lives in San Antonio today. Well, one of the men that did it, there was 3. One is dead, and one I think lives in Oklahoma. But the main guy who did it lives in San Antonio today. I've talked to him. If he had said that he did it, I could have arrested him. But other than that, there wasn't anything I can do.
Wow. And I hadn't gone back. You said earlier about Range Minded doing his podcast, and I caught a little bit of what you were saying. I wish I'd have known. I could have maybe contributed a little bit of that because I know of an agency that has done that, and I will leave it at that. As far as the uniform crime,
You're seeing not reporting UCR stats, uniform crime reporting stats to the FBI.
Yeah. So housebreaking, you come home and find your door kicked in. You call police and go in, and they clear it, and you go in and you say, well, I don't see anything that's been taken. All right. Well, we're writing it up as a MIP, or vandalism, malicious injury to property / vandalism. It was not written up as a house break-in. Now, if something was stolen, it was. So,
Well, that's not exactly what Range is talking about. Range is talking about they're doing the offenses and they're coding them correctly. They just don't report them. UCR reporting is voluntary by agencies. Agencies, in my time, everyone did it. Why wouldn't you do it? It actually aids in law enforcement nationwide by kind of giving an outlook of trends and things like that, and in numbers and areas that might be hotspots. But there's going back, and this goes directly tied to the Biden administration. Maybe predates the Biden administration by a couple of years. But Chicago, New York, Los Angeles, San Francisco, all these blue bastion cities are now not reporting their violent crimes. They'll decide what they report to the through UCR, but Chicago, New York, and San Francisco are not reporting at all. They just refuse to report. So you're just not getting the numbers out of some of these areas that honestly are probably more heavier in crime. But it's interesting when you go listen to the news, they'll talk about, well, crime's going down. Well, yeah, reported crime is reported through UCR is, and I'll also challenge that there's no other way for anybody to be able to put together any data if they don't use the UCR. It's the only way to really capture that. What are you going to do? You're going to go through jail screens on every damn county jail throughout the United States and start trying to log in what the offenses were there, or call logs in every dispatch to determine what calls were called for service there, is what offenses have occurred in every jurisdiction. It's untenable. There's no way that anybody could ever do that. It would cost billions of dollars just to try to hire the people to go out there and sort through these data records. And unlike a lot of folks think that there's like this big national computer somewhere that you can go tap into and get all the information that you want, it's not. It's siloed. The National Crime Information Computer, it's not in one location. It's it's in every agency. It's held in every agency. John, I guarantee you that there'll be times you're on patrol and they'll hit you up sometime at 2 or 3 in the morning, and your dispatch is letting you know that you can't run anything for the next hour because they're doing uploads or they're doing maintenance through your independent crime is, because that's the way it works. This is also why folks may not know this, that if I get pulled over and I've got a warrant for my arrest, you'll get a hit. 99 traffic is what we call it here, or my agency did. I think it's a 10 code for a wanted person. So they'll run my driver's license. They say, well, Joe's 1099. That means I'm wanted by another agency, but I'm not under arrest yet. The officer can't arrest me yet. He's going to then tell his dispatch to call the other dispatch and confirm that warrant. The proper way to confirm it is they go to a paper file, pull it out, and pull that actual warrant out that hasn't been served. And then they will tell my agency, but this warrant, this is a good warrant. We have confirmed it. In other words, we held it in our hand and read it. This is a good warrant. Now, taking this, what I was just telling you about the maintenance, but those records are maintained both physically and on the databases of every agency. So when you run a check, if you run a regional check on in Texas, it's TLITS, which is the Texas crime computer. If you run a regional, it's only going to run certain area. It's going to run any jurisdiction that's connected to my jurisdiction that will extradite for a Class C warrant. In other words, a capious profile, a warrant for cash only or money only. In other words, I hadn't paid a fine. Somebody's not going to travel 3 states over to pick you up because you didn't pay for a parking ticket, but they may come 2 counties over to get you. We got the camera back. I'll finish that boring story later about NCIC and TCIC bullshit. Here we go.
What's up, Bev?
She said, I hope you had a light lunch because this shit's going to be boring. I don't want you falling asleep. Take notes.
Thank you. All right, Ms. Giannetti.
Thank you very much, Your Honor. Defense calls Richard Green.
Okay.
I heard Richard Green. Remember who this is?
I don't. And I think we're going to find out before I can pull up the witness list.
Oh, yeah. We'll find out here in just a second. I'm trying to figure out, are these material witnesses or are these the experts? The defense case may be just the damn experts. That's where maybe we were at. Oh, no, I don't remember this guy as an expert.
Can you raise your right hand? You solemnly swear the evidence you give the court and jury in the case now, the truth, the whole truth, and nothing but the truth, so help you God. I do.
I do, Sonny.
Good afternoon.
Young lady. Got my blue shirt on today. I got my glasses out. I'm ready to start answering questions. Let's go.
Sir, if you pull that microphone as close to your face as you can so your voice will be kept up, and I'd ask you to state your name and spell your last name.
Sure. Richard Green. That's Green.
And where do you live, sir?
I now reside in Coldwater, Michigan.
What do you do?
It's like he's happy to be there.
I own and operate a company called United States Forensics.
And what is United States Forensics?
Sure. We're a digital investigation firm. We have we're licensed in Florida and Michigan, but we do cases across the country.
All right. And again, I'd ask you to keep.
Dante says this is the Celebrate guy. They got 3 experts in discredit. This should be very good.
Okay.
Folks, I've got to step away for a minute. I'm going to be listening, but it goes quiet. John and James, you guys have the con.
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. Prefer to take cases from attorneys. We've also worked with numerous public defenders. We've worked with a federal public defender. We've worked with law enforcement. Quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit and it was just improper for them to use their own experts. So that's where we provide assistance.
Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics and been full-time in the industry since that point.
All right. Yeah, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And do you work full-time, part-time? What's your schedule?
Oh, it's been full-time ever since.
Would you describe to the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis. This
Hey, Joe, if you can hear this rubber band.
To do training.
Okay, again, voice dropped off a little bit, so
I'm
sorry to keep reminding you that.
Yeah, it's going bad.
Your case at USA, give the jury some idea of cases you handle.
I think 120 cases a year. We probably get inquiries to about 3 times.
You testified as an expert witness in the area of computer forensics since that night.
Oof, sounds like we lost it.
Yeah, we'll give it a minute.
1996 first appearance.
Yeah, we testified about 24 times in various state and federal courts.
Okay. And we say various states and courts. Is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022, were you contacted by somebody to become involved in this matter?
Yes, sir.
Remember who that was?
I believe it was Miss Little.
What were you asked to do?
Well, there was 3 cell phones related to this case, and to provide relevance with the data on those phones as related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially what was reported was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when he arrived?
Yeah, 34 Fairview.
In Canton?
Yes, sir.
All right. Were you able to determine, as a result of your examination, approximately when his phone arrived at 34 Fairview Road according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's proverbial we. I extracted the location cache data, which is stored in the on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so it can take literally, thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34 Fairview on January 29th, 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk, could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
I may approach, Your Honor?
Yes.
So I placed a document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
So this is a screenshot from the CellHawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to what?
Oh, John O'Keefe's location data.
Is that an exact? Is the data on that document exactly what you received when you used the CellHawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
No objections.
Oh, I'm sorry. I thought he said objection.
So you need to give it to Madam Court Reporter.
I'm all flustered. Sorry. And if the witness could have that again.
Thank you.
With permission, I'd like to publish that, Your Honor.
Okay.
Okay, so, Mr. Green, what are we looking at?
So that is the CellHawk.
And what can you tell us about what you learned from that exhibit?
Well, I'll just use one here, but you can see the part here where this is where we apply the filter for feeder loss, that be accuracy, and then it actually returns 0 results, meaning all of the data within there had an accuracy rating higher than that 5 meters or 10 meters, but none of it was granular enough, a 3-foot or less accuracy level.
And if you could input accuracy within, say, 500, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related to. What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in a circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess of what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Okay, so we've talked about the location and where John Keith's phone in terms of arriving at 34 Fair, but we also have health data on John O'Keefe's phone during that time.
Sure, yes.
Is Apple Health data generally accepted within the forensic science as being reliable?
Well, the Apple Health data, and it's going to come from
Yeah, but I sent him a text.
It's integral to the iOS systems. Anyone that has a phone probably can have Health data. And what's it's known to have extremely valuable data that the first tools work with and present to us. The degree of accuracy depends on the type of data that being pulled out of the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So if the Apple Health data returns, for instance, steps, 20 steps within a certain time period, 98% of the time, Apple's going to be right?
That's what they have shown.
All right. May I approach the witness, Your Honor?
Yes.
You want it back?
You guys getting audio problems out of this?
Yeah, audio and video.
Mr. Green, I've placed another document before you. Do you recognize what that is?
All right.
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
All right. That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
Looks good. Or it did.
Yeah. So just FYI, while he's doing whatever it is he's doing. So a lot of law enforcement officers, or at least I know they do around here, uses software called Leads Online. It's kind of like it's not a national database, I don't think, but
yeah, Leads Online is a national database.
Okay, so Cellhawk is implemented with that.
It's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said the same time period. So again, 12/21/10 to 12/24/22, correct?
Correct.
All right, folks, I changed the feed. You should be better now.
For record number 1.
Yeah. Yes.
Post that. When you're ready, Mr. Green, if you could tell the jury what that reflects?
Sure. So this indicates 3 sets of floors that represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12/22/14 to 12/24/37.
Okay, did you say 12/21/14 to 12/22, I'm sorry, 12/24/37?
Yeah, 12/22/14 to 12/47/37.
I see.
Okay.
And with regard to all of this data, the 80 steps and the 3 flights of stairs that you mentioned, is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't it doesn't signify as any more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So it's time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if the steps are bunched up toward the beginning or toward the end or more evenly spread out?
No, I would not be able to tell you that.
Now, we've discussed the Apple Health data. I want to go back for a second to talk about the location data on the iPhone. Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:21 and 10 seconds and 12:24 and 37 seconds?
Well, there is that certainly indicates an overlap, but the health data is ending after the arrival, and we can.
Now, I'd like to discuss with you the concept of clocks used by apps on an iPhone.
Sure.
Are you aware of the 3 different clocks that are used by iPhone apps?
I am.
What are they?
We have you have 3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Okay, and is the wall clock also called the display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding, different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor. Sure. I've placed Exhibit 640 before you, sir. Do you recognize what that is?
Yes, sir.
What is it?
So this is a screenshot from the Magnet Action program I was referring to. It's the 8.1, actually it looks like 4287, but
Keep your voice up, sir.
I'm sorry. Yeah. So it's the newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
With the court's permission, may I publish that?
There you go.
And first of all, are you? No, that writing's probably too small. I can't read it.
Okay. Thank you. I'll go off of this one.
There we go. With regard to what we are looking at there on that part of the screen, what are we looking at, Mr. Green?
Okay, so this is listing details of this particular artifact, and you can see that this is bundled. The com.ways.iphone, that's a standard bundle type name where it always starts with com dot and then the application reference.
And what does that mean? When it says, it's highlighted on the screen, com.ways.iphone. What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the three of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to.
Objection. Move to strike.
Sustained. I'm willing to strike that. Next
Okay,
question.
I apologize.
That's okay.
You can hand that back to Madam Court Reporter.
Certainly. Thank
and
you.
I'd like to go back to the Apple Health data, Mr. Binks, if you can put that back up. And this would be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do.
I do.
Page 2, record number 3, sir.
Yes, sir.
What does that show?
All right. Okay, so this is another entry from John O'Keefe's data, cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, if you could tell the jury what that shows, and if we can have that displayed as well, Mr. Vince.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36 steps being taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Henry.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and an accompany file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column had it was a time column that'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for Haas long, and I say Haas, HOS long to
Correct.
dry and cold, found in the browser state DB wall file, what was the date and time for that artifact?
Sure. So that's recorded in what's called Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, but that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah. So the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say.
And I'm sorry.
I'm sorry. Go ahead.
I interrupted you. Sorry.
Well, no. So we definitely get the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
Okay. What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
ArtX?
I'm sorry?
ArtX?
You saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference the three of those together? How did you use them?
Yeah, so all three of those tools, along with Axiom and Cellbrite, which I did, they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I wanted to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 2:27 a.m. search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called Knowledge C that records the user's activity, but the browser state is the very last entry on the items that we observed.
And did you find other examples of that you can speak to before this jury?
Yes, I believe we have one printed out there.
Okay. May I approach, Your Honor?
Yes.
Okay.
I placed the document before you, sir. If you could familiarize yourself with that and look up at me when you're done.
I have it.
What is it?
Okay, so this is another screenshot from the Axiom program. And it is showing a search that we conducted for reigning men. And then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only wanted to see artifacts that had dates associated with them. And then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Okay. Any objection?
No, Your Honor.
There you go.
And with the court's permission, may it be published, Your Honor?
You want this?
Yes.
Okay.
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 So we have a number of columns here. Could you explain to the jury what's going on with that exhibit?
Certainly. So I'm gonna switch glasses back here. Forgive me.
Do you need the light on, sir, or are you okay?
No, I'm fine, Your Honor.
Okay.
Thank you much. I can certainly do this. So we are looking at here web-related history, and also I have the filter turned on for application usage because there's some log files, sort files that the iPhone keeps track of to record user interactions, and that can give us a idea of the history as well. And then, as I mentioned, we have it filtered so that it's only showing dates, that dates existed, and we took the earliest possible date to a date way in the future. And then it's listed, and next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's relevant and really important here is that the Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us the internet history happened before that, and the purpose of this tab on at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last tab, am I correct that the time is 1:29:22, same day, at 2:27 and 38 seconds? Is that what it says on your?
I'm sorry. I'm definitely getting a pair of bifocals. I apologize here. I feel a little silly. Yes, on this particular one. So that is just moments before the Google search artifact.
The one that you previously talked about, the How Long to Die House.
Long to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about when the It's Raining Men was either searched or accessed, was that after, or before 2:27 and 38 seconds?
I'm sorry, can you?
Sustained.
Okay, well, if you say it one more time.
All right, let me try and put it a different way. Given the timestamp of 2:27 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well, so the indications would be that that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get
Okay.
what I want. What I want is the timing of the interaction with It's Raining Men by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of this that timestamp in the browser state.
All right. Now, with regard to this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for how long to die in cold?
Objection.
Sustained.
Do you have an opinion to a reasonable degree of scientific certainty as to when Long to Die in Cold was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
So he has a point to all these questions, right?
Yeah, the discrepancy between, so what he's basically saying is that there's 3 clocks and there's like 3 minutes and 1 second time difference because of the Waze app that they were talking about the other day. In this particular case, 3 minutes is either going to put her there or not put her there. So this guy's basically disputing what the other testimony has been in reference to Celebrate, which is widely used with law enforcement agencies.
I don't know if you caught the comment that I put down on YouTube where I said, gosh, what the heck did I say? Now I don't even remember.
You are
Defense has a point.
No, not that one. It's before that. Right. Bev seemed like she muttered "fuck" under her breath at that 3-minute discrepancy when the defense attorney didn't press
Yes,
it.
I do.
Yeah, I missed that.
Yeah.
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is I keep using the proverbial we. I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
All right. And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identification. Do you recognize what I've placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. Is a program, again, like the Axiom that processes data. And this is a This lists out a 623. This lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe, but through searching for that the number, I was able to see that it went to. You want me to say the name?
Sure.
Yeah, Uncle Brian A.
Okay. I would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
Okay.
I wonder what the previous objection was.
I don't know.
They've been doing an awful lot of approaching the bench this trial.
Yeah.
But yeah, when the prosecuting attorney had an objection and she sustained it, when he was questioning about the 3-minute difference, as the camera panned back over to the witness, it totally looked like she muttered under her breath, just a little bit.
Oh, she's probably said it a couple times. We just ain't heard it.
Yeah, because it totally looked like she wanted to see where that 3-minute gap went, where it was leading, because that's odd. Like, you can totally see the display time and the other time being off by, I don't know, half a second, whatever it was, because it looked like it was off by about half a second. But having the 3-minute difference on the monotonic time, that's insane. Like,
Yeah.
he didn't even get to explain what the monotonic time was, like, fully. Do you know what that is?
I don't.
Like he was saying, the monotonic time is time that is counted since January 1st, 2021, in seconds. And so you do calculations to figure out everything that happens after that. That's basically the exact time. And this is something that's pulled from like the internet and whatnot. So having your display time 3 minutes different from that, that's not really heard of.
Yeah. And even and I understand what you're saying, but baseband, I wonder what that is, because that's only within 2 seconds of the display, 2 seconds shorter than the display time.
I think baseband time is time that's just.
So folks, we're trying to streamline the exhibit numbers. It looks like this may already be in evidence. It's one of 4 different numbers, so I sort of wanted to keep it with that. We are so far removed from where it was that this will just come in as the next exhibit. So you will technically have it in evidence twice.
Okay.
Thank you. May I approach again, Your Honor?
Yes.
There's one final document before you. If you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and number of live items.
I would offer that, Your Honor.
If I get to see.
Sure.
So this is saying monotonic time is a measurement of the time
I
since
think it's
the
already in
system
evidence as well.
powered
So
on
actually, it's
and is
confirmed
maintained
it's not.
kernel.
It's not yet in evidence. We looked at the exhibit.
Oh, okay. So yeah, the baseband time is the one from 1 second. That'd be the time that you get from your cell towers.
Okay, with regard to that exhibit, Mr. Green, what did you find that was unusual, if anything?
Objection.
Sustained. Ask it differently, Mr. Yannetti.
Yes. What did you find of note?
Certainly. What was the time frame of the deleted records? Now, I'll just talk about this particular report here. It starts at 5:33:47 in the morning, and on the second page we see it ends at 8:50 and 15 seconds, again a.m. And then the normal calls, what we would call live data, then begins at 8:59 and 34 seconds and goes on throughout the day with no additional deletions.
And am I right that those are all, that's the call log, those are all phone calls?
Correct. Yeah, this is the call log.
And what was the difference between the calls that were at 8:59 and after on January 29th, 2022, and the calls that were before 8:50 a.m. on January 29th, 2022?
Yeah, well, it's the state they were found in, deleted versus live data.
I'm sorry?
Deleted data at the earlier time and live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please. I have to see counsel.
Huh.
Don't see the judge calling everybody up every so often.
He is still thinking she done it, even after all this.
That guy is convinced. Looks like the guy behind him has some doubts, though. Yeah, very interesting. I want to know why the hell the phone thinks it's 3 minutes and 1 second older than it should be.
Well, that's what I was actually just researching.
Like I said, I've never even really heard of something like that. The times usually agree. I mean, I guess you... Oh, damn it.
So, Mr. Green, I'm not sure if that question was clear or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so, what percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
I may have a moment?
Sure.
No further questions. Thank you, sir.
So it says the monotonic time is actually the universal time code.
So that would be the atomic time.
Good afternoon, sir.
Do you know who Miss Jessica Hyde is?
I do.
Are you aware that she wrote a report in relation to this case?
Yes.
Specifically in regard to the Google searches for Ms. McCabe's phone that you were just talking about?
Yes, sir. It was very specific about that search.
And have you had a chance to review that report?
I have.
You also know who Ian Whiffen is.
Certainly, yes.
And are you aware that he wrote several reports or submitted several items in relation to, again, the exact topic that you're testifying about in relation to the Google searches on Ms. McCabe's phone?
Yes, sir. I understand that.
And have you had a chance to review those materials as well?
Yes, sir.
You understand that they both disagree with what your opinion is in relation to those searches?
I absolutely understand that, sir.
Now, just as far as your qualifications and certifications go, I'm just having a difficult time. From the certifications that you have, at what point were you, or what, if any, certifications do you have with reference to Cellbrite as a tool, as far as your use and interpretation of data from Cellbrite?
Certainly. So my certifications are much more broad. They have to do with a lot of the fundamentals and how we conduct the investigations and what tools we should know and when we need to know we need to do more work and such like that. Cellbrite, I do not have any specific Cellbrite certifications. They offer many of them. However, I have participated in, God, I can't even count, hundreds of their training events that they offer, both Cellbrite, Axiom, Belkasoff. They all provide the community with fantastic support as far as that. And although certainly a class can be very good, but you really need to stay up to speed. You got to participate in the most recent understanding being put out there. Even in the changes of their tools will change from one version to another.
And so, to the point, as far as you have no certifications in regard to Cellbrite as a tool and how to use it, those kind of things?
That's correct, sir.
And in this specific instance, at any point, did you reach out to Cellbrite to go over sort of your findings or your opinions in relation to this search?
I did.
And who, if anyone, did you speak with from Cellbrite?
As close as I can remember, I know it was Leo, and I believe it was Santos.
And do you know what part of Cellbrite they work in or what they do?
Well, he was in the technical support and contacted him. He had informed me that they had elevated this up to some higher level technical support when they came back. His comments to me, if you want to hear them, was that this, okay.
That's for his comments, but at
Okay,
some point,
I
you
understand.
talked to technical support, is that correct?
Absolutely.
And they indicated that they would refer you to actually Mr. Whiffen's team?
No, sir, they did not.
So you weren't told that you were referred to Mr. Whiffen's team and you weren't contacted by anyone from Mr. Whiffen's team?
No, and I forget the exact date. A couple weeks ago, maybe a month ago, out of the blue, I got an email from Ms. Whiffen saying, and I can't, I don't want to misquote them, but certainly I got an email from
I'm not asking
him.
you about any specific conversations
Okay.
that you had. When I'm asking, and I'm asking about a time period more back in 2022.
I'm sorry, I couldn't quite hear you.
Back in 2022, did you reach out to Cellbrite in relation to this search and your opinions related to it?
Yes, sir.
And at that point, was that the point that you spoke to someone from technical support?
Yes, sir.
And at that point, did someone from technical support actually refer you or tell you that they were referring you to Mr. Whiffen's team?
No, sir, I had absolutely no idea about that.
So no one from no one from Mr. Whiffen's team reached out to you and then you just never called them back? That didn't happen?
Not that I'm aware.
Now, you were asked to look at a couple different phones, and I'm assuming by counsel for the defendant, correct?
Can you say that once again? I'm sorry.
You were asked to look at 3 different phones is what your testimony was. And I'm
Correct.
assuming that was by some counsel for the defendant, correct?
But,
No one else asked you to look at these phones,
oh,
correct?
correct. Yes, it was from the defense aspect too. Yes.
And so the phones that you were asked to look at were Mr. O'Keefe's phone, the defendant's phone, and Ms. McCabe's phone, correct?
Correct.
Now, as far as Kerry Roberts' phone, were you ever asked to look at that?
No.
And with respect to the defendant's phone, was there any GPS location information or data that you observed in her phone?
So we had an indication that location had been using there was something called Apple Map tiles, and those probably when you use the Apple Map app, that it in order for it to work, it will create these little tiles or little pieces of pictures, and they get stitched together to give you the view that you see on your phone. Now, for that had to be working, we know location data had to be working. This particular location data, the location data cache, is known to only be present on the phone for a couple weeks. Now, what I don't know, and Mr. Lally, if I'm going too far, just please stop me. What I don't know are what measures were taken to preserve that data, whether it was put in airplane mode, where the location services were turned off, whether it was put in a Faraday bag. And quite frankly, Mr. Lowry, I don't know if they did all that, if the location data would have remained or not. I've never tested that, but all indications, it would have had location data on the day that it was seized, because we received the Apple Map tile. But when I got the full extraction, there was no location data there. Now, I did observe.
So there was no
Okay.
GPS location data on the defendant's phone, correct? From what you observed.
And again, if I'm, there was, I did find deleted location data from April of 2022.
Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of January 29th, 2022?
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for it?
You know, I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know if I would have had to have a cause to.
Now, with reference to, you were asked some question about location accuracy within 3 feet. You did some sort of thing last night on CellHawk using that tool. Is that correct?
Certainly.
And you were asked to do that after Trooper Guarino testified yesterday. Is that correct?
I understand you testified yesterday.
And so with relation to you creating sort of that document, and that's now been marked as an exhibit, was that something that Mr. Yannetti asked you to do in relation to Trooper Guarino's testimony yesterday?
Well, in all fairness, you need to ask Mr. Yannetti. I could make an assumption here. I mean, if
I'm not.
I don't know quite. I'm not trying not to answer you, you know, but I was asked by Mr. Yannetti to perform that search.
So, Mr. Lally, please be cautious of that.
Yes, sir. So, Ms. Green, with respect to that 3 feet of accuracy, are you aware that what Trooper Guarino was testifying to in regard to that had absolutely nothing to do with phone applications or anything to do with data from phone or a CellHawk or a tool or anything like that?
Now, I don't know the full extent of what Mr. Guarino would have been testifying to.
And so you're not aware that his testimony was actually in regard to reviewing cruiser camera video from the Canton Police Department and photographs of where Mr. O'Keefe's body was, and then mapping that using GPS latitude and longitude based on that within a 3 feet accuracy.
The objection sustained.
Yeah, that's an absolute objection.
Are you aware of any of what Trooper Guarino testified to yesterday?
What you're mentioning, I may vaguely be remembering, and again, I'm not trying to not answer your question exactly. My conversation with Mr. Yannetti is 3 foot when it comes to GPS data. Can you tell 3 feet from GPS data? And no, it's not known to be that reliable, and particularly Apple location services. How that applies to the trooper's testimony, you know, I can't say with specificity.
What do you guys think? Credible? Not credible?
No, I think he's very credible.
Oh, yeah.
I'm happy to opine on location data, though.
There's no question.
Okay.
I mean, trying to say, do you have certification on this one application? Who the fuck does that? I mean, it's out there, but who does that?
Well, he's trying to get some armor in the chinks in the armor. I've been listening. I think this guy has described what's been going on that cell phone better than any of the state's witnesses.
Yes, absolutely.
I don't know if he's correct or not, but I think the jury is going to absorb more of what he said than what these other jackasses said and the way they displayed it.
I've been
I
able
agree.
to follow him and understand it better than I could the others.
Reference to
That's not
Safari
saying
and
a whole lot.
deleted tabs. Isn't it true that there is no way for a user to delete a tab, only to close it? Do you agree with that?
Yeah, well, when you close a tab, all right, you're taking it out of the active state, and it's going to an inactive state that some people could call deleted. Now, the Safari history allows you to go in and delete history by certain date ranges, but you can also go into specific websites that you visited and delete those. Now if you want me to continue, the WAL file itself, you can't open up a WAL file and say, oh, I want to delete that record. But functioning the phone through the user interfaces will have an effect of deleting data within that WAL file.
Isn't it also true that Cellebrite uses that red X to annotate that the record is no longer active and has been recovered? Which should then make it incumbent upon the examiner, being you in this instance, to determine if it was actually deleted, correct?
Yes, sir. Thank you for asking. It's yes.
That's all I'm asking.
Okay. All right.
There'll definitely be a redirect on
You
this.
stated in your affidavit, in your testimony, that
Yeah, I
you
agree.
used the Sanderson, SQLite, or SQLite Forensic Explorer to examine the Safari tabs DB associated with the WAL file log. Is that correct?
Yes, sir.
Now, in your analysis using that Sanderson Forensic Explorer, was there an indication that House Long to Die in Cold was found in the WAL file?
Yes, sir.
Now, with regard to that, did you independently verify the cause of that timestamp that you observed there?
Yes, sir.
Now, is it your interpretation that the timestamp means the search appeared at that time solely based on the naming of the field in the database?
No, sir.
Now, can a WAL file contain items that are so new that they're not yet committed to the database?
Yes, sir. That's the purpose of it.
So the WAL file holds the newest information until it's merged to the database, including additions, deletions, changes, all of those items, correct?
That is correct.
Now, according to your affidavit, the device was in active use between 2:23 a.m. and 2:31 a.m. And just to be clear, I'm talking about Ms. McCabe's device, correct?
Correct.
And what other searches did you see at that time, and where were they?
I'm sorry. Can you repeat that? I couldn't quite hear you.
Searches did you observe in that time frame, and where were they performed?
Well, there were a number of websites, including the Raining Men exhibit that we did. There was Ozone Basketball, I believe. There, Hockermont, Smith, and I can tell you that those similarly, the last entry with those there is the browser state DB file. It's not at the beginning, it's not at the end, and I have a couple thoughts on why that may be in regards to Ms. Hyde and Ms. Whiffen. I'm happy to share those with you.
I'm not asking you anything about that, sir. What
Very
I'm
good.
asking is,
But the
is it
defense
possible
will.
for a change request
Oh, yeah.
in the WAL to a SQLite database.
I think Lally's getting.
pertaining to one particular field, leaving the other fields as what they were.
I think he knows this is downhill.
I want to answer your question as well as I can. So can you repeat that one more time?
Is it possible? Is it possible for a change request in the WAL to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
That's a stretch.
I'm having a little trouble answering this. So, if I'm understanding correctly,
Yes.
When the WAL file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you. I'm just
That's
a
okay.
little lost on how you're asking it.
And the question?
Sorry?
Do you not understand the question?
Why don't you move on, Mr. Mullin?
Is it possible that the URL field, which has the website name, was
This question
updated,
didn't make sense.
to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
Is it possible that the
Question
search
did
for,
actually make
How
sense.
Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab?
Oh, well, not in that tab, but I certainly agree with you that there was a second search done at around that time.
Now, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24:51 a.m. for that same search?
Yeah, that's inconsistent with the actual data I'm seeing on this actual phone with this precise iOS version.
Now, as far as the search in Safari with the string, as far as the smotot.apple.com included, is it, you recall that search as far as being a suggestion from Apple, from the iOS, as far as the search with how long to digest food?
Okay, I didn't hear your whole question, but I heard the last part about how long to digest food. So I can opine on that. So my feeling on that is when the how long to die in code was put in, that was most likely a Apple suggestion. And I've done some testing now. The time period I'm doing my testing, is after the fact that this would have actually occurred. But as I tested that on a live phone and using a Google search, I could see that how long to digest food would come up. I also notice the specific phrase, how long does it take to die from hypothermia? So as you do this Google search, you try to repeat what's being done. Those are two suggestions that actually came up.
And so that was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, and I know that's different from my affidavit from about a year and a half ago, in all fairness, but
that's entirely different.
One person, Mr. Lally,
I'm sorry.
one person at a time.
Yes.
Okay. So yeah, in fairness, I want to give you my best knowledge as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, it's since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
Doesn't cause me any distress.
Okay.
What I'm asking, sir, is that that's what you filed because that's what you thought at the time, correct?
Yes, sir.
And subsequently, you've done further testing, and that's shown that you were wrong, correct?
That is correct.
Now, according to your affidavit, there was a search for how long to digest food at 6:23:49 a.m. that precedes the search for how long to die, and the misspelling here would be the key CLKD at 6:23:51 a.m. Is that correct?
Yes, sir.
Now, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct?
Yeah, I don't know. I don't know the answer to that. I believe that it was, if it had picked up a earlier search from 227 of how long to die in the cold, and then you went to retype it in, it may have then tried to give you something similar at the 6:23 and 6:24 timelines. So hopefully that answers your question.
So steps, going to Mr. O'Keefe's health data, steps doesn't necessarily mean that someone is physically taking steps, correct?
Again, the research that's done for this is steps tend to be a very accurate artifact.
So steps could not also be coincided with, say, movement in a car or other sort of movement of the phone as far as the health data is concerned?
Sure. Well, I did geez, quite some time ago, do some testing with an actual iPhone 11, the same make and model, and took a drive and tried to see if it would register steps. It did not. I sat in a chair and tried to duplicate how I thought I would walk to see if it recorded steps. It did not. I took the phone from the floor to the ceiling to see if it would record a flight of stairs. It did not. The only, with that iPhone 11, same make and model that I got, it was very consistent with me actually doing walking steps, and that was whether I had it in my shirt pocket, my pants pocket, or clipped onto my belt.
That's your testimony?
That is my testimony. Yes, sir.
Now, are you familiar with GPS native locations?
Yes, sir.
And GPS native locations takes its data as far as defining latitude and longitude from a number of different sources, correct?
Well, true GPS, okay, is going to take it from the GPS network. What you may be thinking of is assisted GPS, which the iPhone uses, and that assisted GPS will try to, it kind of does a crowdsourcing. So it'll look at cell towers, what's in range as far as like Wi-Fi's and a number of other devices to try to get you an enhanced GPS location and give you the best data possible.
So it takes GPS native locations within an Apple iOS device, takes from 4 different sources. Isn't that correct?
It tries to get from a variety of sources, like I just mentioned. Not all would be available.
Now, with regard, did you look at any GPS native location data with regard to Mr. O'Keefe's phone?
Yes, sir.
And would you agree then that the GPS native locations didn't record any movement of that phone after 12:25 a.m.?
12:25. You know, I would have to look at the exhibit to see what the time of that last entry was. I don't want to misstate something to you, sir.
Now, you were asked about sort of the elevation change in 3 floors, ascending, descending, and saying that you couldn't pinpoint a time period or within that 1221 to 1224 time period from the health data. Is that correct?
Correct. It happened somewhere within that time.
Could you pinpoint more specifically if you looked at the GPS native location data?
No, well, we're talking Apple Health and GPS location. So
But you said you couldn't do it.
I'm sorry. Which one are you asking about? Please.
What I'm asking is, you said you couldn't pinpoint it within the GPS health data. What I'm asking is, if you had looked at the GPS native location data, could you give a more specific pinpoint as to where Mr. O'Keefe's phone was?
I'm going to allow that.
Maybe we can see briefly.
Okay.
So yeah, that question that kind of confused everybody. It did actually make some sense. He was just asking in a very convoluted way. Anyone who's not tech savvy would have no clue what the hell he was saying at all. And even the tech savvy guy was like, I'm not entirely sure what you're asking. Yeah, no, it did make sense. It was just odd way of asking it.
I think that Lolly questions were intentionally vague and difficult to answer to try to trip this guy up. The problem with this guy for the state is that
You are unmuted.
This guy didn't take a class. This guy knows it. He's been doing it since the mid 90s before cell phones were a thing. He could walk in his head through the iOS system on any particular phone.
Now, to be clear, sir, you indicated earlier in your
And I think
testimony
the jury's going to respond well to this
elevation
testimony.
change, from 1221 to 1224, you could not pinpoint where in that time period, or specifically where in that time period the elevation change occurred, correct?
That's correct. It's a time range. Yes, sir.
So what I'm asking is, had you looked at that in the GPS native location data, would you have been able to more accurately or specifically pinpoint when that occurred?
Okay. So the location, are you looking for a yes or no? I'm sorry.
Yes or no?
I can try. There was, yes, there was location data within that time period. Okay.
And are you aware that Mr. O'Keefe's phone from the GPS native location data was actually a half-mile away from 34 Fairview Road at the time that it made those recordings in the GPS Apple Health data?
Right. Yes, I understand he was using Waze, and it had made that recording. I understand that. That's why the finding that 3 minute and 1 second offset brings into serious doubt if that time was accurate. And when you apply that to the location offset, then the Apple Health data and the GPS all aligns. Now, I have not decoded Waze and found out what functions they were calling and all that. And I don't mean to indicate that I have, but I mean that the latest version of Axiom is bringing that up as an artifact and a timestamp related to Waze. And in the case of here, where minutes are important, I thought it proper that I bring this to the attention of the case as a possible explanation.
As a possible explanation?
As a possible explanation, sir, yes.
The three different clocks that you were talking about, are you aware that those are actually associated to power usage and not applications?
Right, that power usage was directly related to the Waze application.
So it's your testimony that those three clocks apply to the times in Waze? Is that your testimony?
I'm saying that the timestamps were directly related to Waze. It was reported by Axiom when you applied the filter and say, show me all the artifacts related to Waze. These were artifacts that came up related to the Waze bundle. So I guess you need to give it the weight it deserves. Like I said, I've not decoded Waze. That's not something that has been done, but I think we need to consider the 3 minute offset as it applies to giving significance to the Apple Health data and the Waze GPS.
Now, turning to Ms. McCabe's phone again, as far as the search, what you indicated as last view time, are you aware that that is actually related to a time that it was actually focused on the screen as opposed to your interpretation of it?
I'm aware that that it appears to be the last time and date it was focused, and when it was no longer was focused, that's when the timestamp was written. That's what's consistent with the other data on this particular phone on this very specific iOS.
Now, with regard to looking at this search, you mentioned that you used something called an ArtX tool. Is that correct?
Yes, sir.
And are you aware that's a tool that was actually created by Mr. Ian Whiffen?
Absolutely.
And with regard to this specific issue, as far as how this data is being interpreted from the browser, state DB versus the knowledge C database and the wall file and all of those, the P list and all of those other kinds of things, as far as the misinterpretation of the data has then caused Mr. Whiffen in further versions of Cellbrite to revise that so that this kind of error can occur.
Sure, happy to answer that. So Mr. Whiffen's testing was not done with this specific version of the iOS. The iOS has been known to be changing the way this artifact works. To do proper analysis, the researcher that he is, he would need to work with that same iOS. Now, in regards to the Cellbrite question, they have two versions of the Cellbrite Physical Analyzer. One is the standard physical analyzer that's been out for several years now, probably is majority use in the community. It's a tool that takes that raw data and it puts it into human terms that we can look at and understand and write reports like you've been seeing here. So they have the Cellbrite Physical Analyzer that's out there. I believe it's 7.68, but don't quote me on that. And then they have a new version that's come out called Insights, and this operates more on a where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer reporting on that time. Their current physical analyzer program, and I tested this a few days ago, still reports on that search occurring, and that timestamp. So currently Cellbrite is providing examiners, law enforcement, and people worldwide with two different versions giving two different results. That I can't speak to more than that, other than I've tested that, and I see how those programs are working now.
So my question, sir, yes or no, is are you aware that Celebrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with the asterisk, they updated one of two programs.
Nothing further.
Yeah, I bet you don't want to keep asking that question because this guy.
Mr. Green, you are all set.
Thank you, Judge.
What?
Destroy.
I think he destroyed the state's case. Hey, is it just me, or does that guy remind me of the way Grizz talks? His voice,
kind of.
right?
All right, jurors, that's it for today.
All right.
So juries, we are going to send you home for the weekend. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. We are on track. You will get this case next week for your deliberation. See you on Monday.
Court, all rise for the jury.
See if they got any court business, and then we'll jump into do an assessment for today. Interesting day.
Very interesting.
All right, why don't I see counsel regarding scheduling?
Okay. Big
So-
Ron. Big Ron's been at the range. I don't think Big Ron's caught up to speed. Do we need to get you up to speed, Big Ron?
Yeah, let's get me up to speed.
I tell you what, I saw those pictures. That is a fine young lady who knows how to handle a firearm. I'm actually pretty impressed.
I'll tell you what, man, she was doing mag dumps and just giggling.
Good times, my friend. Good times. You don't get those days back, so cherish them. Well, we've had we have Lucky. The snowplow was the first witness for the defense. He's was pretty good on the story. Testified well. It seems to be very credible and very honest man. It seems like he testified that he went in front of the Fairview address a couple of times, and that there was nobody there. And then he believes that he would have seen it because of his truck. He's got alley lights. These are lights that are mounted that sweep off 90 degrees from the vehicle. He said that he knows where the Albert House is a friend of the Alberts and knows them. And that he pays attention to the house when he drives by, that his light sweeps from their front door across the entire front yard as he goes. And he's familiar where his flagpole is. He's plowed this street many a times. And he said he's certain, because he's looking for objects on the side of the road when he plows, he's certain that he, if their body had been there, he would have noticed it and that it wasn't there. The state tried to beat him up a little bit. I think the state made themselves look like an ass because he was a very sympathetic witness, very believable. They tried to stump him, or Lally tried to stump him once with that night. He reported an incident where he hit a basketball goal. You know, the ones I'm assuming that you'll set out by the roadway that are ballast. That his blade caught that and knocked it over, so he reported that as potential damage. And Lally tried to come at him and said, "Well, I mean, it's not like you can be. It's difficult to see out of the truck." And he's saying, "No, it's not. In fact, this truck is outfitted where it's actually he's got a very good field of view." But he says that this is it. I don't want to miss anything. Lally says, "So you didn't see that?" He said, "No, absolutely, I saw it. I just misgauged how close it was, but I saw it. I knew it was there, and I knew when I hit it, and then I reported it." So I'm going to give a score to the defense on that. I think that at least it does is draw a question in the jury's mind as to how credible some of the state's witnesses were, because he came across very credible in my mind. Then we went to Granny Canine, the expert witness that we did voir dire on last week, who's testifying that the injuries to O'Keefe's right arm are caused by a dog bite. I think she was the weakest witness for the defense. She does throw in some, some credibility. that this could possibly be a dog bite, but I don't think she came across real well to the. And this is my opinion. Some my two other co-hosts may differ, but I don't believe that she came across very strong in front of the jury. It's more of the droning out all these experts talking that they've been listening to since the end of April. The last guy up is Mr. Green. He's the Celebrite or cell phone data expert that the defense brought in. That's saying that house long to die in the cold was absolutely searched at 2:37. He brought into question the 3 internal clocks that are on the phone. One is 3 minutes off. I think he was extremely good at actually articulating. You've seen some of the other cell phone data experts they brought in, at least 2 others that they brought in, that they kind of muddy the water. He's like, man, I'm not sure. I must just have to believe what the guy says because I can't understand. It's very difficult to follow them and what they're talking about inside the phone with wall columns and databases and this function and that function and iOS and all that bullshit. But I will tell you, this guy laid it out there, I think, very well. I think he explained it in layman's terms where an average person can understand that and go, okay, that makes sense to me. So if I had to guess, I would say today goes to the defense, if nothing else. Wrong one. When you come to the point of muddying the waters on the defense's case, I think at the very minimum, this guy left some doubt in the state's witnesses, especially there at the end when he brought up, Whiffen I think tried to punk this guy a little bit. Basically, it's like he's not smart enough, but I've done it. I've invented this tool and I've made the adjustments for all of Celebrite. He's like, well, yeah, he did, but not for all the tools and not for all the iOS systems. And he explains how the iOS systems on different phones operate differently. I think he comes from the credibility when it comes to the pedometer in the iPhone 11. That's exactly the iPhone 11 that was carried by O'Keefe, and that's exactly the one he went and did his test on. And it's a real test. It's not like I run a tool or I did a data or I looked at research and I went to class. He's like, no, I did it. I tried it out because I'm a nerd and that's what I do. I think the defense actually is doing a pretty decent job at least muddying the water. And I'll tell you from some experience that you'll have this issue. Expert after expert gets up, and you got the battle of the experts there. A lot of times, the jurors will go, "Hey, I didn't understand any of that shit. I'm going to hook on something else." To me, all that's a wash. I don't know who's telling the truth. I don't know which one's right. Sure, they're all right, maybe, but that they won't weigh very heavily in their decision. Dante says he was busting code before Celebrite was a twist in its daddy's sack. Very well put there, Dante. Very artful with your expression. But yes, this guy was. If you didn't catch that, Ron, he's been certified as a court expert in digital data testimony since 1996. So you think about who was running around with a cell phone back in 1996, but he's been testifying in courts as an expert since 1996. He's an independent contractor, works for himself, he's got his own small company. And I think that he eats, breathes, and sleeps data and operating system functions on cell phones. But he's explaining that the house long to die in the cold absolutely was searched at 2:37, and again at 6, just like Turtle Boy, and we've heard outside the in other places. Hang on a second. So I think that the state wins this case, wins the day on that as far as spreading some doubt, reasonable doubt into the jury's mind. I'm sorry, yeah, what I said, the state defense, absolutely. Don't let me get sideways there. But James, you're a little more up to speed than I am on this digital data stuff. What did you think? Dante says that the dude's spitting out code and sounding straight. What's your opinion?
No, he's definitely sounding straight to me. My brother is a coder, and he has a huge group of hacker friends, and they talk this kind of shit all the time. So I'm somewhat well versed, and I try to stay up myself since I'm about the same age. And everything he was saying made absolute perfect sense to me. I mean, I was even following the other experts, but they were definitely not concise with their conclusions with the data that they had. This guy, all up. No, this is what happened. This is what happened. This is what the data shows.
No, I agree. I think that I think he brought it in a language and an understanding that a layman could understand. And I did understand what they're talking about with the wall files. That does make sense if you look at all iOS operating systems being the same. But he was very good at breaking it down that it depends on the model of phone you've got, and it depends on the update that the phone's running as to what version of iOS that it's operating on. But different iPhone models will process and use the operating system in different ways. One of the biggest things is this 3-minute time difference on the is it metatonic clock? Am I right, James?
Monotonic, yeah.
Monotonic, excuse me. This monotonic clock, he says, like 3+ minutes off, which changes the Waze application. Is when they say that he was a mile and a half away when these steps were being made, and he's saying, well, that you take out the error factor on the 3 minutes. That's not true. That everything he says everything matches up when he makes the correction of the 3 minutes.
And that's what I'm saying too. I believe John and I just discussed that, and the monotonic time is basically the atomic time. That's what's coming in off the internet. So Waze, that's what the time they're reporting exactly. So the display time, that's what the phone is saying, more or less, or at least what the reporting of the phone is saying. So that's the 3 minutes off. You account for that, and yeah, everything lines up.
I think it's a problem for the state as well. Dante says he single-handedly forced Celebrate to rewrite its code as Whiffen still didn't use it right. iOS Commonwealth is going to go in smoke and mirrors on the digital stuff. You know what, Dante? I 100% agree with you. I think that's what the Commonwealths or the states plan is at this point with this stuff is to cloud it up enough smoke and mirrors that it keeps the jury confused and it doesn't really come into play. In other words, you don't know if she made the search at 2:37, but you don't know that she didn't. So it kind of just falls aside, and it's not a decision factor for the jury when they go to deliberate. But I think this guy cleaned it up a little bit. I think this guy and the snowplow driver were outstanding in their testimony, and I think they're going to play well to the jury.
So do you think any of this testimony is gonna help her, or do you think it's gonna hurt her? Because from what you're telling me, it sounds like it's gonna help her.
You're talking about Karen Reed, right?
Yes.
Yeah, I think it absolutely helps Karen Reed's case today. I don't think the jury's going to go back and ignore the testimony of the driver, and I don't think that the jury's going to go back and ignore the testimony of the Celebrite guy. Where I think they may go back and say the Whiffen and that other chick, they were talking way over our heads. I didn't understand what they were saying, but I understand what this guy's saying. Does that make sense, Big Ron? And Dante, I don't disagree with you. The mic drop when he said they're making two versions and providing the old one to L&E law enforcement. I think that was great right there, and it's telling. Celebrite's a business, and they look at these big contracts with these law enforcement agencies. But there's another client out there for Celebrite, and that's these independent analysts like himself, which they're out there. But these guys are nerds, man. They know they'll stick with it. Whereas you give it to a law enforcement agency, I've been to the class, I'm certified, and that's the way it is. You kind of get like you did with your accident reconstruction guy. I do it when it's needed, but this guy does it every day, and he sleeps it and eats it. And he knows it with a passion. So I agree with two things. I agree with you on Dante today. We're doing real well.
And like I was saying before in chats, it is absolutely possible to edit the wall file or to delete the information like GPS data or whatever from the hard code data of the phone. But you'd have to have either a jailbroken phone or some third-party application that generally Apple doesn't allow. And there would be signs that such an application had been used. And this guy laid it out very clearly. No, that's not what happened at all.
Yeah, no, he didn't. But you know what? I think what plays to the defense's side is that Lowley, I think, is taking the wrong tact with these people. He's kind of looking like a bully. And again,
this last witness on the stand, he's a good guy. You go drink a beer with him, hang out with him. He's a nice guy. If you were on the way out the store and had too many grocery bags in your hand, he's the type of guy that would stop and help you. You know, he's a friendly guy, and he kind of badgered him. Just same thing he did with, in my opinion, with Lucky. He kind of badgered Lucky as well. And I will tell you that that doesn't play well with juries more often than not. It usually hurts one side or the other if they look like they're bullying a witness that is sympathetic to the jury. You know, that guy could be one of those jurors' uncles or grandfathers or even a father. They could see somebody that they care for in him, and that'll turn that juror sideways on you because they're like attacking their people.
Yeah, it almost seems like the prosecution is trying to get the case tossed.
No, I think the
or at least
prosecution-
hung so that they can go at it again. Sorry.
Well, I don't think so. I think the prosecution's tack from this far out is to swat at flies as they come, and they believe they've left enough evidence on the table in the 3 months that the state's been putting on the case that they've got enough to get a conviction, I think. And I'll go back again. You still have to get past the lens pieces in the yard around the body. I mean, they couldn't have got if she didn't hit him. That means you had law enforcement out there planting pieces like Easter eggs in this yard. I'm not saying it didn't happen, but that's the level you're going to have to come to decide that she didn't do it. In my mind, but there's another avenue that the defense wins on this is that it's so convoluted. I'm not sure who's telling the truth or who's being straight up or which fact is true. And because of that, I can't convict, and then she gets acquitted, and that's the worst case scenario for the state on this. But I don't think the state's trying to blow it. I think he's playing true defense on these witnesses, and I think we'll see that going forward. But he was even bullying, Dr. K9. I just don't think she was as sympathetic as the other two were.
Yeah, it sounds like she had a good day. Then hopefully it maintains that. Then.
You know, I don't know where they go next with witnesses. They didn't go back and do redress on the Celebrite guy, so evidently the defense felt pretty good with that, and I kind of agree. I don't think you need to go back and ask him. He didn't have much to clean up, so I guess I would leave it at that. You've got the ARCA guys, the experts on the biomechanical engineers that are going to come in, I think probably next week. I don't know what witnesses the defense has beyond that. So we may be getting very close to deliberating on this and seeing what the outcome is going to be and if we're all right or wrong.
I believe Bev said at the end there, as she was giving out jury instructions and whatnot, she said, "We are on track for deliberations next week."
Right, which could be like Wednesday of next week. It actually could go Tuesday of next week. We could have a decision by the end of the week.
Oh, this is going to be good.
Yeah, what are you going to do if it comes back guilty? You be angry?
Dude, I love justice. I don't care which way it goes.
Yeah, I'm kind of. I like the gamemanship in the court. It's interesting to me, but yeah, Big Ron. I think it was a win for the defense today. I think that they've come out strong on their defense case. I think the state is looking, or the Commonwealth, as I guess what that is. The Commonwealth is looking real defensive and almost bullyish with some of these witnesses. When I think that may be an incorrect tact to run at it. And Lolly doesn't know anything about fucking cell phones. This guy has been reading up, and he knows good questions to ask. But this expert that was just there was the questions he was asking. Almost the expert can't really give you a real answer to that because it's such a pedestrian question on a very precise subject. And as Vet says, it's a big game of chess. You're 100% right, Vet. It is a big game of chess and tactics. And I think the defense is doing well. But James? Is James still with us? We lose him.
I think we lost James.
We lost James.
Yeah, that's a really.
Go ahead, John.
I was gonna say that's a really good recap. It looks like I missed a lot, but it was worth it.
Well, I was going to give James has been with us, I think, most of the morning. I was going to give James a chance to recap, and then we're going to sign off and get ready for our night court police use force video review tonight, folks. That's a 9 to 11 Eastern time, and we're going to do a live stream on X, and it'll be on YouTube as well. But we have a panel of law enforcement officers, some legal minds, some attorneys, and some are just legal minds. And we have civilians that we take body worn camera or dash cam videos of police using force, and we kind of play as the grand jury. Do we indict them, or do we give them a no bill as a justifiable use of force? So join us for that show tonight. If you hadn't caught one, come in. We take questions from the audience through the chat. We're really fast with those. We'll get them up and put them on the screen like you've seen us do during the trial. It's actually a good time and enjoyable show. It's one of the better ones we do each week, although all of our shows are good. But this one is exciting because we've got a good group of panelists to give us good opinions. Of course, we'll have the after party afterwards. But James, we're going to close it out here. I want to give me a quick assessment of what you saw today and where you think things are at.
Well, I definitely think the defense laid out a solid case that what the state is saying happened didn't quite happen the way they said it did, leaving up plenty of holes of doubt. I had them before, but man, they are way open now. I think this is definitely a good case for the defense.
So you're talking it up a good day for the defense, and you're going to add a point to the scorecard.
Yes, sir, that is accurate.
Big Ron, I know you didn't catch all the testimony today, but you've been keeping up with the trial. This is the first half day of the defense's case. We've been looking forward to it, to see some fireworks. Didn't really see fireworks today, but we've seen some real solid shots. Has your mind changed, or were you, if you had to go back and do deliberations right now, where would you be?
No, my mind still hasn't changed. I still don't think that she was responsible for it. And I think the snowplow guy, because that's about the time that I popped off, actually I popped off as soon as the dog lady came in. But that was, in my mind, that was pretty damning evidence. He's got that thing lit up like a Christmas tree, landing lights all over it. He didn't see anything out there. I don't know. We've got him saying he didn't see bodies out there. We've got cameras that have been erased, cameras that had views that they said they didn't need the imaging off of it because it wouldn't have added anything. There's just so much little stuff that at minimum it should be a mistrial just for the fact that it was sloppy on everything and dismissed under prejudice. So no, I haven't been swayed. I don't think she did it.
I'm leaning back again to I think hung jury. I think is where this is going to be, but I wouldn't be surprised with an acquittal for all the things that both of you guys have just said. You go back to him laying in that yard from 12:30 to 6:20 in the morning. The traffic that was there was a car parked near where the body was. The plow driver is telling us today with certainty, and he knows vehicles. They try to trick him up. Well, you sure it was a Ford Edge? He's like, no, absolutely. Another tail lights. I won't get him confused. This guy knows. You ask him what he drove back in 2015, and he was almost able to give you the VIN off the vehicle. So he's one of those guys that absolutely knows what a vehicle is, and he's saying with certainty that there was a Ford Edge parked right there. But once again, we have nobody that saw the body lying in the front yard from 12:30 as the defense asserts. I mean, as the Commonwealth asserts, until 6:20 in the morning. And we know we've got traffic up and down the road because we got road plows going in, and I'm sure there was other traffic as well. So I think if I had to force to guilty or not guilty, and I think I'd have to go with not guilty on it as well. But folks, that's our show today. I hope you enjoyed it. It was some damn sure interesting turn of events as far as, well, not turn of events, but damn sure interesting on how the defense is coming at the defending Karen Reed on this case, and I think they're doing a pretty good job. Of course, you would expect so with the price tag that's costing Karen Reed, but if I had the money, I'd spend it too. My freedom means a lot to me. Before we sign out, though, I'm going to do another promo for our Range Minded podcast. Today is Range Minded Podcast Day. He's on every platform that the Range Minded or that you can get a podcast for. I highly suggest going to his YouTube channel, going to Spotify, give him, not just listen to a podcast, but give him a follow, give him a support, follow him on X as well. This gentleman is putting some maximum effort into bringing some content to you guys, and it's good. I'm going to give you a real quick peek of it right here.
We live in a world full of experts. Where politicians use fear to generate power for themselves.
We've already had over 290 mass shootings this year. That's more mass shootings than days in the year.
Where our media feeds us with misinformation.
And according to the CDC, the #1 cause of death for children ages 1 to 19 in this country is gun-related violence.
Tropes.
Where it will literally tear out the inside of the body.
Where those who make the rules seem to know the very least. Scary terms used.
Arm known as a ghost gun because it skirts most federal gun laws.
Don't be like this guy. Listen to the Range Minded podcast and free your mind.
There you go, folks. My last little bit here on promoting is the Sport the Night Court and your host with tips and donations. We use this kindness for equipment and cost to bring content to you guys. We prefer Cash App, and there's the Joe Lanou Cash App tag. It's a $sign Joseph LNU. Anything you can spare, anything that you feel in your heart to throw our way, we absolutely appreciate it. That money goes to equipment and other things that are actually cost for us to bring you content. And we've also got our new smoke show, Big Ron. I think Big Ron missed that, but James was on it as well. But we've got a new smoke show where we're going over the basics of smoking all kinds of different meats. You can catch us on Wednesday. It's a live stream where we're going to be with Vet LT3 as he jumps down on doing some chicken for the first time. We're going to smoke some chicken on Wednesday and go over the details of that, how to pick out the chicken, the best ways and tips and practices to do that. And I believe, folks, we've got a couple of other extras that are ready to join the crew on giving their tips on the smoke show. It's another little thing that we're bringing to you that we're excited about, the smoke show. If you're not giving us a follow, give us a follow, and let's that way we can keep you up to date on the new things we got coming. We've got some great things coming up here in the future that we're working on. But once again, if you can spare anything, we appreciate it. Just like if you get good service at the restaurant, you leave a tip. We give you good service, and we're bringing you good content that you enjoy. We appreciate a tip as well. All right. Thanks, folks. That's it for the day. We'll catch you tonight at 9 to 11. Don't miss us. The Use of Force video review. It is the most popular show of the week. We'll catch you then.